Okay. Again, apologize for the delay. I'm Bruce Thompson. I am Chair of the Water Quality Control Commission. We're starting our meeting today on May 13th. I'd like to welcome everybody. It looks like it's going to be a rather full day. So the first item on our agenda is a roll call. Ms. Jones, would you call the roll?
Yes, I will. Good morning. Commissioner Brankard, are you present?
Present.
Commissioner Candelaria has let us know he's not going to be here, so I will record him as absent. Commissioner Dominguez?
Present.
Commissioner Fry?
Present.
Commissioner McWilliams?
Present.
Commissioner Paladugu? Commissioner Patton?
Present.
Commissioner Rosatos?
Present.
Commissioner Velasquez?
Present.
Commissioner Vigil?
Present.
Commissioner Zemlik?
Present.
Vice Chair Armstrong? Chair Thompson?
Present.
Chair, you have a quorum.
Thank you. So the second item on the agenda is approval of the agenda for today's meeting. I would entertain a motion to approve.
Motion to approve the agenda. Second.
Been moved and approved, moved and seconded. Any discussion? Hearing none. This requires a roll call vote. So let's do the roll call.
Okay, thanks. I want to confirm, was Vice Chair Armstrong, did you made the motion, and Commissioner Brankard, you were second. Thank you. So Commissioner Brankard, how do you vote?
Yes.
Thank you. Commissioner Dominguez?
Yes.
Commissioner Fry?
Yes.
Commissioner McWilliams?
Yes.
Commissioner Paladugu?
Yes.
Commissioner Patton?
Yes.
Commissioner Rosatos?
Yes.
Commissioner Velasquez?
Yes.
Commissioner Vigil?
Yes.
Commissioner Zemlik?
Yes.
Vice Chair Armstrong?
Yes.
And Chair Thompson.
Yes.
Motion passes.
Thank you. Third item on our agenda is approval of the minutes of the March 12th meeting.
Mr. Chair, I would make a motion to approve the minutes as presented.
I second.
Been moved and seconded. Discussion? Changes? Okay, let's have a vote on that. Again, I think this is a roll call vote.
Okay, thank you. And can I confirm who made the second? Thank you. Commissioner Brankard, how do you vote?
Yes.
Commissioner Dominguez?
Yes.
Commissioner Fry?
Yes.
Commissioner McWilliams?
Yes.
Commissioner Paladugu?
Yes.
Commissioner Patton?
Mr. Chair, I'm going to abstain as I was not present.
Commissioner Rosatos?
Yes.
Thank you. Commissioner Velasquez?
Mr. Chair, I too will abstain. I was not present.
Commissioner Vigil?
Yes.
Commissioner Zemlik?
Yes.
Vice Chair Armstrong?
Yes.
And Chair Thompson?
Yes,
Chair, the motion passes.
thank you. Agenda item 4 is public comments, and these are general comments not pertaining to the meeting agenda. So if you want to make comments about the proposed reuse rule, that is not appropriate. So I would ask if there's anyone that wishes to make public comment. Hearing none, let's move along. Agenda item number 5 is WQCC 23-65. It's Carly LLC's application for a stay of proceedings pending the appeal of Adams Cleaners, and it's versus NMED. We've got a public hearing scheduled. However, there have been some motions that were introduced to either stay or, yeah, to stay the proceedings. So I think before we have the public hearing, we'd like to hear the discussion of the motions. And I believe it was the NMED that filed that motion.
Chair Thompson. Oh, yeah, it wasn't me. And that's
So
filed,
it was filed by Ms. Weatherly.
I think they're on the platform.
Is Mr. Nasco also on the video call? Ms. Weatherly, are you present? Mr. Nasco, are you present? So we don't have the parties. Perhaps it'd be appropriate to table this item. Does that require a motion? Okay. A motion to table.
Mr. Chair, I would make a motion to table in regard to WQCC 23-65 CO.
I would move to second.
Okay. Been moved and seconded to table WQC 23-65. This will again require a roll call vote.
Very good. Commissioner Brankard, how do you vote?
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Paladugu,
Yes.
Commissioner Patton,
Yes.
Commissioner Rosatos.
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vihil,
Yes.
Commissioner Zemlik,
Yes.
Vice Chair Armstrong,
Yes.
Chair Thompson.
Yes.
The motion passes.
Okay, thank you. Agenda item 6 is a public hearing on WQCC 23-84, which is the new proposed rule 20-.6.8 NMAC water reuse regulations. There has been some concern about potential conflicts of interest on the parts of the commissioners or whether or not some of the members have filed the appropriate paperwork to serve on this particular aspect. So at this point, council has recommended that we go around the table and all the commissioners state whether or not they have any real or perceived conflicts of interest regarding this. So I'd like to start this off as chair. I have numerous acquaintances, people I've worked with on both sides of the issues. However, I have no professional conflict of interest, nor do I have any financial conflict of interest in this particular issue. So let's start down. We'll just go around the table. We'll start with the Commissioner Zemlik.
No, I do not have any professional or financial conflicts of interest. I have no professional or financial conflicts of interest. Bonnie Fry.
Larry Dominguez, no professional, financial, or perceived conflicts of interest.
Krista McWilliams, I have no conflicts of interest, professional or otherwise. Srikanth Paladigu. I have no professional or financial conflict of interest.
Jonas Armstrong. I have no professional or financial conflict of interest.
Kirk Patton, I have no professional or financial conflicts of interest.
William Brackett, I do not believe that I have any conflicts of interest relevant to this proceeding.
Toby Velasquez, I have no financial or professional conflict of interest. However, I do have a personal conflict of interest, and I will recuse myself because of it.
Edward Vigil. I have no professional or financial conflicts of interest in this matter.
Chair Thomas, did you want me to also?
Oh, I'm sorry. Commissioner Zatos.
No, this is Gerasimus Rosados. I have no professional or financial conflicts of interest either.
Thank you. Yeah, we were just talking, Commissioner Armstrong and I, New Mexico is a small state, which is one of the nice things about it. Many of us know each other. But I think it's worth getting on the record that we are don't have any conflicts that might influence our participation in these deliberations. So at this time, I think we're going to have a public hearing. We have appointed Miss Felicia Orth as the hearing officer. And unless anybody has concerns, we'll turn it over to Miss Orth.
Thank you very much, Chair Thompson. Am I echoing a little bit? Move that away. All right. Good morning. My name is Felicia Orth, appointed by the Water Quality Control Commission to conduct a hearing in WQCC 23-84R for rulemaking. This is a proposed rule 20.6.8, ground and surface water protection supplemental requirements for water reuse. The Environment Department Water Protection Division is the petitioner. As probably everyone knows, there's been an awful lot of activity in the matter already, lots of parties. So I'll just mention a few things briefly. One, the rulemaking proceeding will be conducted in accordance with the Commission's rulemaking rules set out at 20.1.6. There are some respects in which we have adjusted the requirements in those rules. I entered one long pre-hearing order. We also had a pre-hearing conference last Wednesday, and there has been a fair amount of email traffic in which I've made some decisions that will be relevant to how we proceed. And I'll raise those as we go along. For example, SIR rebuttal. If it's proper SIR rebuttal, we're going to hear it. If it's not proper SIR rebuttal, we won't hear it. We have 17 expert witnesses. To the extent they have pre-filed both direct and rebuttal, they'll make that presentation at the same time so that we're not going back and forth with the witnesses at different times of the week. We will make a couple of accommodations for witness availability and travel. You'll hear about that. For now, though, what I'd like to do is ask folks for their appearances in the order in which I will ask them to offer their presentations. So for the petitioner, Mr. Knight.
Morning. Good morning, Madam Hearing Officer, Mr. Chairman, Commissioners. My name is Andrew Knight. I'm an Assistant General Counsel with the New Mexico Environment Department, and we are here to propose 20.6.8 to you today. And I've brought 5 witnesses with me, which we will bring up and introduce individually. And we look forward to the hearing. Thank you.
Thank you, Mr. Knight. Ms. Fox?
Good morning, Madam Hearing Officer and Commissioners. My name is Tanis Fox, and I'm a lawyer with Western Environmental Law Center, and I'm here today representing Amigos Bravos and Sierra Club. Thank you for your time and your work.
Thank you. Ms. Nanasi?
Good morning, Madam Hearing Officer and Chair Thompson and Commissioners. My name is Mariel Lanassi. I represent New Energy Economy. And with me today is Christopher Dodd, who also represents New Energy Economy. Thank you very much.
Thank you. Mr. Davis?
Good morning, Commissioners. Madam Hearing Officer, my name is Tim Davis. I represent Wild Earth Guardians in this matter.
Thank you. Ms. Evans or Mr. Cox?
Morning, Commissioners and Madam Hearing Examiner. My name is Colin Cox. I represent Center for Biological Diversity in this matter.
Okay, thank you. And we do have 3 individual entries of appearance that I will call immediately following Center for Biological Diversity. They may or may not be on the platform and have already said that their intention is to offer public comment, but they did enter appearances as individuals. So I will call them. This is Mr. So, Mr. Atencio, or Mr. Sage.
Madam Hearing Officer, my name is Mario Atencio, representing myself, and will present public comment. Thank you.
Thank you. Pause a moment in the event Mr. So or Mr. Sage are on. No? All right. Let's see. Ms. McCaleb or Ms. Taylor?
Good morning, Madam Hearing Officer. Good morning, Chair. Good morning, Commissioners. My name is Liz Newland Taylor, and I'm representing Select Water Solutions. Thank you.
Thank you. Is Mr. Hightower with us?
Mr. Hightower is present, but at the moment he is out.
All right. Give me your name for the transcript.
Stephen Hightower.
You are Mr. Hightower.
Stephen Hightower.
You're
looking
that
for
name.
Mike.
Yes, I am. All right. Thank you. Let's see. Mr. Maxwell.
Good morning, Your Honor, members of the Commission, and esteemed members of the public. My name is Nicholas Ray Maxwell, entering my appearance into this matter. And
Thank you,
I hope
Mr. Maxwell.
to make statements. Thank you.
Thank you. And Mr. Wexler.
Morning, everyone. Nice to see you. Jeff Wexler on behalf of the New Mexico Oil and Gas Association.
Thank you very much. All right, so we have the appearances. The rules are the same as with most of our hearings. Testimony is taken under oath and subject to cross-examination. Commissioners will have an opportunity to ask their questions of the witnesses. All of the parties who just entered their appearances will have an opportunity to ask questions as well. We will, because the rules require that for every day of hearing, we set aside a time to accept public comment. We've tried to be organized about that, and we have a sign-up sheet at the back of the room where you can indicate, where today there are 2 public comment periods. One is at noon and one is at 5. If you would like to indicate your desire to speak at public comment, please sign up on either the first or second page. We will have public comment again every day. No decisions will be made this week by the commission. They are your decision makers, but we are going to have a post-hearing process, meaning the parties will be able to submit post-hearing submittals. The chair has requested a report, and then all of that will be bundled up for the commission's deliberations at a subsequent meeting. We don't know when that will be, but every party will be notified of when that will be. And we can talk more about the post-hearing process at the end of the hearing, which I sure hope is this week. We begin with opening statements. The parties, commissioners, the parties have the option of presenting their opening statements right now or of deferring the timing of their opening statement to immediately prior to the presentation of their case. And that's in their discretion. So we will start with Mr. Knight.
The microphones are very sensitive. Note to all future users of them. Good morning once again. My name is Andrew Knight, and I'm here to present 20.68, our proposed supplemental requirements for water reuse. The department is here today to propose a new part to the ground and surface water protection regulations. This week, we are all going to learn a lot more about water reuse, different kinds of water reuse, including domestic wastewater reuse, direct and indirect potable applications, industrial wastewater reuse, and produced water reuse. The proposed rule creates a framework and definitions for all of these types of reuse, which will allow the commission to build out regulations for each type of reuse in the future as it sees fit.
Oh, my boy. My boy too.
Right. The objective of the rule as a whole is to control discharges of water contaminants specific to water reuse. The rule is supplemental to the regular ground and surface water protection rules, meaning that all of the standards and requirements of those rules still apply to any activity carried out under the proposed rule. The rule is prohibitive when it comes to discharges of any type of produced water, whether treated or untreated. That is because at present, there are just too many unknowns to allow the department to propose standards or specific permit conditions or to permit any discharge of treated produced water in a way that is protective and that complies with the Water Quality Act. At this point, we couldn't even tell you what testing would be needed to determine that a certain treatment technology or combination of technologies would be protective. The 3103 standards in our existing regulations are wonderful, but they only include contaminants that are likely to be found in traditional ground and surface waters. For this reason, treated produced water could theoretically meet all 3103 standards and still not be safe to discharge. While the department was developing this reuse rule, the legislature passed the Produced Water Act, which you will hear a lot more about, and which provides that any reuse of produced water outside of the oil and gas industry will be regulated by this commission and will be done pursuant to a permit issued by the department. This reuse rule has been a huge effort on the part of a lot of people within the department. It has been a multi-year effort. The department convened a advisory committee, drafted a rule, took public comment, and engaged in extensive stakeholder outreach. Throughout this public process, what we somewhat reluctantly came to realize is that the science regarding treatment of produced water is just not there yet. The scientific research that would allow us to protectively permit treated produced water discharges simply does not exist. So we have proposed a rule that creates a framework in which pilot projects and demonstration projects involving produced water can be conducted in a way that is protective of ground and surface water as defined in the Water Quality Act. The proposed rule requires that the knowledge gained from these demonstration and pilot projects be shared with the department to facilitate further regulation development. We have attempted to create a rule that is as protective as possible while still allowing the science to advance through pilot and demonstration projects that will provide us with the data, reliable and reproducible data that will allow further development and deployment of reuse technologies. Each of the definitions in our proposed rule is important. A great deal of time was spent internally debating and deciding which definitions to propose and which to include in this rule, and the exact words used in each definition that was new. Some of the definitions appear elsewhere in our regulations, but we feel it is extremely important that those definitions also be included in this Part 8. As always, we think that the rule we have proposed strikes the perfect balance. And while we urge you to adopt it exactly as we have proposed it, I think what is really more important is that you adopt some version of the rule after this hearing that clearly prohibits discharges of any kind of produced water outside of the oil and gas industry, but that also allows for development and testing of treatment technologies and general advancement of our understanding of this topic. The witnesses you will hear from the department today are among the most qualified people anywhere to talk about this topic. There is probably around a century of collective experience between these people permitting and regulating discharges to ground and surface waters of New Mexico. This opportunity to acknowledge the tremendous amount of hard work that is on the part of our staff that has gone into bringing us to the point where we can propose this rule today. And I just want to say that we are lucky to have these people. In closing, I would just like to say that we don't know what the future holds. Some types of water reuse may turn out to never be practical. Other types may develop in ways we have not anticipated. But what seems clear is that water reuse in some form is going to be important in the future, and there will be continued pressure and continued incentive to develop these technologies in New Mexico. Produced water in particular is a problem that needs to be solved. And there is a great diversity of strongly held opinion as to what the best ways to go about that are. But I just invite you to listen to all the testimony and, reach the conclusion that in your minds is the most practical and pragmatic and what's best for New Mexico, as you always do. With that, I would like to call my first witness. Is that not yet? Or other opening statements?
There may be. I'm going to check.
Okay. That's what I had in my script, so.
Thank you, Mr. Knight. Ms. Fox, would you like to make an opening statement now?
Commissioners, Madam Hearing Officer. Again, my name is Tanis Fox. I'm a lawyer with Western Environmental Law Center. And I'm here today representing Amigos Bravos, a statewide water protection and conservation nonprofit organization, and Sierra Club, a national nonprofit organization dedicated to promoting the responsible use of the Earth's ecosystems and resources. Amigos Bravos and Sierra Club strongly support a prohibition against discharge of treated and untreated produced water to New Mexico ground and surface waters. Our evidence will show that discharge of produced water, whether treated or untreated, to our state's precious water resources is not protective of human health and the environment. We will present two witnesses, Dr. Christopher Lewis, an expert in risk assessment, and Charles DeSalen, an expert in legal drafting. Dr. Lewis has a doctorate in environmental health from the Harvard School of Public Health. He works for Industrial Economics, Inc., which is an international consultancy with expertise in natural resources, policy, and economics. Dr. Lewis has a wide range of experience working for national, state, and international agencies, and has a great deal of experience working in New Mexico. He's been lead for the last 14 years for the natural resources damage assessment for releases of hazardous substances and oil from the historic operations of Los Alamos National Laboratory. Dr. Lewis has conducted a survey of peer-reviewed literature on the toxicology and treatment of produced water. His findings are consistent with those of the expert witnesses from the New Mexico Environment Department. And that is that given the hazards and potential risks associated with discharge of untreated and treated produced water, the treatment technologies available, the lack of information on the precise constituents that are in produced water, and the lack of information on the human health and ecological toxicity of many of the constituents of produced water, a prohibition on discharge of treated and untreated produced water to New Mexico ground and surface water is prudent and warranted in order to protect human health and the environment. Dr. Lewis grounds his opinions in science, and it is the science and protection of human health and the environment upon which the commission must base its decision. The science tells us that the chemicals in produced water vary wildly from well to well, operator to operator, geologic formation to geologic formation, basin to basin. A seminal article on the characteristics of produced water, the 2020 Danforth et al. Article, which is NMED Exhibit 133, and discussed by Dr. Lewis and the NMED experts. In particular, Dr. Lehue finds that there are 1,198 individual chemicals potentially found in produced water. Wow. The chemicals in produced water range from hydrocarbons, salts, metals, and radionuclides. They include known hazards such as arsenic, barium, bromide, mercury, as well as benzene, toluene, ethylbenzene, and xylenes. These particular constituents have the potential to cause carcinogenic, developmental, reproductive, and other adverse effects in humans and other biological organisms. As just one example, a recent meta-analysis found that the maximum concentrations in produced water of benzene were 860 milligrams per liter. That's 860. While EPA's standard for aquatic life for benzene is 5.3 milligrams per liter, and the federal maximum contaminant level for drinking water is 0.0005 milligrams per liter. What can be found in produced water is multiple orders of magnitude higher than EPA standards. But it's worse than that. Benzene is carcinogenic, and its maximum contaminant level goal for drinking water is 0. The New Mexico Oil and Gas Association and Mike Hightower claim repeatedly that treated produced water is safe to discharge as long as New Mexico water quality standards are met. But NMOGA witnesses and Mr. Hightower failed to acknowledge that the Commission's current ground and surface water quality standards do not include many of the potentially harmful chemicals in produced water. How can produced water be treated to standards if there are no standards? NMOGA witnesses and Mr. Hightower are bereft of any explanation. Dr. Danforth, along with her then colleagues at the Environmental Defense Fund, actually compared the potential constituents in produced water with the constituents for which there are New Mexico ground and surface water standards under this commission's rules. They even excluded potential constituents for which there are no standardized analytic methods to identify them. Their analysis found there are many potentially hazardous chemicals in produced water for which there are no New Mexico water quality standards. This analysis, which was submitted to NMED for the Commission's last triennial review, will be introduced as ABSC Exhibit 11 in Sir rebuttal to NMOGA testimony, and it was dropped in the drop box that the parties and the commissioners and the hearing officer have access to yesterday. The bottom line, commissioners, is this. The New Mexico Environment Department's proposed prohibition against discharge of treated and untreated produced water to ground and surface waters in New Mexico is supported by the science and should be adopted by this commission. Now, Amigos Bravos and Sierra Club do take issue with some of how this rule is drafted. And Mr. DeSalen will explain to you why this is and propose changes to simplify, clarify, and streamline the rule. This testimony is important. The rules passed by the commission are its work product, and any rule, which of course carries the force of law, must be clear, well drafted, and comprehensible. Mr. DeSalen, in his direct and rebuttal testimony, methodically walked the commission through why each of his proposed changes to improve the rule is warranted. We hope you consider each of his recommendations. He is one of the foremost authorities on drafting regulations in New Mexico. Amigos Bravos and the Sierra Club have provided a red line strikeout and a clean copy of the language we propose. Those are exhibits 1 revised and 2 revised. I hope you will agree that the revised rule we propose is an improved product. A point of disagreement between Amigos Bravos and Sierra Club that Mr. Knight alluded to in his opening statement and NMED is the inclusion of defined terms that are not used in the body of the rule or that are only used in another definition. Mr. DeSalen, legal scholars, and the Legislative Counsel Services drafting manual, which must be looked to by this commission for guidance in drafting its rules, are all in agreement that such definitions have no place in rule. During the last triennial review, the commission unanimously agreed. Some of you may remember that during that proceeding, NMED proposed definitions for base flow and effluent dominated, terms that were not used in the substantive regulations. Amigos Bravos, a party in that proceeding as well, objected to their inclusion because they served no regulatory purpose. The commission agreed, unanimously voting not to include those definitions. We have included the commission's deliberations and vote as our Exhibit 8. Then the department tried to justify those unused definitions and rule to clarify policy documents. Now the department tries to justify these definitions and rule to clarify permits. But the department's justifications are vague And Mr. DeSalen explains the new rules will not apply to existing permits. And there are other appropriate mechanisms for making permit terms more clear, including issuing department guidance and amending the permits themselves. A significant problem that has arisen from including these unused definitions in the rule is this. Many of the definitions define land applications of reuse water. These include agricultural application, food crop application, irrigation application, and land application, to name a few. The public, understandably, is concerned that the rule allows land application of produced water, and that produced water will infiltrate and pollute groundwater. This is not what the rule says, but it is what members of the public are concerned about. From a public perception viewpoint and from a legal drafting viewpoint, more importantly, it makes more sense to craft these definitions if and when there is regulatory context to assess, evaluate, and craft appropriate definitions for these terms. This rule, in closing, is few in numbers of words and pages, but will nonetheless have tremendous impact in New Mexico and, quite frankly, beyond the four corners of the state. New Mexico should lead based on the science and the evidence presented to the Commission. Amigos Bravos and Sierra Club, thank you for your time and hard work on this important rule.
Thank you, Ms. Fox. Mr. Nasi? Mr. Dodd.
At this time, New Energy Economy defers its opening statement until its presentation of witnesses. However, we would ask that our motion to cure jurisdictional infirmity be heard prior to proceedings in this matter.
Excuse me. I believe the discussion earlier in which every commissioner spoke to whether they believed they had a conflict was meant to address that motion. But let me turn the response to your request to the chair and Ms. Miller.
Thank you. I've been advised by counsel that we don't have to make a jurisdictional determination. And so I think I'm going to let the record stand that if all of the commissioners have stated that they don't have a conflict, and we'll leave it at that.
Thank you, Mr. Chair. Thank you, Mr. Dodd and Ms. Nanasi.
Thank you, Mr. Chair.
Mr. Davis.
Thank you, Madam Hearing Officer. Good morning, Commissioners. Again, my name is Tim Davis. I represent Wild Earth Guardians in this matter. And while this rule proposes a prohibition on the discharge of treated and untreated produced water, it still fails to meet its purpose of regulating reuse water in a way that protects groundwater and surface water in New Mexico. So before I go any further, I want to give you a quick roadmap of why that is. First, it doesn't regulate reuse water in the same way that it does produced water. There is a prohibition on the discharge of produced water, whether it's treated or untreated, but not on reuse water. Second, it fails to provide sufficient standards for treatment and data collection. Third, it permits the use of undisclosed chemicals in demonstration and industrial projects. And fourth, it doesn't protect our freshwater resources from the new waste streams that are going to be created through the treatment process. So I'll start with the reuse water issue. And part of the issue here is that reuse water is defined as treated produced water that is appropriately treated. And there's no standard for what appropriate treatment is. And it does not also say who makes that determination. There's also the issue that you've heard about briefly this morning with industrial projects. And these are demonstration projects without a cap of scope or scale. And given the limited data that we have on treatment of produced water, it's just not appropriate at this time to allow industrial projects. So Guardians would ask a couple of things here. When you adopt a rule, we ask that first, it prohibits the discharge of reuse water, in addition to the prohibition of discharge on treated and untreated produced water. Second, we ask you to adopt a rule that gives standards for what appropriate treatment is for something to become reuse water for any of the contemplated end uses that this rule may have. And third, we ask that you just strike any reference to industrial projects in this rule. It's just premature to contemplate industrial projects in this proposed rule. Next, I'd like to address the data and treatment standards. Instead of providing scientifically based standards for demonstration project treatment and data collection, the rule leaves the decision of how to treat, report, and collect data up to the project proponents themselves. So we would ask that the Commission adopt a proposed rule that includes standards for demonstration projects based on the best available scientific protocols. As an example, the New Mexico Produced Water Research Consortium's document called Guidance on Produced Water Sampling and Procedure could set a minimum regulatory baseline for data quality and assurance, which requires testing at each stage of the treatment train. Likewise, the Commission should adopt a rule that includes standards for handling, testing, and evaluation of produced water data that apply to all demonstration projects to ensure accuracy and conformity of data sets. Next, the proposed rule allows the use of undisclosed chemicals in demonstration projects. The Commission can adopt a rule that protects our surface and groundwater from these undisclosed chemicals under its existing authority. And how would it do that? It can ban the use of produced water, source produced water, that comes from wells where there are undisclosed and trade secret chemicals used. This is important because when you disclose chemicals on the front end of the treatment train, you can use targeted testing to quantify those chemicals. You know what you're looking for. When they're undisclosed, you have to use less accurate testing methods to try to identify undisclosed chemicals. In other words, you don't know what you're looking for. And it's also important to note that while these chemicals are often referred to as unknown chemicals, that's not entirely accurate. These chemicals are unknown to you, they're unknown to the department, they're unknown to me, but they're not unknown to everyone. Others, like manufacturers who do know what is in their frac fluid, for example, could disclose those if they're required to do so. But to be clear, we are not asking this Commission to try and require disclosure in any way. You can use your existing authority to ban the use of any undisclosed chemicals. So if the source water has undisclosed or trade secret chemicals in it, it really shouldn't be used in these demonstration projects. Next, this proposed rule is going to create new waste streams. So the proposed rule directs project operators, demonstration project operators, to dispose of their treated produced water back to the oil field via OCD permitted facilities. The rule then makes a provision for other methods of waste disposal on a case-by-case basis, but it does not outline what should be considered on a case-by-case basis or who makes that decision. So we'd ask that that provision be stricken, the case-by-case basis provision. Let's also remember that demonstration projects can occur off the oil field. Treated produced water goes through stages of treatment that could use undisclosed chemicals, can change the chemical composition of the source water, and ultimately reuse projects are for purposes that are unrelated to the exploration or production of oil and gas. So it's anything but clear whether the treated produced water that comes out of these projects, the new waste stream, the reuse water, it's unclear if that's actually still oil and gas waste. So I can imagine a scenario in which a project proponent takes their treated produced water back to the oil field, but that treated produced water being disposed of at an OCD facility could violate state, federal, or local law. Because again, it's changed its chemical composition. It's been brought off the oil field and it's being used in a process that is not intended for the exploration or production of oil and gas. There's another provision in here that directs all components of a reuse project to be disposed of, ultimate disposition, that's applicable state, local, and federal law. So I think to make this clear, we should require that all treated produced water, reuse water, make it clear that those are components of a reuse project that have to be disposed of under applicable state, federal, and local law. And we also have to make sure that there is a strict prohibition on the discharge of reuse water and that treated produced water is not returned back to the oil field for its ultimate disposition. So in closing, Guardians makes the following request: that you adopt a rule that prohibits the discharge of produced water, treated produced water, and reuse water to surface and groundwater. We ask you to adopt a rule that establishes standards for what appropriate treatment is to basically turn treated produced water into reuse water. We ask you to adopt a rule that includes standards based on the best available science for produced water testing, treatment, reuse, and data collection. We ask you to adopt a rule that does not allow industrial projects. We ask you to prohibit the use of source-produced water from wells where undisclosed or trade secret chemicals are used. If there's undisclosed chemicals, that source water should not be used in demonstration projects. And last, we ask you to strike provisions that direct demonstration project waste, including treated produced water, to OCD disposal sites, and instead require compliance with all federal, state, and local law in the final disposition of treated produced water, reuse water, and new waste created by demonstration projects. As I stated earlier, these new waste streams may not be exempt hazardous oil and gas waste when they are a result of new processes unrelated to the exploration and production of oil and gas. And in closing, I would just ask that the Commission allow Guardians to submit a final red line at the conclusion of this hearing to provide the Commission with the specifics of how Guardians would ask you to implement these requests. Thank you for your time and attention.
Thank you, Mr. Davis. Mr. Cox?
Thank you, Madam Hearing Officer and Commissioners. I'm going to defer my opening statement until we come up in the order of testimony. If that's all right.
That's fine. Thank you very much.
Thank you.
Ms. Taylor?
Thank you. Good morning again, Commissioners. As I said before, I'm Liz Taylor, and I represent Select Water Solutions. Just to give you a little background, Select is a leading provider of sustainable water and chemical solutions to the energy industry in New Mexico, Texas, and around the country. Today, or at this hearing, Select will not be presenting witnesses itself, but I will be participating. Select has infrastructure, chemical manufacturing, and water treatment and recycling capacities and continues to build those out. Nationally, Select's supply of treated or recycled water to the energy industry exceeds 17 billion gallons of water. 17 billion. For those of us in New Mexico, that's more than 52,000 acre feet. A lot of water. Treatment and recycling are expanding water sources for the energy industry. Recycled water also shows promise to support industrial, agricultural, and domestic uses. But expanded uses must be safe and environmentally responsible. Adopting good water reuse regulations is critical to extend the life cycle of water through treatment and recycling while protecting public health and the environment. Good regulations need 3 ingredients. They must be comprehensive, they must be scientifically sound, and their development must include all interested stakeholders. These regulations fail to meet all 3 of these criteria to be good regulations. The regulations are not comprehensive. They address only the reuse of produced water, not domestic water or industrial water. As important, and as you've already heard, the water quality standards are absent. Consequently, the regulations are not scientifically sound because there's no science in them. The water quality standards simply have not been proposed yet. Finally, the development of the regulations failed to include interested stakeholders and the public. After an initial flurry of public meetings back in 2019, the stakeholders have not been involved. For example, the department failed to hold stakeholder meetings to explain the regulations before initiating the public comment period in November. Since November, we have seen 4 different proposed regulations just in the past 6 months, including significant changes that were made in the rebuttal testimony that we got last Monday, just a week ago. The regulations, therefore, failed to meet the criteria to be good regulations. And the regulations are not necessary. The department currently authorizes demonstration projects, and those projects can produce the science needed to develop the standards. Select has a concern, shared by others, that the proprietary information developed in the projects must be protected for trade secret and proprietary reasons. So far, the department has not made efforts to protect this proprietary information. Also, to justify these regulations, the department argues that the regulations are needed to, quote unquote, close a loophole in the current regulatory scheme. But this loophole is an imagined loophole. If treated produced water fails to meet water quality standards, especially if the standards don't exist, then the department can deny the 401 certification needed to discharge the permit. The department apparently wants a regulation to be able to deny a permit based on the source of the water, not its quality. But neither the Water Quality Act nor the Produced Water Act permits such a regulation. New Mexico certainly needs additional sources of water, and treated produced water could be part of the solution. These proposed regulations, however, fail to provide a step toward that solution. The petition should be denied, and the department should be instructed to engage with stakeholders to develop a comprehensive, scientifically sound set of regulations. Thank you.
Thank you, Ms. Taylor. Is Mr. Hightower with us? Mr. Hightower, if you would first please enter your appearance.
To be honest with you, I've never been in one of these. So what is that?
All right.
I apologize, but I spend a lot of time in the academic side. I really haven't been to one of these hearings, so
That's all right.
if you'll lead me, I'll follow.
All righty. If you would give us your name.
My name is Marion Michael Hightower.
Thank you. And on whose behalf are you appearing in this hearing?
I'm appearing on my own behalf. I've done work in produced water and desal for 25 years.
Okay.
And so I'm presenting, my presentation will be about activities over the last 25 years, but I'm currently the director of the New Mexico Produced Water Research Consortium, but I'm also been on boards for the New Mexico Desal Association, and am a emeritus from Sandia National Laboratories, where I did work for the Department of Energy and Produced Water and DSAL.
All right. So as I understand it, just to be very clear, you're not here on behalf of DOE, Sandia, the consortium, or the organizations you've worked with.
No, I'm not. I'm going to provide information on results from all of that work over the last 20 years, but not representing any one of those organizations. No.
All right. So that's the entry of appearance. And the other thing you can do while you're there at the table is to offer a brief summary of what your testimony will be later this week.
Okay. Real quickly, and I've provided that notice of intent to present. And I've given about 25 pages of background information for the last 20 years. Presentation that I will be giving will add more detail of the last 20 years of work looking at non-traditional water resources and how those water resources can be utilized to support water stewardship for both the state of New Mexico, the Southwest, and work that I've done internationally and nationally for the Department of Energy. So I see produced water as a brackish water, saline water, very similar to other waters that we're looking at around the country and around the world as alternative supplies to support additional resources to support surface and fresh groundwater, fresh surface water. So I see produced water very similar to what I look at in other waters is opportunities there to improve water supplies by treating these waters to a level that meets current standards. State of New Mexico has current water quality control standards for a number of fit-for-purpose applications. And what I've been able to see through my research over the last 20 years is that we can meet those current regulations for those fit-for-purpose applications with current technologies. We can do that with brackish water. We can also do that with produced water. So the work that I've done suggests that the technologies are there and the cost performance of those technologies exist to allow us to treat these non-traditional waters to support new supplies for the state of New Mexico. Fair
Thank
enough?
you very much.
Okay, thank
you. Mr. Maxwell.
Your Honor, I'll defer my opening statement until I make a case.
All right. Thank you very much. And Mr. Wexler.
Okay, we'll also defer our opening statement until our cases. I would ask, however, Your Honor, that the Environment Department disclose when and this will become so that we can as prepared as possible. We don't waste time.
All right. Thank you. Mr. Knight, would you share with us what your plan is, please?
Madam Hearing.
Why is it
Examiner,
just me? Why is everybody else so smooth on the mic? I've done this a time or two before, but Madam Hearing Officer, Mr. Chairman, and Commissioners, pursuant to our notice of intent, we intend to call those 5 witnesses, I believe, in the order that they appear in our notice of intent. Yes, that is, in fact, the plan.
Thank you very much.
Yes. And while I'm up here,
Yes, sir.
are there any other opening statements?
No, there aren't.
May I call my first witness?
Yes, I'm only hesitating because it's 10:22.
Yes.
And I'm wondering if a 10-minute break would be appropriate.
Yes.
All right. So you can arrange your witness and let's come back in 10 minutes.
Thank you.
Let's come back from the break, please. All right. Our first presentation will come from the petitioner, Mr. Knight.
Thank you, Madam Hearing Officer. Mr. Chairman, members of the commission, at this time, the department would like to call its first witness and have them sworn.
All right. This is Ms. Fulham.
It is.
All right. Do you swear or affirm to tell the truth?
Yes.
Thank you.
Could you state your full name for the record, please?
Jennifer Fulham.
And what is your current position?
I'm a Water Resource Manager, Class 1 with the New Mexico Environment Department Groundwater Quality Bureau, and I serve as the reuse team leader.
And how long have you held that position?
As provided in my written direct technical testimony filed as NMED Exhibit 2, as the reuse team leader, I provide support and oversight for approximately 450 groundwater discharge permits, at least 95 of which have some element of effluent reuse. I serve as an expert for the regulatory oversight of above and below groundwater reuse projects. I develop policy, guidelines, templates, and regulations for the Bureau. I directly supervise between 3 and 4 full-time staff, conduct compliance inspections, and personally oversee permitting and compliance for at least 23 groundwater discharge permits.
Thank you.
Also, and I know I'm going to have to say this a lot, when you, folks read, they tend to speed up, and we need you to take it slowly.
It's going to be a long day for the court reporter, so do everything we can for her. Please summarize your post-high school education.
I have a Bachelor of Science degree in biology with a minor in geography from the University of New Mexico and a Master of Science degree in environmental science and management from New Mexico Highlands University.
Do you hold any certifications or have you received any additional professional training that is relevant to the proceeding before the commission today?
Yes, I have received training and obtained various certifications applicable to both my position and more specifically to this proceeding. In particular, I attended and received certification from EPA's Water Quality Standards Academy for both tribal waters as well as state waters. I have certifications from EPA on quality assurance management, data quality objectives, and quality management plans. I've also taken the state's rulemaking training as well as their records and information management training. A full list of my trainings and certifications can be found in my CV, which has been filed as NMED Exhibit 7.
Can you tell us about your work experience relevant to the proceeding before the commission today?
I have been employed with New Mexico Environment Department since July of 2007 and have held my current position with the Groundwater Quality Bureau since April of 2023. During my almost 17 years with the department, I was the Surface Water Quality Bureau's Water Quality Standards Coordinator for 6 years, the Petroleum Storage Tank Bureau's Delivery Prohibition Coordinator for 3 years, and an Environmental Scientist Specialist with the Groundwater Quality Bureau for 7 years. Prior to my work with NMED, I was the Environment Department Director for Tesuque Pueblo, a Graduate Research Assistant at Los Alamos National Laboratory, and an Environmental and GIS Field Technician for the Pueblo of Pewaukee. The details of my job duties can be found in my CV.
Have you authored or co-authored any articles relating to your professional training?
Yes. I was a co-author on a study published by Los Alamos National Laboratory investigating migration of polychlorinated biphenyls after the Cerro Grande fire using semi-permeable membrane devices, and was the principal investigator on a paper regarding elk habitat utilization within the lower pinyon juniper forests of Tesuque Pueblo as a means to understand potential contaminant migration. This study was published and filed with New Mexico Highlands University in partial fulfillment of my master's degree.
Have you reviewed the direct and rebuttal technical testimony as filed by the parties in this matter?
Yes.
And did you submit technical testimony and rebuttal testimony in this matter?
Yes. My direct technical testimony was filed as NMED Exhibit 2, and my rebuttal testimony was filed as NMED Exhibit 176.
Do you have any changes or corrections that you would like to make to that written testimony at this time?
No.
And do you therefore adopt your pre-filed written testimony as your testimony here today?
I do.
So let's go through your testimony. What is the nature of your testimony today?
Today, I will give a brief overview of my written direct technical testimony and my written rebuttal testimony. Both include the background for proposing this supplemental rule, the structure of the proposed rule, definitions associated with reuse water sources and applications, and the administrative process pertaining to developing this proposed supplemental rule.
Okay, to start off, please provide the commission with a brief summary of the proposed rule.
Well, the department is proposing reuse regulations supplemental to the state's ground and surface water protection regulations codified in 20.6.2 NMAC. The department is proposing these supplemental regulations to be adopted as a new part 20.6.8.
And what is the intent of the proposed rule?
As provided in my written direct technical testimony, this rule accomplishes a few needs. First, it establishes a framework in which water reuse is managed in New Mexico, given the critical increase and the need for ensuring water conservation and protection. As discussed in my testimony, reuse is expanding in New Mexico. This regulation also provides the language and definitions needed for consistent and transparent implementation of discharge permits as technology and applications such as indirect and direct potable reuse expand. And finally, it provides the regulatory structure for ensuring protection of ground and surface waters as it pertains to treated produced water.
Is this rule specific to produced water?
No. As provided in the title and the objective, the proposed rule is a supplemental rule to control water contaminants specific to all wastewater reuse.
Given this rule is a supplemental rule for various types of reuse, how did the department develop the overall structure of this proposed rule?
The rule is structured in a manner that covers general sections as required in all of New Mexico's administrative code. And this is in accordance with 1.24.10 NMAC. And these include the issuing agency, the scope, statutory authority, duration, effective date, and definitions. Now, there are definitions used in this rule itself, definitions that add clarity to other definitions that are subject to be interpreted, which impacts the consistency in implementation. And finally, there are definitions that are critical for consistent and protective implementation specific to wastewater reuse. The rest of the rule, as illustrated in the department's second amended proposed rule, filed as NMED Exhibit 175, was developed to accommodate reuse for various sources of wastewater. As with many rules, there is a section that provides general provisions applicable to all reuse, and then the subsequent parts, which are focused on the various sources of treated wastewater. For this rule, the department is proposing a section for domestic wastewater, which includes Section 201 for direct and indirect potable applications, Section 300, which is reserved for industrial wastewater reuse, and that is the treated wastewater originating from industrial sources. And finally, Section 400, which outlines restrictions for produced water.
And can you briefly describe the reasoning for these sections?
As discussed in my written direct technical testimony, the state of New Mexico is at a point where supplemental reuse regulations are needed to ensure transparency and consistency with regulating the discharge applications of treated wastewater for beneficial uses. Currently, the Groundwater Quality Bureau permits discharges of treated wastewater for reuse purposes under the state's ground and surface water regulations. There are about 95 facilities with some component of reuse, a majority of which are using domestic wastewater. However, with the interest in using alternative water sources and with the adoption of the Produced Water Act and the Water Quality Act, addressing the application of treated produced water was time sensitive. Given there are other reuse applications already occurring in New Mexico, the opportunity to codify protections evolved organically. Given domestic wastewater applications can continue with the current regulations and guidance, the objective and focus of this first phase of the rule is to start with developing the regulatory framework. So amendments are easily referenced, requiring notices of intent for produced water demonstration projects and providing clarity on discharge prohibitions using treated produced water. Given there are general provisions that will apply to all reuse sources, the rule should have these identified as the first section following the definitions. And based on overall applicability, with domestic wastewater being the most prominent and likely the most referenced, it has been identified as the next section, section 200. Industrial wastewater reuse, meaning the water is sourced from treated industrial sources, is the next most abundant source of reuse water in the state. So it is proposed to be reserved as section 300. And then finally, there is the produced water section, proposed to be section 400 of this rule. Given that the goal of the Water Quality Act is based on water protection, parsing out the rule based on the contaminants in the source water, the development of standards and regulatory protections will align with the potential risks. This structure is critical for ensuring cohesiveness with amendments, citing references, and consistent implementation.
So how is it clear that this rule is a supplemental rule for all sources of wastewater reuse?
It is provided in the title, which states it is a supplemental reuse rule, and in the objective section, where it clarifies this rule is to supplement the general requirements regarding noticing, permitting, and certifying federal permits in 20.6.2.1200 through 2201 NMAC, the general groundwater permitting requirements in 20.6.2 3000 through 3114 NMAC, and the state's surface water quality standards codified in 20.6.4 NMAC.
You state this rule is intended to supplement the permitting requirements for wastewater reuse in New Mexico as it pertains to ground and surface water protection. Can you explain why there is no content in the sections on domestic wastewater reuse and industrial water reuse, sections 200 and 300 respectively?
In short, the department regulates discharges of treated domestic wastewater for reuse purposes using the regulations in 20.6.2 NMAC and reuse guidelines, and will continue to do so until regulations specific to domestic reuse are codified. But at this time, no permittees are impacted by not having these regulations. On the same note, produced water demonstration projects and the department's authority to require notices of intent is impacted and makes this rule time sensitive for this particular industry and impacts to ground and surface water protection. More detail of my reasoning is found in NMED Exhibit 176.
Which is, as you noted, your rebuttal testimony, is that right?
Correct.
So the development of the regulations for domestic and industrial wastewater sources is still in development?
Yes.
Would it have made sense, as indicated in D'Antonio's testimony, filed as NMOGA Exhibit 2, to wait until the language and evidence for these sections was developed before petitioning the commission?
No. The problem with that approach is that this would hold back the development of reuse regulation by years, at which point the technology and evidence for some of these sources would inevitably be outdated. Waiting years to develop the regulations for produced water would have put the department in a predicament given the notices of intent are not required under the current regulations for non-discharging projects, and there is no clear authority to deny a permit for a produced water discharge, as Mr. Herman discusses in his testimony. Finally, it is important to clarify that almost all rules are developed in phases and amended as new science or evidence warrants. I do not know of any regulation that has not undergone amendments over time, and one can look at a part of the administrative code and see the list of amendments and their dates at the end of each section.
What makes this phased rulemaking approach more efficient?
Well, as discussed in more detail in my rebuttal to D'Antonio's testimony, there are three significant reasons for conducting rulemakings in a phased approach. First, the resources needed to develop a rule of magnitude suggested by D'Antonio would be extensive and would slow any rulemaking development by years. Second, this rule covers a broad range of wastewater sources, and water reuse is an emerging and rapidly evolving field. In this context, it is important to get an overall framework in place so that we can build on it as each area develops. Waiting until we have all the answers to propose any rule at all, and then trying to do it all at once is simply not practical. It would create risks to surface and groundwater in the meantime. The third reason for not conducting a single rulemaking is the consideration of the public and the Commission's time to be able to invest in participating in the rulemaking process. Sufficient time should be afforded for everyone to review the evidence and participate in a meaningful way. Trying to conduct a comprehensive rulemaking would require an extensive amount of time, thus extending the rulemaking process out even further.
But if there are guidelines and permits already issued for domestic wastewater reuse, why is the department initiating an overall supplemental reuse rule? Why not just continue using the guidance and the regulations in 20.6.2 NMAC?
It is a good question. First, the guidelines are not subject to a public process, whereas a rule is. Second, the guidelines are limited to domestic wastewater reuse, whereas the state has the need for other types of reuse, including reuse from industrial sources and applications such as direct and indirect potable. Currently, there is a public comment period for each permit as it is issued, renewed, or modified. But if one were trying to focus on the conditions for all the permits with a reuse element, it would take years of continually scanning public notices and reviewing each permit on a case-by-case basis as it came up. This is illustrative of the growing need in New Mexico to conserve and protect our water. Essentially, we are outgrowing the 2007 guidance, and given the number of reuse permits the department is managing, the time to codify these regulations is becoming more pertinent.
As far as the topic of produced water goes, you mentioned that section 400 is titled produced water reuse. Given this is a reuse rule and produced water has its own section, does this imply that discharges of produced water, treated or untreated, would be authorized?
No. Section 400 has three subsections. The first, subsection A, is general requirements, which explicitly prohibit treated or untreated produced water discharges. Subsection B discusses authorized uses, for which this rule only authorizes non-discharging demonstration or industrial projects, pending determination by the department through the notice of intent process that the project is non-discharging. Subsection C then discusses the elements necessary for the notice of intent so that NMED can make the determination and ensure there are no discharges.
Was the intent of this phase of the rule ever to permit application of treated produced water?
No. As far back as 2019, as illustrated in public presentations submitted as NMED Exhibit 61, the intent of this first rulemaking was to be restrictive.
And does the language in the rule provide for discharges of produced water?
Again, no. The rule prohibits discharges of produced water, treated or untreated, but the department recognized that in former versions of the petitioned rule, the headers of subsection 400B was titled Authorized Applications, which could have been misleading.
Was there objection to the language in this section of the proposed rule, the section on produced water?
There was no direct objection to the language, but there were objections asserting the rule allowed for discharges of produced water, which it doesn't.
And what was the issue with using this language for the header?
So although the language within the subsection clearly discusses non-discharging uses of produced water, the title implies that applications, being defined as discharges subject to a permit, were being authorized. This may lead one to conclude that the department and this rule authorize such activities, which is directly conflicting with the language in subsection A that explicitly states the department would not certify or issue permits that discharge to ground or surface waters.
So was the language in the header for 20.6.8.400B, was that language clarified to align with the intent and other parts of the proposed rule?
Yes. As provided in NMED Exhibit 175, the header has been amended to reflect the authorized uses, which at this point only allows for non-discharging demonstration and industrial projects.
So the department is proposing these regulations to accommodate need for a clear path with protective restrictions for produced water while still implementing other reuse permits without interruption. Is that right?
Yes.
Let's talk about the definitions in the proposed rule. In your testimony about the structure of the rule, you touched upon some of the definitions for wastewater sources. Can you explain in a little more detail why the department is proposing terminology associated with wastewater reuse sources?
So, as the reuse team leader, all applications and draft groundwater discharge permits with proposed reuse are routed through me. In permits, one of the common issues we run into regularly is the use of terminology. Without defined definitions between source waters and applications, terms tend to be used interchangeably, which is problematic when you are trying to distinguish between a wastewater source and the discharge. You will commonly hear the term industrial reuse, but currently, this could be referring to the source of treated wastewater or the intended end use for industrial purposes. The need to develop consistency in terminology is critical for consistent implementation of permits and communicating those requirements with the regulated community. In order to resolve this issue, the department has proposed terms to differentiate between wastewater sources being used for reuse and the applications, which are the types of discharges.
Were there any objections to the definitions relating to source waters?
There was no direct opposition to the definition for domestic wastewater. There were some comments on the definition of produced water, but I will defer to Kathleen Murphy to discuss the merits of those objections in more detail.
Are the terms associated with reuse interchangeable with terms for applications?
No. And historically in our groundwater discharge permits, we've referred to terms on a case-by-case basis, which over time, with ever increasing number of permits, is problematic for consistent implementation and enforcement.
Are these terms currently integrated into discharge permits?
To an extent, The department does reference various types of applications and the source of treated wastewater, but consistent reference to these types of applications being used in permits varies considerably, even with efforts to streamline terminology. As provided in my written direct technical testimony, the ability to quantify volumes or discharge for our permits isn't exceptionally accurate.
Can you point out how the proposed terms associated with applications are structured in the proposed rule?
Sure. There are 12 terms related to reuse applications. The first is the broad term for application, which identifies that an application is a discharge of treated wastewater for reuse. Then there are 11 subcategories, with varying descriptions predominantly related to potential threat to groundwater and human exposure. My direct testimony goes into more detail on how each of these subcategories is relative to developing permit conditions based on the risk to groundwater and human health.
When discussing definitions for applications, why is it important to consider where the reuse water goes or how it is applied? Isn't clean water good enough?
You would think. But the fact of the matter is that the impacts to ground or surface water is dependent on how the water is applied. Contaminants are harmful based on dose. So concentration and potential exposure or migration to a ground or surface water varies with each of these types of applications. In order to condition permits to be protective, we have to know what contaminants are in the source water before treatment, the type of treatment being employed, how effective it is in removing those contaminants, the quality of the treated water, and how it will be applied for reuse. This allows us to determine what types of limits on exposure and concentrations are protective. It is important to clarify that not all treated water is protective of human health or the environment. Both the source and type of application must be considered.
Were there any objections to the definitions relating to applications?
There were, particularly from Amigos Bravos and Sierra Club, as described in DeSalen's testimony, filed as ABSC Exhibit 6, although others also objected to the inclusion of definitions for various applications.
What is, as you understand it, what was the basis for these objections?
The overwhelming majority of the objections were for the specific types of applications, because the terms are not used directly in the rule. The arguments conclude that without the use in the rule, it is impossible to understand the applicability of the term.
Does the department disagree with the reasoning for those objections?
Yes. First, this rule is supplemental to 20.6.2 NMAC, which provides the language for permitting discharges. These terms are aligned directly with the enforceable language in a groundwater discharge permit. Secondly, DeSalen's argument citing the legislative style manual is misleading. This is the manual used for formatting of acts adopted by legislature. As discussed in my rebuttal testimony, it is also used for formatting and style of regulation. However, there is a critical functional difference between an act and a regulation. A regulation is the tool used for implementation. The New Mexico Administrative Code Regulation, filed as NMED Exhibit 181, does state in 1.24.10.12 NMAC that relevant portions of the legislative drafting manual should be used for style, but nowhere in this section does it discuss guidance for definitions. In addition, the regulation identifies the Administrative Law Division of the State Record Center and Archives as the delegated entity for determining if a regulation meets style and format.
And did the department submit the proposed rule to the Administrative Law Division for review?
Yes. As provided in my rebuttal testimony, the department submitted the proposed rule to state records on October 27th, 2023.
And did the Administrative Law Division provide any comments or edits?
Yes. As discussed in my written rebuttal testimony, the Director for the Administrative Law Division provided edits to the proposed rule prior to public comment. This email was filed as NMED Exhibit 183. It should be noted the Administrative Law Division did not have any edits regarding the definitions.
Are there other regulations that have definitions that are not used within the body of that particular rule?
Yes. As provided in my rebuttal testimony, there are quite a few examples. The inclusion of these definitions as proposed in this rule is not that unusual and would not be setting precedent.
Is the commission, in your opinion, authorized to adopt regulations to implement actions that protect ground and surface water?
Yes. As provided in my rebuttal testimony, I believe the commission has the ability to adopt definitions that aid in implementation. The department has the need for these definitions for implementation and permits. And given this is a supplemental rule for the already codified permitting regulations to protect ground and surface water, this is the applicable place for these definitions. And given implementation is the function of a regulation, and the Administrative Law Division did not have concern with the inclusion of these definitions as proposed, I see no reason why these definitions should not be adopted.
What would be the consequence of not adopting definitions for these terms as suggested by some of the other parties?
Well, for the already 95 plus existing groundwater discharge permits with reuse elements, having defined terms that have been subject to public participation for the types of applications is key to being able to manage the state's water resources effectively. The department could develop terminology without engagement, such as through guidance, but developing enforceable terms without engagement is not ideal because it is subject to change without having a notification process in place to notify the affected permittees or the public. Our goal is for protection of ground and surface water, and that requires knowledge and involvement from the affected parties. To be honest, the department has implemented terms for reuse as needed up until now, but the department felt that the significant increase in interest and exponential development of water reuse in the state warrants codification of these terms sooner rather than later.
Does having definitions for the various applications in the rule imply discharge of produced water is permitted?
No. And as I discussed earlier, this rule is a reuse rule. It is not a produced water rule. The scope of this rule, as proposed in NMED Exhibit 175, is applicable to persons intending to reuse wastewater. Given the scope of wastewater reuse occurring in New Mexico, predominantly from domestic wastewater sources, it is imperative to implement applications in these groundwater discharge permits in a consistent manner. As discussed throughout NMED's cumulative testimony, whether produced water is ever authorized to discharge for any of the described applications still remains to be seen.
Is there somewhere a permittee or a new regulator could go to reference these terms?
Not at the moment. There is the department's 2007 above ground use of reclaimed domestic reuse guidelines and EPA's 2012 guidelines for water reuse, which are helpful, but not completely aligned with one another.
So how does a new permit writer or a permittee know what the application in their permit allows and doesn't allow?
They would have to discuss the conditions of the permit with their technical permit writer or with the reuse team leader. Because there are various nuances to how permittees propose to reuse wastewater when applying for a groundwater discharge permit, permit descriptions can vary considerably.
Will this terminology aid in implementation under the existing and future discharge permits with reuse elements?
Definitely. Being able to refer to a codified definition that provides the permittee with the description authorized for discharge will inevitably enhance compliance and provide the regulated community with the essential information to meet expectations for groundwater protection.
So in your opinion, there is value and applicability in codifying these terms in the rule as proposed?
Yes, these terms are critical for consistent implementation, which is the core function of a regulation.
All right, now let's briefly discuss the rule development. Going back to something you mentioned earlier, there have been several versions of the proposed rule up to the most recent version, which was filed with the department's rebuttal testimony as Exhibit 175. Can you give a brief overview of the various stages of rule development and the various iterations of the rule language?
Sure. The department started with a working draft version in September of 2023. This working draft was used to initiate discussions during the advisory committee meetings. Then, in November of 2023, the department released a public comment version, which had incorporated the applicable comments and input from the advisory committee. The commission can refer to the public comment version in NMED Exhibit 49. The department incorporated the applicable public comments into the proposed rule and petitioned for a hearing in December of 2023. The commission can refer to the comments provided during the public comment period in NMED Exhibit 70 and the December 2023 version of the proposed rule in NMED Exhibit 71. Following review during drafting testimony for the December 2023 version, the department filed an amended petition in March of 2024. This version, referenced as the first amended proposed rule, is referenced as NMED Exhibit 1 and was the reference for the department's written direct technical testimony. Now, upon reviewing testimony from other parties filed on April 15th, 2024, in accordance with the pre-hearing order, the department amended the proposed rule to either clarify language or correct grammatical errors. This version is referenced as the second amended proposed rule and was filed with the commission on May 6, 2024. This version is referenced in NMED's rebuttal testimony as NMED Exhibit 175, and this is the version being considered for adoption by the commission.
Is it standard practice to have this many iterations of a proposed rule such as you described here?
It is. In the numerous rulemakings that I've been involved in, the process is iterative and public. The changes are based on input by the department, the advisory committee, stakeholders, tribes, and the public. It is the department's opinion that these iterations, based on supportive evidence, demonstrate the public rulemaking process is working, not just for the department to implement, but for the affected regulated community that adhere to these regulations and the affected citizens that depend on the protection of ground and surface waters. I provide more detail on the reasoning in my rebuttal testimony.
You mentioned quite a few points of engagement and input from various groups that contributed to the proposed rule. Is this also summarized in your testimony?
Yes, and I will discuss this a little later when I provide more detail about the administrative process, but I do provide a detailed description of the department's engagement and the regulatory obligations for the department's actions in my written direct technical testimony.
Okay, let's go back a little bit. You discussed the reasoning for the amendments between the public comment version and the version that was filed in December of 2023. But there was an amended version filed in March 2024, which is, I guess was known as, that was the first amended proposed rule. What did the department change?
Well, there were some grammatical corrections and adjustment of where the language regarding prohibition was, but the most significant amendment was to the language in section 400, which referenced industrial applications.
Okay, why was the language as proposed in the December 2023 version problematic?
As described in my written direct technical testimony, the purpose of this proposed rule was to prohibit discharges of treated and untreated produced water because, as discussed in Ms. Murphy and Dr. Hu's testimony, the evidence just hasn't demonstrated that NMED could regulate discharges of treated produced water in a way that would be protective of ground and surface waters. The issue arises because the language in section 400 referred to an industrial application as being an authorized use. But for implementation purposes, the use of the term application is a discharge, which was contrary to the intent and the rest of the language in the section on produced water. The department recognized the language as proposed in December 2023 posed a significant implementation problem.
So how did the department address that issue?
The department revised the rule to provide clarity that applications of treated produced water have not been deemed to be protective of surface or groundwater and would not be permitted. The department acknowledges the benefit and interest in exploring the potential of produced water for industrial purposes and wanted to highlight that initiative. Instead of using the term industrial applications, which again is defined as a discharge, the department created a more descriptive, non-discharging term to align with, but be more descriptive than the term demonstration project. The department wants it to be clear there are no discharges of treated produced water authorized under these proposed regulations, but use in industrial projects, similar to demonstration projects that are designed and reviewed by the department to be of no impact to ground or surface water because they will not discharge, may be conducted. This closed that inadvertent loophole that the language in the December 2023 version caused. Now, as a consequence of amending the language in section 400, the department incorporated a new definition for industrial project.
So the first amended version from March 2024 corrected the language to align with a non-discharging rule for produced water. Now let's focus on the second amended version filed on May 6th, 2024, since this is the one, that is the version being considered today for adoption. Can you highlight the amendments that are of note from the first amended version filed with the commission on March 2023?
Certainly. First, as provided in my rebuttal testimony, the department corrected some formatting issues and citations to any reference acts as provided by State Records Center and Archives, New Mexico Oil and Gas Association, Amigos Bravos, and Sierra Club. In addition, the department also concurs with DeSalen's arguments on several points. First, that direct potable applications as defined did not explicitly restrict sources to domestic wastewater. As such, the department amended the definition to the term direct potable application to align with the definition for indirect potable application to be restricted to reclaimed wastewater, which is limited to domestic sources. Secondly, Amigos Bravos and Sierra Club in ABSC Exhibit 1 identified two pertinent elements needed for a notice of intent under the proposed rule. The NOI should include the concentration of water contaminants in the untreated produced water and the volume of produced water being proposed in the demonstration project. As a result of Amigos Bravos and Sierra Club's testimony, the department has amended the proposed rule to include these two elements. Finally, DeSalen's arguments regarding section 400D regarding effluent quality. They were noted, and so the department is proposing to strike the subsection on produced water effluent quality in its entirety instead of reserving it. Additionally, based on Namoga's testimony, the department concurs with and is proposing to add clarifying language in the scope to identify it is only applicable to the delegations afforded to the Environment Department and not those delegated to the New Mexico Energy, Minerals, and Natural Resources Department, which also administers protections under the Ground and Surface Water Protection Regulations codified in 20.6.2 NMAC.
You mentioned subsection 400D. Can you describe the amendments that have been made regarding this part?
This part of the proposed rule has undergone considerable amendments based on input from the advisory committee, public comment, internal review, and filed testimony. In short, the department initially drafted language for this section that stated until such a time that water quality criteria based on scientifically defensible information could be adopted for discharges of produced water, the department would not approve a discharge plan. Following public comment, specifically from Renovo Resources and Western Environmental Law Center, the language was amended to be more direct, remove duplication of language in other sections, and remove assumptions of future predictions. This was the version filed in December of 2023. However, on the first amended version, the department felt the language in this subsection led to confusion that there were effluent limits. So the department removed all the language, but left the subsection reserved. Based on comments from multiple parties in their testimony, the inclusion of this subsection, now that it contains no content, is not necessary. So the department is proposing that subsection D in 20.6.8.400 be removed in its entirety.
And this change reflected in the second amended rule. This change is reflected in the second amended rule filed with the commission on May 6th. Is that correct?
Yes.
So does the lack of defined effluent standards for produced water allow for a person to discharge produced water?
No. As I describe in the structure of the rule, subsection A clearly identifies that there are no discharges of produced water authorized under this rule.
Okay, moving on to the administrative process. How long has the department been working on the development of this proposed rule?
The department began efforts for this restrictive or prohibitive rule since the amendments to the Produced Water and Water Quality Act, and that was in 2019. As discussed in my written direct technical testimony, this has been a multi-year process involving the public, oil and gas industry, non-government organizations, tribes, stakeholders, the public, and the New Mexico Produced Water Research Consortium.
What actions did the department initially take to engage the public?
Well, early on, prior to any rule development, NMED presented on the topic both with the tribes and public, as illustrated in NMED Exhibits 54 and 61 respectively. The subject matter for these initial discussions was focused on the research and rulemaking efforts that were being planned based on the 2019 amendments to the Produced Water Act and the Water Quality Act.
In your written direct technical testimony, you discuss the Produced Water Advisory Committee. Please describe who was on this committee and why.
Following the department's initial outreach efforts, and as required under the Water Quality Act, the department formed the Produced Water Advisory Committee, which, as discussed in my written direct technical testimony and illustrated in NMED Exhibit 47, was comprised of members representing oil and gas, tribes, and other interested organizations.
So there was an advisory committee for the sections of the rule focused on produced water, but was there also an advisory committee for the sections relating to direct and indirect potable feasibility studies?
No,
Could you briefly describe why not?
I would be glad to. The department, aligning with the language in the Water Quality Act, which I am paraphrasing, says the commission may adopt regulations for particular industries and establish an advisory committee comprised of persons with expertise particular to that industry. But given the limited applicability of these feasibility studies, which are not mandated by all municipalities, the department determined that the adoption of this portion of the proposed rule would not have implications to the domestic wastewater industry as a whole, and as such, did not establish an advisory committee. As I discuss in my rebuttal testimony, prior to the development of this section of the proposed rule, the department has engaged with communities that are interested in developing direct and indirect potable reuse. Future regulations relevant to potable applications would likely require development of an advisory committee prior to petitioning the commission.
So once the advisory committee provided input, what other engagement did the department conduct prior to filing the petition in this matter?
Well, again, as I discuss in more detail in my written direct technical testimony, the department also solicited stakeholders and invited tribal participation prior to any public noticing. Then, in November of 2023, the department broadly distributed the 30-day public comment period notice on the draft rule. The notice of the draft rule was distributed in English and Spanish and published in newspapers, various locations on the department's website, emailed to over 3,000 subscribers on the department's listservs, sent to 135 self-identified stakeholders, and to our state's tribes, pueblos, and nations. Comments were received via the department's public comment portal. During this 30-day public comment period, the department received comments from 24 entities encompassing a total of 429 individual comments. I provide a summary of these comments in NMED Exhibit 70, but the full set of comments has also been made available on the department's water reuse webpage. Ultimately, these comments resulted in the proposed rule that was filed with the commission in December of 2023.
And were there additional noticing requirements specific to a public hearing?
Yes. Starting on page 19 of my written direct technical testimony, I outlined the various regulatory requirements for noticing a public rulemaking hearing.
For this matter, who provided the obligatory notice of public hearing?
The department.
And can you summarize the actions the department took?
Yes. The department published the public hearing notice in English and Spanish in the State Register, the Santa Fe New Mexican, and the Albuquerque Journal, all prior to the 60-day hearing requirement. In addition, the department provided notification to the agency's district managers, posted the notice in several places on the department's website, emailed the notice to individuals subscribed to the Groundwater Quality Bureau, Produced Water, and Surface Water Quality Bureau's listservs, posted the notice on the Sunshine Portal, and provided the notice to the Legislative Council Service. In accordance with 14-4A-4 of the Small Business Regulatory Relief Act, the department also provided notification via letter and later met with the Small Business Advisory Commission on March 13th, 2024. Finally, in accordance with the State Tribal Collaboration Act and the department's Tribal Communication and Collaboration Policy, the department provided the public hearing notice via email to tribal representatives. For more details on the noticing undertaken by the department, please refer to my written direct technical testimony and NMED Exhibits 54, 60, and 72 through 80.
Were there objections to whether the obligatory hearing notice requirements were met?
Yes.
What was the basis of these objections?
Mr. Maxwell submitted comment to the department via email on March 25th, 2024, identifying that although the notification process met most of the requirements, all more than 60 days before the hearing notice had not been posted on the Water Quality Control Commission's website. Although it did appear in a different location on NMED's website, Mr. Maxwell followed up with a formal comment to the Office of Public Facilitation on March 26, 2024, reiterating the issue, and also pointed out a typographical error in the notice posted on the Sunshine portal.
Did the department correct the concerns posed by Mr. Maxwell?
Yes. The department notified the Office of Public Facilitation and submitted a correction to the Sunshine portal. Both entities responded with corrections by March 26, 2024, 48 days prior to the hearing.
In your opinion, given your experience with providing notices in other rulemakings, did the department sufficiently fulfill the expectations with respect to noticing this public hearing?
To the best of the department's abilities, yes.
Did the department file its notice of intent as prescribed in the pre-hearing order dated February 13th, 2024?
Yes. The department timely filed its notice of intent to present technical testimony, which included direct written testimony and supporting exhibits on April 15th, 2024.
Should the commission adopt the rule as proposed or amended, what is the process to make the rule effective for state purposes?
Well, following the determination by the commission, a final order and statement of reasons will be issued. Based on that document, the department will file the rule with state records for publication in the state register. The rule will become effective either 30 days after filing the rule with state records or after publication in the register, whichever comes later.
All right. And finally, does the department support the second amended version of the proposed rule filed as NMED Exhibit 175?
Yes.
Thank you. And that concludes this first witness's testimony. And I would at some point like to move for admission of all the exhibits, but I think I might wait until all witnesses have testified, if that's all right.
It's fine.
At this point, I would like to bring up my next witness.
All right, and I understand we're not engaging in cross-examination at this time because you're going to present your witnesses as a panel for cross.
That is correct.
All right, thank you. And if you would, we're going to have to take just a short break before public comment, which is going to begin at noon. So I'm sorry, you're only going to get about 15, 20 minutes in.
I'll try to balance speaking fast and being slow.
No.
Well, yeah, we will
speak slowly but clearly.
We'll resume after public comment, and
that makes more sense.
Yeah.
Would you raise your right hand, please? Do you swear or affirm to tell the truth?
I do.
And spell your name for the transcript.
My name is Jason Herman, JASONHERMAN.
Thank you, Mr. Herman. What is your current position?
I am the Pollution Prevention Section Program Manager with the New Mexico Environment Department Groundwater Quality Bureau.
And how long have you held this position?
I have been the Program Manager for 2 years.
And what duties are entailed by this position?
As the Program Manager, I oversee the permitting process for domestic, industrial, and reuse discharge permits that may affect groundwater in the state. In this position, I am responsible for managing the funding sources and grants associated with the work of the Pollution Prevention Section. And lastly, I act as the arbiter regarding implementation of the discharge permitting regulations and the enforcement as they relate to domestic, industrial, and reuse permitting.
Please summarize your post-high school education.
I have a bachelor's degree in environmental planning and design from the University of New Mexico, a master's degree in community regional planning from the University of New Mexico, and a master's degree in water resources management from also the University of New Mexico.
Can you tell us about your work experience that is relevant to the proceeding before the commission today?
Sure. Before going to UNM for my degrees, I worked for 2 companies in South Florida that focused on water treatment of all kinds. At All Florida Water, I focused on groundwater quality treatment, system design, operations of small to large treatment systems, and installations as well. One of my main duties at All Florida Water was to provide high purity water technologies and regulatory compliance for water treatment systems used for manufacturing and hemodialysis facilities, testing facilities, and microchip manufacturers. At Reverse Osmosis of South Florida, I worked on desalination of seawater for drinking water, chemical composition recreation, system design, and installation of water treatment systems for difficult or operationally difficult groundwater treatment systems. During my time at Reverse Osmosis of South Florida, I was sent to Nicaragua, Grand Bahama Island, Jamaica, and Haiti to complete repairs and installations on groundwater treatment systems, mostly reverse osmosis and ion exchange technologies. In graduate school, I worked on multiple direct and indirect potable reuse research projects, including my thesis, and as a graduate assistant on a large-scale survey related to public acceptance of potable reuse. The title of my thesis was the cost of direct and indirect potable reuse in a medium-sized arid inland community, which was followed by a willingness to pay study titled Measuring the Impact of Rate Increases on Consumer Acceptance of Potable Water Reuse Options in the Albuquerque area. At MAD, I started as an environmental scientist in the pollution prevention section, and then was promoted to domestic waste team leader. In all, I have more than 6 years of experience in implementing the ground and surface water protection regulations at 20.6.2 NMAC. My other work experience can be found in my resume, filed as NMED Exhibit 8.
Have you authored or co-authored any articles relating to your professional training?
Yes, as I stated previously, my thesis was titled The Costs of Direct and Indirect Potable Water Reuse in a Medium-Sized Inland Community. It was published in 2017 in the Journal of Water Process Engineering. I also have 2 final reports published by the New Mexico Water Resources Research Institute. The first is the report my thesis is based on and has the same title. I won't go through it again. And the second is titled Measuring the Impact of Rate Increases on Consumer Acceptance of Potable Water Reuse in the Albuquerque area.
Have you reviewed the direct technical testimony as filed by other parties in this matter?
Yes.
And did you submit technical testimony in this matter?
Yes, my direct technical testimony was filed as NMED Exhibit 3.
Do you have any changes or corrections that you would like to make to that technical testimony?
Yes, on page 3 of my rebuttal testimony, I used the phrase, quote, to determine if a demonstration project or industrial project activities are protective of ground or surface water. That sentence should have read, to determine if a demonstration project or industrial project activities will have the potential to move directly or indirectly into ground or surface waters.
So do you adopt your pre-filed written testimony with that correction here today?
I do.
Can we get that information in a minute? Yeah, well, we'll get that to you. What is the nature of your testimony today?
My testimony will summarize the reasoning and supporting evidence the department used to draft the proposed regulations, the implications of not adopting the regulations, and how the department envisions the implementation of the proposed regulations.
All right. Can you briefly describe the sections of the proposed rule that you're covering in your testimony today?
Today, I will be testifying regarding 7 topics for the proposed regulations. First, my direct testimony covers the general authority given to constituent agencies of the WQCC that can propose regulations to the Commission. Second, my testimony focuses on multiple definitions that are used throughout the proposed regulations. Third, my testimony focuses on definitions related to domestic wastewater facilities and feasibility studies. Fourth, my testimony addresses the need and purpose of including the direct and indirect potable applications section in the proposed regulations. Fifth, my testimony provides supporting reasons and evidence related to portions of the produced water reuse section of the proposed regulations. Sixth, I will testify regarding the implementation and of the proposed regulations. And lastly, I'll testify regarding the potential consequences for not adopting the proposed regulations.
Can you briefly describe the department's reasoning for these sections?
Sure. My testimony on the authorities granted to the WQCC and constituent agencies will provide the legislative and regulatory context that the department drafted the proposed regulations within. The definitions section, as proposed, will provide the department with the necessary clarity and support to implement standardized reuse permitting as well as the proposed regulations. The proposed regulations will also explicitly prohibit the discharge of treated or untreated produced water outside the oil and gas industry. Additionally, the proposed regulations will formalize the existing process for submissions of produced water notices of intent to the department for entities that want to study produced water treatment processes in a safe and controlled manner that does not pose a threat to ground or surface waters in the state. Lastly, the proposed regulations include a section to authorize feasibility studies for communities that want to explore potable reuse options to augment their drinking water supply with treated domestic wastewater.
The first topic you mentioned is the authority of the department, the authority the department is relying on for the produced or for the proposed regulations. Can you provide a brief summary of this portion of your direct testimony?
Sure. The Water Quality Act was amended by the Produced Water Act in 2019. The Produced Water Act specifically directed the WQCC to adopt regulations to be administered by the Environment Department for many aspects of treated produced water, including the use of treated produced water outside of the oil and gas industry. The Water Quality Act already contained the guardrails and requirements necessary to promulgate regulations with directions on what the Commission should give weight to and what circumstances are relevant to the rulemaking process.
Did any party object to this section of the proposed rule?
Yes. Wild Earth Guardians, New Energy Economy, and the New Mexico Oil and Gas Association all objected to the proposed regulations on the basis that the Produced Water Act did not authorize or direct the promulgation of the proposed regulations.
And again, as you understand it, what is the basis of these objections?
The objections regarding the authority and underlying directive stemmed from a common misunderstanding of the interactions of other regulations, the proposed regulations, and the existing ground and surface water protection regulations. Some objections focused on the incorrect sections of the Water Quality Act that focus on promulgation of water quality standards instead of the appropriate sections which focus on the rulemaking process that are not related to water quality standards.
And what is the department's response to these objections?
The department believes that the proposed regulations are within the mandate in the Produced Water Act and fulfill the requirements of the appropriate Water Quality Act sections. Many of the changes suggested by the parties would exceed the department's authority and would likely be challenged in a manner that the department would be unable to defend or implement. Further, Some of the suggested changes would either duplicate other existing regulations or conflict with the regulations implemented by other New Mexico state agencies and federal regulatory agencies.
What is the purpose of the proposed regulations?
Every gallon of water that is reused saves a gallon of fresh water that would normally be used for that use. This is only true if the discharged reused water is dispersed in a manner that is protective of existing surface and groundwaters as required by the Water Quality Act. The proposed regulations uphold that requirement and will ensure that produced water will not be discharged in a manner that has the potential to affect ground or surface water.
The second topic you identified earlier is the definitions used throughout the regulations and for implementation of reuse permitting. What definitions does your direct testimony address? And can you provide a brief summary of your testimony?
Yes, my direct testimony identifies 15 definitions in 3 categories, which I'll do my best to quickly list, as well as provide a short summary of the reasons for the department including them in the proposed regulations. The first category is definitions that are included by reference. Those definitions are discharge permit, discharge plan, discharge site, disposal, groundwater, and injection. The department proposes to include these definitions by reference to the controlling regulations for the proposed supplemental regulations. These definitions will assist the department in the implementation of the proposed regulations and other existing reuse permitting activities. It should be noted that discharge plan and discharge permit are used interchangeably, and in the existing ground and surface water protection regulations, different sections refer to both plans and permits due to a change in the nature of the regulations that have not yet been fully fixed. Second category is new definitions included specifically for the implementation of the proposed regulations. Those definitions are reuse water, transference, treatment, untreated wastewater, and wastewater. The department proposes to include these definitions as newly defined terms. These definitions will assist the department in implementation of the proposed regulations and other existing reuse permitting activities. The third category is definitions not found in the existing regulations, but are defined by the Water Quality Act. And those definitions are for water contaminant, water pollutant, and water pollution. The department proposed to include these definitions, which are found in the Water Quality Act. These definitions will assist the department in the implementation of the proposed regulations and other existing reuse permitting activities.
Did any party object to this section?
Yes, multiple parties objected to the definitions, including Amigos Bravos and Sierra Club's witnesses.
And what is the basis of these objections?
The major objection is that the definitions that are not used in the proposed regulations are unnecessary, confusing, or circular and should be deleted.
And what is the department's response to those objections?
In my testimony, I specifically responded only to the assertions made regarding the inclusion of definitions not used in the proposed regulations. The basis of the objections is that just because other types of documents and legislation are drafted in a certain manner, that we should always move forward with those exact methods, regardless of the situation. I do not believe that the argument that we've always done it this way is in any way the right way to innovate and move forward. The inclusion of definitions for the purpose of implementation of the regulations is a consideration that I think deserves attention. I have been in the weeds trying to make these types of regulations work, and I've often found that there to be impossible situations that could easily have been fixed by being able to point to a specific definition. I will also note that those who objected to the inclusion of these definitions have not spent any meaningful time implementing the laws and regulations they have worked on, and their perspective on the implementation reflect that experience.
The third topic you identified is the definitions related to domestic wastewater and feasibility studies. What definitions does your direct testimony address? And can you provide a brief summary of your testimony?
Yes, this portion of my testimony focuses on 7 definitions that are related to direct and indirect potable reuse, domestic wastewater, and feasibility studies. The definitions all are proposed as new definitions and will assist the department in implementation of the potable reuse section of the proposed regulations. My testimony includes reasoning and evidence for the following terms: direct potable application, domestic wastewater, environmental buffer, feasibility study, indirect potable application, potable, and reclaimed wastewater.
Did any party object to this section?
Yes, multiple parties objected to most of the definitions in this category of terms, including New Energy Economy, Amigos Bravos, and Sierra Club.
And do we want to?
We do, if you just reach a good stopping.
Yeah, that's as good as any.
Alrighty, thank you very much. If you would please then step away from the table. We're going to take just a very short 7-minute break. We're going to come back at noon for approximately a half hour of public comment. We will then take a lunch hour. It's just today we noticed a public comment at noon to make sure that it was outside of normal working hours. And on subsequent days, public comment around the noon hour will be taken at 1. But today we need to take a late lunch hour. So let's just take a real quick break. We'll come back and we have about a dozen public commenters. Ms. Taylor. Well, approximately, sure. All right. Any other questions? All right. Back here at noon. Let's come back from the break, please. Ooh. Pitchy. All right. We are taking a break in the technical case in order to accept public comment. This is one of many times this week that we will be inviting non-technical public comment. This is the first. There will be at least 9 more. Another one is at 5 p.m. and then we're at 1 p.m. and 5 p.m. every other day this week that the hearing is going on. So just a couple of things. One, comment is limited to 3 minutes. To the extent you have more to say than can be said in 3 minutes, please submit your comment in writing before we adjourn the hearing, which again, I hope will be later this week. You certainly have a couple of days. Please collect your thoughts. I will call on you only once because we have so much public comment to be given. And I know we had a question about making comments in Spanish. For some of the rulemakings, we have simultaneous interpreters, but a request has to have been made before today, and no request was made. However, if you have a comment to offer and would like to offer it in Spanish, please submit that comment in writing to Madai Corral or Pam Jones, again, sometime before we adjourn. The department does have someone who will translate it, a certified translator who will translate it. It will be part of the record and the commission will be able to read that before they deliberate. Okay, just for this rulemaking, it's going to have to come in writing. All right, we have about a dozen folks who requested an opportunity to speak today. I do have a timer here, and I will ask you to honor the 3-minute limit, and I'll have to interrupt you if you approach that. And the other thing is, I will ask you, I have to swear you in, and I have to ask you to spell your name for the transcript. So let's go. We're first with Penelope Maines, and I want to pronounce people's names correctly. Please correct me if I have not done that. Do we have Ms. Maines?
Yes, yes, I'm here.
All right. Do you swear or affirm to tell the truth?
I do.
Thank you. And would you spell your names first and last?
Penelope. Last name Mainz.
Thank you very much. I'm starting the 3 minutes.
Okay, thank you, Water Quality Control Commission. I've been a resident of New Mexico 42 years. Consideration of the draft water reuse number WQCC 23-84 reminds me of 1960 when Dr. Francis Oldham Kelsey, a new employee at our FDA, was asked to consider the approval of thalidomide for sales in the United States. Thalidomide was then widely sold in other countries for insomnia and nausea, and often to pregnant women. Believing there was insufficient evidence that thalidomide was safe for the U.S. public, Dr. Kelsey refused to approve it for use here, despite constant pressure from the company in Cincinnati, Ohio, that went into profit, and despite the fact that the drug was popular in Europe. Eventually, Germany and Australia connected the dots between thalidomide use and severe birth defects, and it was clear that Dr. Kelsey had prevented horrific tragedies in the United States. You know where I'm going with this. We don't know what toxicity and radiation could linger in produced water, even if we think we've discovered how to clean it. And we don't know what accidental spills there could occur in experimentation that would affect the population. According to the Texas Produced Water Consortium, there could be residual constituents in the produced water, even after treatment, whose impacts on an intended use may not be fully known at this stage. In Wyoming, it has been reported that several sections of streams where produced water is discharged are polluted to the point they no longer support aquatic life. That is from the TexasTribune.org, April 29th of this year. With a nod to Dr. Kelsey, I urge the Commission to approve a very different rule. That would be that no person shall discharge, dispose of, or reuse treated or untreated produced water off of the oil field. The Department shall deny certification of any federal permit proposing to discharge, dispose of, or reuse treated or untreated produced water off the oil field. Let's remember Dr. Kelsey and her brave example. Let's put the health of our citizens before anything else, including financial or political gain. Thank you.
Thank you very much, Ms. Maines. Next is Mick Nickel. Up here?
I think that's
Please.
Michael.
Do you swear or affirm to tell the truth? Thank you. And if
I
you
do.
would state and spell your name.
Michael, Michael.
No, sir.
Swearingen.
No,
Yes?
sir. We have a Mick Nickel in the room. I didn't call on you yet.
Oh, okay. My bad.
Please go ahead, Mr. Nickel.
by the governor.
Mr. Nickel, please wrap up. Thank you, Mr. Nickel. Anna Rondon. Do we have Ms. Rondon on the platform? No? If she joins us again, I'm happy to take her comment. Annie Mattingly. Annie, oh, okay.
Hello. I do. Annie, Annie, and then Mattingly, M like in Mary, Attingley. All right. I'm a little nervous. I've never spoken Roundhouse before. Thank you, first of all, for protecting our water. It's a wonderful task that you have, and I appreciate it. I think that this bill, as I understand it, undermines that role. It does not protect the water because we don't know yet enough about these, how to remove and detoxify the carcinogens and toxic chemicals and radioactivity that's in the water, in the produced water. This bill proposes to reuse this without making the water safe. And I don't understand that. I'm no expert, like the man who just spoke, but I do not understand that. My analogy is that if you're building a home, you have to start with the foundation and then the framework before you put up the roof and the walls. And I think this is working backwards, that we're trying to put the water out before we've put the foundation down, because the foundation is to determine if we can clean this water up enough so that it will not damage any of the water or land or people who are in this state. So I propose that the next thing that needs to happen is to, you can see I'm nervous. I don't usually use notes when I speak. Is it to create that framework, is to set the standards for treating. First, we have to find out if it can be treated. Then we have to find out, determine the standards, and then to monitor the treatment. That's your role, to keep us all safe. And I hope that you can do that. This is a sacred trust to protect our water, and it's been given to you. And I hope that you can honor that by not accepting this bill as it is stated now. Thank you.
Thank you, Ms. Mattingly. Lori Costello. Lori Costello? No? Ms. Costello on the platform?
Yeah, I'm online. Can you hear me?
Yes. Do you swear or affirm to tell the truth?
I do.
Right. If you would spell both of your names for the transcripts.
Lori, Lauri, Costello, Costtello.
Thank you. I'll start your 3 minutes now.
Thank you. Hello, my name is Lori Costello. I'm a physician living in Las Cruces. Please regulate the use of produced water outside oil and gas operations and also remove demonstration and industrial uses from the legislation. In medicine, we appreciate the precautionary principle which requires that public exposure to anything, including procedures, chemicals, and medications, demands prior proof of safety. The principle does not apply to our food or water supply or to our household products. Many for-profit corporations use the same playbook perfected by the tobacco industry. Deny the known harms, market the dangerous but profitable substance, and pay fines when necessary, since they represent only a tiny portion of already realized profits. From the beginning, wastewater has been an issue that has been ignored by the oil and gas industry, given inadequate enforcement of weak regulations. They deny the toxic chemicals in fracking fluid, even when researchers reveal them. The sheer volume of wastewater, with hundreds of known toxins, should be prohibitive. New Mexico continues to be a sacrifice zone for the fossil fuel boom that saw the Permian Basin in 2022 named the highest producing oil field on the planet, the same planet that is being destroyed by our use of fossil fuels. The PFAS chemicals that are already in most Americans' bloodstreams are endocrine disruptors that are present in fracking fluid. Since the EPA is not requiring testing and cleanup of our public water supply until 2025, fracking will continue to reap huge profits while poisoning us and the planet that used to sustain us. Please use this opportunity to prohibit further discharge of produced water, whether it is treated or not, to our surface or groundwater. Industry is also requesting a green light for demonstration and industrial uses of produced water. This is a political stunt. These uses are speculative at best and have no evidence of safety. Please redline them. Also, please strike unnecessary definitions that are not addressed in the rule. Another political stunt designed to confuse the public. The vast quantities of precious water, fresh or reused, necessary for oil and gas operations guarantees a worsening of the wastewater problem, which is already irreversible due to its sheer volume. Please prioritize the health of living beings, which are 70% water, and the health of the planet, which is also 70% water. Please protect us from the oil and gas industry's dirty, deadly secret. It's no secret at all. Thank you.
Thank you, Ms. Costello. Elaine Semino. Elaine Semino? All right, if she rejoins us.
Yes, hello.
Oh, yes, hello.
Yeah, I'm online.
All
Thank
right,
you.
thank you. Do you swear or affirm to tell the truth?
Yes, I do.
And if you would please spell your first and last name for the transcripts.
ELAINE CIMINO. I'm the
Thank you. I'll
director of
start your
Common
3
Ground Rising, a
minutes.
resident of Rio Rancho.
Okay, thank you. I'll start your 3 minutes now.
I stand before you today to strongly oppose the fracking waste reuse rule. The proposal relies on a flawed model that has already proven disastrous. For example, a desalination demonstration project in 2007 revealed known highly contaminated raw brine. The project's waste had significant consequences, such as dumping 300 tons of TENORM radioactive waste at the municipal landfill, followed by fluid waste being dumped into the Rio Rancho wastewater system, likely ending up in the Rio Grande. The impact on our environment is invisible even from space, with the caustic water irrigated pivot and agricultural damage to the surrounding soil that can be seen years later. Toxic fluids from radioactive caustic wells were sprayed around the roads for dust control, exposing the public to hazardous contaminants like T-norm, radium, arsenic, and others. With approvals from NMED, this project was under a corrective action order due to its toxicity and spillage. We were denied by NMED a hearing before this board on the toxic dumping. It now appears the reason why was there was undisclosed plans to create a hazardous waste loophole. And the current proposal is a ticking time bomb, allowing for more dangerous demo projects, shifting the burden of expense of protective legal action from the health and economic harms onto communities. Instances of waste dumping on both on and off the oil field are ongoing, unchecked, including the spread of radioactive waste. We refuse to be the sacrifice for the profits of the industry. We cannot continue to rely on the industry's self-reporting or leave decisions solely to the discretion of the NMED secretary. Stronger rules are needed to protect public health and the environment, and I urge the Commission to reject this proposal and prioritize community well-being over corporate interests. Thank you very much.
Thank you, Ms. Semino. Maria McCullough. Do you swear or affirm to tell the truth?
I do.
Thank you. And if you would spell your first and last name.
Maria, Maria, McCullough, McCullough.
Thank you. I'll start your 3 minutes now.
Thank you. Good afternoon. I'm here representing community members affiliated with Albuquerque Showing Up for Racial Justice, some of who are present in this room and online. I would like to affirm the importance of more public awareness about proposals that impact our water safety. I'm here to share a petition that we wrote after we learned about this proposal from an Indigenous-led partner org 1 week ago. After just a few days of circulating this petition, we've received over 50 signatures and continue to receive more, and we will submit our petition later this week. I'll read excerpts from the petition now. We add our voices in opposition to the NMED's proposed wastewater reuse rule 23-84. Repackaging toxic oil and gas waste as usable water is neither aligned with community nor environmental sustainability, as highlighted by the New Mexico No False Solutions Coalition and the Defend NM Water Campaign. We are invested in the well-being of the waters and lands we inhabit, in environmental justice and the solutions for addressing climate change. This does not include the release of wastewater that does not meet scientific-based standards for the treatment and handling of toxic and radioactive substances. Directing fracked water towards fossil-fueled hydrogen industry or other big industry efforts is sure to yield similar contamination of local communities that we have already seen with the fossil fuel industry. The fact that 38,741 instances of oil and gas spills and 616 instances of produced water spills took place in 2022 alone in the Permian demonstrates that safety is not a priority for these industries or our state's politicians. The transportation and waste disposal of fracked water will pose a huge risk to the waterways, land, aquifers, and human health of communities across New Mexico. Research by groups including the New Mexico Produced Water Research Consortium demonstrate that scientific standards and safety standards have not been created for the kind of project Governor Lujan Grisham and the NMED wish to force onto our communities. Directing $500 million towards alleged cleanup of toxic waste encourages extracting industries to continue and expand their operations. We call on the Water Quality Control Commission to follow the protections that will keep our communities' water, land, and environment safe and healthy for years to come. We call on the WQCC to oppose giving the green light for industry to poison the land through Rule 2384.
Ms. McCullough,
Thank you.
thank you very much. Sharon Argenbright. Do you swear or affirm to tell the truth?
I do.
Thank you. And if you would spell your names for the transcript.
Sharon Argenbright. Sharon, Sharon, Argenbright, Argenbright.
Thank you. I'll start your 3 minutes now.
Hello, Commission Quality Board Commissioners. My name is Sharon Argenbright. I've been a nurse for over 45 years, master's prepared in science. I taught nursing in New Mexico for 20 years to try to alleviate the nursing shortage. I've been a retired Air Force nurse, a mother, a grandmother. The nurse's job is to watch, to make assessments. Can you please make an assessment before you do this? The nurse comes up with plans, initiates the plans, and then evaluates. Can you please evaluate what you're thinking about doing? I have been paying attention. I first became aware of environmental pollution when I was 6 years old. The sky was burnt umber in color, and the stench caused watering of eyes and nasal passages. The air so malodorous, us kids driving in the car over the twin bridges of Perth Amboy, New Jersey, had to cover our mouth and hold our noses until we passed. I remember of the oceans clouding, beach trashed with plastics watching up. I left Jersey in the 70s. I moved to LA, where I lived for 6 years before it became intolerant due to the air pollution and the suffocating air. In the military, my friend went to Iraq, and it was not long before she developed lung disease and came home to be diagnosed and died from burn pit exposure lung cancer. Of course, the etiology of all these environmental poisonings are not the same, but the impact is. I have seen enough to believe. I'm aware of the ash pit cancers and ruined lives. I'm aware of the Superfund cleanup sites. I'm aware of the Love Canals. I have seen the green cloud of methane over Farmington by satellite. I am aware of the Permian Basin catastrophe, which should be closed up, sealed, encapsulated, guarded, and cease to produce anything. The good news is this: the actual coming back up the wrong road can and does happen. I've witnessed firsthand the skies of Perth Amboy return to crystal blue, clear and fresh, and the ocean waters clearing up on the Jersey Shore. Cleanup of the oil and gas waste can happen. It will happen once oil and gas takes responsibility. Please do instead apply for federal monies for Superfund cleanup. We choose to close and seal up for perpetuity the oil and gas effluent. If and when the science leads us to it is safe, I will feel comfortable. No, I vote no to making the problem worse, no to produce water, choose life sustaining instead. Thank you very much.
Thank you, Ms. Argenbright. Destiny Ray. Do you swear or affirm to tell the truth?
Yes.
Would you spell your names for the transcript?
Destiny, Destiny, Ray, Ray. Yeah.
Thank you. I'll start your 3 minutes.
Good afternoon, esteemed chair and commissioners. My name is Destiny Ray, and I'm honored to stand before you today as a representative of YUCCO, which is Youth United for Climate Crisis Action, and as the co-chair and co-founder of Rise Youth Collective, which is resilient, inclusive, sustainable, and empowered youth. My laptop just died. Yes. Okay. As a 21-year-old New Mexico native with roots in Jemez Pueblo and the Diné Nation, as well as an African-American heritage, the protection of our water, our lands, our communities, and our health is deeply personal to me, and this rule is a threat to all of it. Today, we find ourselves at a critical juncture. A decision looms before us that will echo through the halls of history, shaping the destiny of our beloved New Mexico for generations to come. The proposed rule by the Environment Department, veiled in the disguise of industry autonomy, poses a grave threat to our very essence, our identity as stewards of this land. Let us not be swayed by the honeyed words of self-regulation and corporate oversight. Allowing industries to set their own safety guidelines for handling of toxic and radioactive wastewater is akin to handing the keys of our future to those whose interests lie solely in profit, regardless of the cost of our real well-being. Considering the staggering reality, over 1,400 oil and gas liquid spills annually with no repercussions from agencies entrusted with safeguarding our environment. Each spill leaves a scar on our land, a stain on our conscience, and a threat to our health. Yet in the face of this grim truth, we are being asked to entertain the notion of expanding the handling, transportation, and disposal of produced water without stringent safety standards and rigorous enforcement measures in place. We cannot afford to turn a blind eye to the dangers lurking within fracking waste. PFAS, bromide, arsenic, mercury, radioactive isotopes. These are not merely chemicals. They are agents of destruction, catalysts for catastrophe. With only a fraction of these substances adequately studied for their human health impacts, we are playing a dangerous game of chance with our lives, our children's future, and the legacy we leave for generations yet unborn. As a young adult living in 2024, I am profoundly disheartened by the continual disregard for our future. I am weary of witnessing our planet, its inhabitants, and our collective well-being being sacrificed on the altar of profit. The burden we carry is not just from our own actions, but the consequences of past generations' short-sightedness. It is emotionally draining to constantly rectify messes we did not create and certainly do not deserve. But we will not wallow in despair. No, we are here to raise our voices in unison and demand accountability, to reclaim our right to clean and a healthy environment. As young people, as guardians of tomorrow, we refuse to stand idly by as our land is desecrated, our water is contaminated, and our future is endangered. We demand nothing less than a full prohibition on reusing produced water outside of the oil and gas operations and off of the oil field. Our state is not a laboratory for reckless experiment with radioactive toxic waste. Despite what industries think, we are not to be sacrificed.
Ms. Ray.
We demand action and we demand justice, and we will not relent until our voices are heard and our demands are met. Please refuse the water reuse rule. Thank you.
Thank you. And Ms. Ray, would you please email that comment to our administrator so she can get it to the court reporter? Thank you. Evelyn Bemis. Evelyn Bemis, are you online? You're there. Do you swear or affirm to tell the truth? Spell your name for the transcript.
EVALYNBEMIS.
Thank you. I'll start your 3 minutes.
Why are we here today? The obvious answer is to solve the fracking industry's problem with wastewater by commodifying it so it becomes a profit center rather than a liability. Step back from there to see the root of the problem. Towards the end of the 1990s, the world was expected to hit peak oil and needed to transition towards renewable energy. Instead, fracking technology was developed to release previously unavailable oil and gas reserves from deep underground. This method utilizes vast amounts of potable water. Suddenly, every barrel of oil or gas produced resulted in 4 to 10 barrels of poisoned water. In 2022 alone, oil and gas turned 28 billion gallons of fresh water into 86 billion gallons of toxic brew, of which the chemical and radioactive composition isn't known due to industry's claim of trade secrets protections. We don't have endless supplies of water to waste in this fashion. We don't want to solve the industry's problem by commodifying their waste and using it for agriculture or non-industrial purposes. And we don't want it anywhere near our aquifers, our wildlife, and our children. Nowhere do you see the slogan, "Oil is life." We may like the ease of putting cheap fuel in our gas tanks, heating our homes, utilizing all the plastic products made from oil. But what we really like and need is clean water to drink and bathe in, to grow food, and to nurture a healthy environment. We can live without oil and gas and must transition to renewables much more rapidly. Don't let oil and gas off the hook by allowing their poison fluids to be used outside of their own industry. Stop permitting water wells to be drained for fracking. Please stop fracking. Thank you.
Thank you, Ms. Bemis. Jennifer Grassham? Jennifer Grassham? Okay, we'll come back
I'm
to
here.
you. Oh, you are here. All right.
Yes,
Do you swear or affirm to tell the truth?
I do.
Please spell your name for the transcript.
JENNIFERGRASSHAM.
All right, I'm starting your 3 minutes.
I'm Jennifer Grassham, and I'm with the Economic Development Corporation of Lee County. The Economic Development Corporation of Lee County appreciates the opportunity to comment on the proposed new Rule 20.6.8 petition by the New Mexico Environment Department. Water is a precious and limited resource within our state. We are greatly aware of the need to conserve our fresh water resources. However, water is a critical resource in growing both our communities and economic viability. Our area has a surplus of non-potable and treated produced water that we could use for this purpose. The March 20th amended petition and rule will greatly hinder the economic growth and opportunities within our region and within the state. Limiting or banning the use of treated produced water limits the ability to use a byproduct of significant industry in our area for the benefit of our residents. This water can be used for many non-potable opportunities that currently depend on freshwater resources. Banning the use of these types of water forces arid communities to use precious freshwater for non-consumptive actions such as construction, road maintenance, industrial uses, instead of treated produced water, which is abundant. By switching to appropriately cleaned reuse water for non-potable uses, we conserve freshwater resources for higher needs. Several communities within the state are currently hindered by limited freshwater resources, which stunts growth in population and diversifying economies. Productive regional growth will be greatly hindered by this proposed rulemaking. Industry is rapidly growing in our area, and with this rapid growth, we have an abundance of produced water, which is currently an untapped economic resource. At the Economic Development Corporation of Lee County, we are planning for industrial and commercial growth in our area with land, governmental, and economic resources. Utilization of treated water should be one of the resources available to use. It is a key element in bringing growth through water treatment facilities, non-consumable agricultural projects, use of minerals and metals derived from the produced water, and employing the water in manufacturing and industrial uses. These economic opportunities will continue to go to Texas if we cannot offer the possibility of capturing this wealth in our state. If we do not allow reuse applications, then the communities who are wanting to engage in these ventures are forsaken of their own authority, and autonomy in policy decisions. Thank you.
Thank you very much, Ms. Grassham. Nodiah Brent. Nodiah Brent. We will come back. Then we have time for one more public comment during this comment session. I didn't have anyone else on the list who reached out to Pam to say they needed to go at this time, except now Mr. So, if you would please. There are 9 more opportunities. The next opportunity is 5 p.m., but a lot of us in the room have been here for more than 4 hours and we need a lunch break. Mr. So, do you swear or affirm to tell the truth?
Yes.
Thank you. If you would spell your name for the transcript.
DANIEL.
Thank you.
TSO. Got a Madam Hearing Officer and the panel that's seated before me. Let me, whoop, too close. Let me speak to the way the rules are currently written. What I see in my comparative analysis is what occurred with the uranium mining. Those piles fenced off when they're dry, when the wind blows, contaminates the land off the site. And how did the community members of Red Pond find out that it was affecting them? They went to butcher a sheep. All the fat and the meat was off color. So they enlisted researchers. Now we look at San Juan Generating Station. We look at Four Corners Power Plant. Something that is very light, coal ash. When it gets wet, they had to build dams. Coal ash ponds are very radioactive, and they're not good for the health and safety of those folks that live around it. So here we're looking at a small experiment that occurred in Alamogordo. But in the rules, you're saying industrial and commercial sites. That little experiment, how do you project 2,000, 3,000 times what occurred here? But this was in a controlled environment. But out there, it's uncontrolled. Sure, you can say this water, when it's put on the ground, it'll make the grass grow. Navajo people were treated as ignorant by Canales when they first approached Ojo Encino chapter. Hey, we're going to put water on that, and we're going to have you be able to grow alfalfa. For every cutting of alfalfa, 12 inches of water. But at the other end of the result is we have researchers at the university, 17 major universities in the Western United States that are basically testing contamination uptake by the plants that are out there. And it's occurring. And if it happens in the Ojo Encino area, you know where it's going to end up? In the digestive system and the system of the sheep and cattle that people really depend on. So in that aspect, the political science of this is that what you're trying to replicate in the control atmosphere environment, when it gets out there, it's no longer controlled. You don't apply enough to keep the soil wet, that thing's going to blow across and maybe even end up in Santa Fe. If you keep it too wet, then you have something similar to the ash ponds. Up at Nappy, we have a New Mexico State experiment station. Water from the San Juan River is used to irrigate all the fields up there. And that soil structure is so porous that it leaks out into the washes that go into Upper Fruitland. And
Mr. Sun, will you wrap up, please?
so in that aspect, the water testing, it has high amounts of arsenic. Now you tell me if that's going to be safe. The projects that you're selecting, you haven't even gone out to look at those sites. So I say we need a complete change in the way that you're selecting projects, a complete change in the rules that you're wanting to apply. The reason I came up is because during the hearings for the Oil and Gas Act, those of us that were plaintiffs on the constitutional lawsuit were prohibited from participating in the drafting. And so all the hearings we objected. That objection we can replicate in this particular aspect. So that's not a threat. It's just something that's going to happen all the way to the governor's office. Thank you.
Thank you, Mr. So. All right, we will adjourn for lunch at this time. We are in downtown Santa Fe, so I know there are restaurants nearby, but let's take an hour, come back at 1:45. Let's come back from the break, please. Go ahead. All right. When we broke for lunch, we had just completed our first public comment session, and immediately prior to that had broken into the middle of Mr. Herman's testimony. So Mr. Herman, you have 15 minutes gone of your hour, and if you would please resume. Mr. Knight.
Thank you. Madam Hearing Officer, Mr. Chair, and members of the commission, when we left off, we were talking about definitions in the proposed rule. So, Mr. Herman, the third topic you identified is the definitions related to domestic wastewater and feasibility studies. What definitions does your direct testimony address, and can you provide a brief summary of your testimony?
Sure. This portion of my testimony focused on 7 definitions that related to direct and indirect potable reuse, domestic wastewater, and feasibility studies. The definitions all are proposed as new definitions and will assist the department in implementation of the potable reuse section of the proposed regulations. My testimony includes reasoning and evidence for the following terms: direct potable application, domestic wastewater, environmental buffer, feasibility study, indirect potable application, potable, and reclaimed wastewater.
Did any party object to this section?
Yes, multiple parties objected to most of the definitions in this category of terms, including New Energy Economy and Amigos Bravos and Sierra Club.
And again, as you understand it, what is the basis of these objections?
My understanding is that most of the objections stated that there was confusion between the intent of the proposed regulations, produced water, and potable applications. Some objections suggested that a single type of potable application was more appropriate and the definition for environmental buffer was not necessary. One objection included the same argument that some terms are either not used in the regulations or are only used in other definitions.
And what is the department's response to these objections?
The department believes that the proposed regulations are written in a clear and concise manner that does not conflate produced water and potable applications. The 2 types of activities are clearly separated into 2 different sections of the proposed regulations. Further, the department believes that the definitions as proposed for environmental buffers different potable applications and feasibility studies are appropriate and necessary to allow communities in the state to advance their potable reuse projects. The department has the same response to the objections regarding the definitions used in the regulations and their intended use for implementation.
The fourth topic you identified is the direct and indirect potable applications section of the proposed regulation. Can you provide a brief summary of your testimony in that section?
Yes, this portion of my testimony focused on feasibility studies and the importance of delineating the differences between the direct and indirect potable reuse projects. The inclusion of an environmental buffer in a project is the most prominent differential between the 2 types of potable reuse scenarios, and having definitions for each aspect of these types of projects is critical when evaluating their feasibility as would be determined by the feasibility studies identified in this section.
Did any party object to this section?
Yes, New Energy Economy, Amigos Bravos, and Sierra Club objected to portions of this section.
What is the basis of those objections?
The objections again conflated the potable water and the produced water sections, thinking that the department was proposing to allow for produced water to be used in potable water applications. Some of the parties object to the inclusion of the potable reuse sections in its entirety. Specifically, New Energy Economy testified that the department failed to include a requirement for economic feasibility studies related to produced water, and Amigos Bravos and Sierra Club proposed to remove the differentiation between direct and indirect potable applications and complete removal of the definition for environmental buffer.
What is the department's response to those objections?
The department again believes that the proposed regulations are very clear, that they are different sections for different reuse types, and that potable applications are a different type of reuse type than the produced water one. The confusion and consternation about direct and indirect potable applications, as well as environmental buffers, are not supported by the evidence submitted by the department. As I stated in my rebuttal testimony, regulations often include multiple sections in each chapter that address different aspects of an overall activity type. The department contends that the supplemental reuse regulations are the correct regulatory location for the potable reuse section, and that it is appropriate to delineate between direct and indirect potable applications, which can mostly be done by determining if an environmental buffer is included in the project. The department also does not believe that requiring economic feasibility studies is within the purview of the Water Quality Act and would not be categorized as something that would protect ground or surface waters.
The fifth topic you identified is the produced water reuse section of the proposed regulation. Can you provide a brief summary of your testimony for that section?
Sure. The department believes that the proposed regulations, I should be specific. So the department believes that the proposed regulations accomplish two major things in the produced water reuse section. First, we are closing a regulatory loophole that would allow anyone to apply for a groundwater discharge permit and place the department in the position of being required to develop a draft permit under existing regulations, regardless of if the source water is treated produced water. The produced water section includes explicit prohibitions on the discharge of produced water or treated produced water. Second, we are providing a very narrow path for research to be conducted and for industrial projects to move forward in a manner that is safe, and so that produced water is not discharged in a manner that may move directly or indirectly into ground or surface water.
Did any party object to this section?
Yes, multiple parties objected to the produced water reuse section.
Okay, and again, as you understand it, what is the basis of these objections?
The majority of these objections were again based on conflating the potable reuse and produced water reuse sections and did not appear to understand the delineation being made between the two types of reuse. Another objection was the assertion that the department was creating loopholes and giving away the authority to regulate aspects of treated produced water.
And what is the department's response to these objections?
As I stated previously, the department believes that the proposed regulations are clear and concise and do not conflate the two types of reuses, and that the proposed regulations are drafted in a manner that fulfills the requirements of the ground and surface water protection regulations and is protective of human health and the environment.
Did any of these parties propose alternative language?
Yes, some of the parties included red line strike-through versions of the proposed regulations. The revisions suggested by the parties include some minor changes that the department agrees with and which are covered by my colleague's testimony. The only major suggested changes that the department agrees with are the suggested additions to the notice of intent section. Amigos Bravos and Sierra Club suggest that the inclusion of volume and quality into the required submission information for treated produced water notices of intent. These two requirements should have been included originally, and the department supports their inclusion in the proposed regulations.
The sixth topic you identified is the implementation of the proposed regulations. Can you provide a brief summary of your testimony on that subject?
Sure. The department plans on implementing the promulgated regulations immediately upon promulgation by the WQCC. Implementation will include limited changes from the manner in which the department has already been applying the requirements of the Water Quality Act and the Produced Water Act for what we previously called produced water pilot projects.
Okay, did any did any party object to this section?
No.
Okay. The seventh topic you identified is the potential consequences for not adopting the regulations as drafted. Can you provide a brief summary of your testimony on that subject?
Yes, the regulations that are in place now do not have the protections and mechanisms necessary to adequately protect ground and surface waters from discharges of treated produced water. The permitting regulations do not explicitly prohibit treated produced water discharges and do not give the department the power to deny a permit based on the type of water being discharged. It is not a matter of being afraid of an appellate court or the WQCC. It's a matter of implementation of the permitting regulations in a manner that is defensible. The proposed regulations are both protective of ground and surface water as they relate to human health and the environment.
Let's see, did any party object to that portion?
Yes, there was some rebuttal to this part of my testimony.
Okay. And what is the basis of those objections?
The New Energy Economy and New Mexico Oil and Gas Association representatives that objected did not provide specific rebuttal to the fact that we are closing a loophole, with one simply stating that my assertion that a permit would have to be drafted is incorrect, and the other stated that the department should not fear the WQCC or appellate court if we were to draft a permit for produced water that was then appealed.
Understood. And what is the department's response to those objections?
Well, I do not have a response to the testimony that simply stated I was wrong, as I don't understand what their basis was. The testimony that the department should not fear having a permit appealed fails to contemplate the amount of effort, time, and taxpayer money that goes into defending a draft discharge permit. The process takes a huge amount of my section's budget and staff time and takes time away from the objectives like enforcement. It would be extremely bad management to move forward under the belief that somehow it will all work out and an appeal to the WQCC or state court is just the inevitable path for a draft permit.
Can you briefly describe what types of activities would require a discharge permit and therefore would not be eligible to be an industrial project or demonstration project?
Yes, the Groundwater Quality Bureau requires discharge permits for many activities that do not appear to fit the basic definition of being a discharge. The primary example would be impoundments or lagoons. Under the 2026.2 regulations and the proposed supplemental regulations, all impoundments or lined ponds would require a discharge permit, and as drafted, the proposed regulations would not allow a produced water demonstration project or industrial project that includes an impoundment of any kind.
Can you briefly describe what a non-discharging project would be that is not closed loop?
Sure. There are two examples of notices of intent that have been submitted to the department for review that are non-discharging, but are also not considered closed loop. The first is a project that is testing the potential to grow plants using treated produced water in an above ground grow box that is not touching the ground. They will treat produced water through an RO system and use the permeate to water the plants. Any produced water and remaining treated produced water will be combined back together and disposed of in the existing saltwater disposal well. All materials used to grow the plants and the plants themselves are required to be disposed of in an appropriately permitted disposal facility. The other project proposes to grow hemp in impoundments, originally proposed to grow hemp in impoundments, and the department required the applicant to modify their plan to be grown inside of lined above ground containers that are elevated to ensure there is no potential for any kind of produced water to make contact with the ground surface.
Okay. Does that conclude your oral testimony?
Yes, it does.
Okay. Thank you.
Thank you, Mr. Herman.
I would like to call Kathleen Murphy, my next witness. Okay.
Ms. Murphy? Do you swear or affirm to tell the truth?
I do.
Thank you. And if you would spell your name for the transcript.
Kathleen, Kathleen, Murphy, Murphy.
Right. Good. Okay. What is your current position?
I am the Produced Water Project Manager for the Groundwater Quality Bureau with the New Mexico Environment Department.
And how long have you held this position?
I've held this position for 2 years in April 2024.
And what duties are entailed by this position?
As provided in my written direct testimony, my job duties include to serve as an in-house produced water expert for produced water related to groundwater protection, to provide technical review of proposed treatment technologies, demonstration projects, water quality data analysis, and related publications, to prepare written testimony and serve as an expert witness for produced water regulations and permitting actions, to keep current on produced water research, to participate in the New Mexico Produced Water Research Consortium working groups, also known as the consortium, and to interact with entities outside of NMED, including universities, non-governmental organizations, stakeholders, landowners, industry, and various state and federal agencies regarding produced water.
Please summarize your post-high school education.
I have a Bachelor of Science degree in geology from the Ohio State University and a Master of Science degree from the University of Nebraska-Lincoln.
Can you tell us about your work experience relevant to the proceeding before the commission?
I have been employed with the NMED for 2 years, and prior to that, I was employed at the Oil Conservation Division for over 3 years as an advanced petroleum specialist. In that role, I was a hearing examiner for the Oil Conservation Division and wrote hearing orders for saltwater disposal wells, compulsory pooling units, and water floods. Prior to that, I worked at the State Land Office as a GIS analyst on a large right-of-way project. I have worked for the state of New Mexico since 2016. Previous work as a GIS analyst included work for a Native American tribe, a national park, and environmental consultants. The details of my job duties can be found on my CV, which is NMED Exhibit 9.
Have you reviewed the direct technical testimony as filed by the parties in this matter?
Yes.
Did you submit technical testimony in this matter?
My direct technical testimony was filed as NMED Exhibit 4. My rebuttal testimony was filed as NMED Exhibit 178.
Do you have any changes or corrections to that technical testimony?
Yes, there are 4. On page 16, line 14 in my direct testimony, which is Exhibit 4, it should say 504,867,983 MCF. On page 16, line 21, it should say 2,188,623,951 MCF. On page 26, line 14 of my direct testimony, I would like to clarify that the department has processed 7 standard notices of intent from entities wanting to complete research associated with the treatment of produced water. My testimony states 9. And lastly, on page 22, line 14 of my rebuttal testimony, again filed as NMED Exhibit 178, the word "not" should be inserted between the word "may" and "directly." This concludes my corrections.
Okay, do you then adopt that pre-filed written testimony here today with those corrections?
I do.
And what is the nature of your testimony today?
My testimony today summarizes produced water quantity, produced water quality, and the demonstration projects as detailed in my written and rebuttal testimony.
Okay, let's to begin with, let's discuss some of the issues relating to getting accurate data on produced water quantity. What are some of the limitations of this data quality?
As stated in my testimony, there are data quality issues when using the OCD publicly available data, and this is related to the date of download and whether operators are able to edit data for prior years, which does occur. Thus, the produced water data generally may be used for course predictions.
Is there a current example of why getting a better estimate of produced water quantities is important?
As stated in my testimony, Scanlon et al. Predicts a 70 to 80-year feedstock of produced water in the Delaware Basin, whereas the Texas Produced Water Consortium predicts produced water volumes in adjacent Texas counties to start to decrease in 2028. These are applicable studies to New Mexico, but make vastly different predictions regarding future produced water volumes. Having accurate volume data along with the sources is critical to designing non-discharging produced water research. For example, if there is insufficient quantity for offsetting a particular end goal, entities should know this to determine viability of the research efforts or make informed decisions to redirect research to more viable endpoints.
Is there another example on a local scale of why accuracy in produced water quantity is needed?
Yes, and as stated in my written testimony, Scanlon et al. Also estimates the available produced water volumes in the Delaware Basin of New Mexico would satisfy between 1 and 12% of the irrigation demands in Eddy and Lee counties respectively. This contrasts with claims that treated produced water is an abundant and viable product for use in irrigation in New Mexico. Knowing the volume and location of produced water that is not able to be recycled in oil and gas operations is vital to understanding what water quality and treatment methods should be researched. The quality of water in unconventional wells or horizontal wells in the Delaware Basin, as mentioned, is significantly different than the wells in the San Juan Basin. A thorough study would give New Mexico a clearer understanding of the available quantity with respect to each of the basins. This is important for determining water quality and thus treatment technologies.
So although accuracy is less than ideal, what information of value was the department able to extract from the available water quality data?
The department was able to determine where the majority of unrecycled produced water is generated, and to some extent, the type of wells that are generating the water.
In your testimony, did you state that there are over 2 billion barrels of produced water generated in New Mexico each year?
Yes, according to the 2022 publicly available OCD data, this volume has doubled from 1 billion barrels since 2018.
And where is most of this produced water located?
As stated in my testimony, in 2022, the Delaware Basin generated over 2 billion barrels of produced water, whereas the San Juan Basin generated 25 million barrels. The Delaware Basin generates 98% of the produced water in the state.
Okay, so the Delaware Basin generates by far the most produced water.
Yes.
Which type of wells are unable to recycle their produced water?
As stated in my testimony, horizontal wells, also known as unconventional wells, are unable to recycle their excess produced water.
Why can't horizontal wells recycle produced water?
Horizontal wells cannot recycle their produced water because they are completed within tight shale and sandstone formations, which are not as porous or permeable as other formations.
Okay, and how many horizontal wells are there currently in New Mexico?
According to OCD publicly available data, there are 8,400 active horizontal wells and 10,600 horizontal wells proposed as new. 95% of these new wells are proposed in the Delaware Basin.
How is this significant to produced water quantity in New Mexico currently and in the future?
Horizontal wells generate excess produced water that cannot currently be recycled within these formations. This results in 98% of produced water being generated in the Delaware Basin. With 10,600 horizontal wells currently proposed in these formations, and 95% of these wells proposed for the Delaware Basin, excess produced water will continue to be an issue in the coming years.
And currently, where does this produced water go?
Most produced water is disposed of through SWDs, also known as saltwater disposal wells, or reused in the hydraulic fracturing and completions within the oil and gas industry.
In your testimony, did you state that in 2022 in the Delaware Basin, approximately half the produced water generated was reinjected through SWDs?
Yes, this is seen on charts from OCD data and submitted in my testimony as NMED Exhibits 119 and 120.
How much produced water was reused by industry in hydraulic fracturing and completions in New Mexico?
As stated in my testimony and according to the 2022 OCD Water Use Report, the oil and gas industry recycled 271 million barrels of produced water in hydraulic fracturing and completions, or 60% of the total water used. Still, this is only 13% of the over 2 billion barrels of produced water generated in 2022. This is seen in a chart submitted as NMED Exhibit 122.
Okay, and why is knowing produced water quantity relevant to the proposed regulation?
Again, most of the produced water that is not recycled is generated in the Delaware Basin. This is significant for raw water characterization and potential treatment options. As discussed in my direct testimony, the variability within and between basins impacts the constituents that could cause harm to human health and the environment.
All right, let's turn our attention to produced water quality. In your professional opinion, what are some of the best New Mexico specific sources of produced water quality data that are available? In other words, the raw data that generally comes from sampling before analysis.
As stated in my testimony, produced water quality data specific to New Mexico is available from the USGS Produced Waters database and the New Mexico Tech GoTech webpage.
Okay, and what can be concluded from the available produced water quality data?
As stated in my testimony, source water characterization is inconclusive at this time. This is because available data are scant and in many cases only provide field data from conventional wells. Although field data are helpful, they do not provide concentrations for constituents that could jeopardize protection of ground and surface waters. Additionally, by having limited data for the unconventional or horizontal wells which employ the hydraulic fracturing, these data sets lack lab analysis for compounds that could be present in fracked produced water, in addition to the naturally occurring constituents that are of concern for protection of human health and the environment.
Before we move on, can you clarify whether the proprietary chemicals used in hydraulic fracturing are the same?
It is generally understood that there are a variety of proprietary blends being used, but until the source water characterization is done for a large enough sample size to compare, the variability in fracking fluid and its interaction with the various formation water remains largely unknown.
Next, let's discuss produced water quality studies, those that have used the raw data to conduct analyses and develop conclusions. What can be concluded from the available produced water quality studies?
As provided in my testimony regarding quantity, horizontal wells in the Delaware Basin are currently the wells the department is most focused on, since the produced water from these wells generates the greatest quantity, which is not recycled in oil and gas operations. Completions of these horizontal wells involve hydraulic fracturing with proprietary chemicals. Without metadata for these studies, the department is unable to draw informed conclusions. Thus, although many of these journal documents are informational, they are not sufficient in and of themselves to provide the basis for public policy decision making.
Okay, what are proprietary chemicals?
As stated in my testimony and provided in Frac Focus's additive webpage, proprietary chemicals are additives used by industry in the hydraulic fracturing and completion process. These compounds are not disclosed to the public as to what their constituents are.
Where does one find information about proprietary chemicals?
The Frac Focus database has information on individual wells that have been hydraulically fractured. This database indicates some operators use more than 10 proprietary chemicals, whereas others report using none.
What lab analyses are proposed to identify these constituents?
As stated in my rebuttal testimony, the consortium has proposed a three-tiered analysis protocol developed by the two risk and toxicology working groups over 2+ years, consisting of well-credentialed scientists from academia, state and federal government, NGOs, and industry. The three-tiered analysis protocol includes lab analysis according to the NPDES Plus list, whole effluent toxicology, also called wet testing, and non-targeted analysis testing.
Where can one find information on this three-tiered analysis protocol from the consortium?
The publication entitled Guidance on Treated and Untreated Produced Water Sampling Procedure, dated May 15, 2023, and written by the consortium, can be found under the reference documents on the consortium's webpage and is filed with the department's rebuttal testimony as Exhibit 199.
To your knowledge, Have any of the 7 demonstration projects you discussed sampled for the full suite of constituents in the consortium's 3-tiered analysis protocol for both raw produced water and treated produced water?
No. As discussed in my rebuttal testimony filed as NMED Exhibit 178, there is one subjective project that was conducted in the San Juan Basin, but the department has not received analytical data using the protocol for any demonstration project in the Delaware Basin. No project has tested both raw and treated produced water according to the consortium's guidelines.
Will the consortium's 3-tiered lab analyses protocol change in the future?
It may or may not. For example, as more lab analysis data sets are submitted to the NMED and made public in the consortium's WaterStar water data portal, data may indicate that some analytes are consistently not identified in produced water, whereas others are consistently identified. The list of analytes may increase or decrease over time based on additional credible scientific data.
What is the WaterStar water data portal?
The WaterStar Water Data Portal is the public GIS database that was designed by the consortium to house produced water, quantity and quality water data from horizontal wells. It is currently active as a web page and has produced water quantity data, but only basic produced water quality field data.
What is the process proposed for the analyses and treatment of produced water?
The produced water and treated produced water must be thoroughly characterized. Raw produced water would be analyzed according to the consortium's guidelines, processed through a treatment train, then analyzed again according to the consortium's guidelines to test the efficacy of the treatment train in removing contaminants.
What are NMED's expectations for data to be considered defensible scientific data?
NMED requires supporting QA/QC of data, which provides quality assurance of sampling methodologies, sampling locations, data acquisition and management, lab analysis methodologies, chain of custodies to show holding times and sample preservation, trip blank analysis to demonstrate quality control for cross-contamination of the samples, and validation and verification of the data. In part, this requires lab analysis at a NELAP certified lab.
On page 4 of Jacoby's rebuttal testimony for NMOGA, he states you oppose the public distribution of information that addresses naturally occurring radioactive material, or NORM. Can you identify where in your testimony you state this?
I did not state this in either my direct testimony or rebuttal testimony. In my position as the produced water project manager, there is an absolute responsibility for scientific evidence to be made public to develop regulations.
Okay, let's move on and discuss demonstration projects. What are demonstration projects?
Demonstration projects, as proposed to be defined in this rule, are non-discharging produced water research projects with the explicit intent to characterize produced water, evaluate the treatment methodologies, and determine attainable effluent quality, to evaluate the potential use of treated produced water outside of the oil and gas industry. These demonstration projects must operate in a manner that is protective of ground and surface water quality, in part by demonstrating that they are closed-loop with no discharges to ground or surface water.
And how does one apply to conduct a demonstration project in New Mexico?
An interested party would submit an NMED notice of intent, which is also called an NOI, to the department.
Okay, is the NOI an application to discharge?
No, the NOI is a separate process to allow the department to determine and ensure the project is not proposing any form of discharge. An application is a separate process, and given this proposed rule explicitly prohibits discharges, any application to discharge would be denied pending adoption of this rule.
Okay, where is the information regarding the NMED NOI process found?
As stated in my testimony, information about the NOI submittal process in current and past demonstration projects can be found on the NMED Public Produced Water webpage under Guidelines and Forms and Produced Water Pilot Projects.
Does the proposed rule prescribe what treatment process a demonstration project should use?
No, the rule only provides the mechanism to get a determination from the department that the project is not discharging and therefore not a threat to ground or surface waters within the department's regulatory authority.
Is there an advantage to conducting a demonstration project?
Yes, a demonstration project could test a technology, see what part of the process works or does not work, reconfigure and adjust as necessary, and provide needed, credible scientific data in the form of lab analysis. An applicant would then have defensible data that the project worked and could scale up. Financial resources could be expended more efficiently.
Why is the NOI process needed in the current proposed rule?
The department has a NOI process in place in 20.6.2 NMAC, but it is limited in scope and enforceability, placing the burden to determine if there is a discharge on the entity, not the department. The proposed rule provides the authority for NMED to determine if a demonstration project is non-discharging and requires additional information needed by the department that extends beyond the requirements in 20.6.2 NMAC to ensure consistency in evaluating and making determinations for industry-specific types of projects. By submitting the produced water NOI as proposed in 20.6.8 NMAC, New Mexico citizens will have access to information concerning all produced water demonstration projects being conducted within the state, as this data is posted on the NMED Produced Water webpage. In this rule, it is mandatory to submit an NOI, whereas in 20.6.2 NMAC, it is not mandatory to submit an NOI for a non-discharging project. As stated already, NMED needs the authority to make a determination as to whether a proposed produced water project is non-discharging.
Currently, does NMED know where all the produced water demonstration projects are occurring in the state?
It is unclear. There may be projects occurring in the state that have not submitted an NOI to NMED, and thus NMED has not had the opportunity to determine if they are non-discharging.
Okay, your rebuttal testimony responding to the consortium NMOGA details the premise that other states are discharging produced or treated produced water without controversy or environmental consequences.
Yes.
What other states were mentioned as currently discharging produced water or treated produced water?
California, Wyoming, Pennsylvania, Colorado, and Arkansas are mentioned by others are mentioned in others' testimony. California, Wyoming, and Pennsylvania are referenced in more detail in my rebuttal testimony.
And is the implication that because other states are discharging produced or treated produced water, so should New Mexico do likewise? Is this a valid assumption?
No, as provided in my direct testimony, produced waters from areas with varying formations and geochemistry, well development, and extraction processes are not comparable as seen in New Mexico, just between the San Juan and Delaware basins. Broad, superficial statements within the context of a declaratory few sentences are disingenuous and do not present the full picture.
Can you quickly summarize key points from your rebuttal testimony for a couple of these states and why discharges in these states are not comparable? And also, importantly, whether there have been implications as a result of these discharges pertaining to protection of human health and the environment.
As summarized in my rebuttal testimony, a quick summary does not do justice to this complicated subject. First, California has indeed allowed the discharge of treated produced water for the past 30 years in one county for irrigation. However, only produced water from non-fracked wells is used as a fractional component of river water. There have been recent investigations by a food safety expert panel based on allegations concerning threats to food safety from using oil field produced water on crops. Second, Wyoming, which also has a long history of discharging produced or treated produced water to ground and surface water, mostly discharges coal bed methane produced water from one basin, which may be similar to the San Juan Basin produced water, but not to Delaware Basin produced water, where all of the unrecycled produced water is generated in New Mexico. Recently, as provided in an article submitted as NMED Exhibit 197, an operator in Wyoming violated their permit conditions, which impacted a community's drinking water sources and what resulted in 2 streams becoming impaired. These streams flow into a reservoir that is a drinking water source for 3,000 people. And lastly, a Duke University study regarding discharges in Pennsylvania indicated that high levels of radioactivity persisted in stream sediment downstream of the discharge point of a centralized waste treatment facility where produced water was treated. The radioactivity measured at these sites was 650 times higher than at unaffected stream sites upstream. The study concluded that the contamination came from conventional or non-fracked oil and gas wastewater.
These examples are not necessarily comparable or applicable to New Mexico produced water.
Correct. They are not necessarily comparable or applicable.
However, what we can say is that these states are discharging produced or treated produced water, and in at least some cases, there were environmental consequences.
Yes.
Given the current state of knowledge regarding produced water, could the department propose reuse regulations similar to these other states that would be protective of ground and surface water?
No. Most of New Mexico water's resources serve rural and underserved communities. The concept of permitting discharges without extensive source water characterization, well-studied treatment methodologies, and protective criteria for applications that ensure protection of ground and surface water is contrary to the Water Quality Act.
Thank you. That concludes this witness's testimony.
Okay, thank you, Ms. Murphy.
Yeah, I'll give it all. Shall we just keep moving?
I think so.
Okay.
It's been less than an hour.
I would like to call Lei Hu, witness.
Dr. Hu, do you swear or affirm to tell the truth?
Yes, I do.
Thank you. And if you would spell your name for the transcript.
Yeah, my name is Lei Hu, L-E-I-H-U.
Thank you.
And Dr. Hu, what is your current position?
I'm the producer water project manager with the New Mexico Environmental Department Surface Water Quality Bureau.
And how long have you held this position?
I have been the producer water project manager for 2 years.
And what duties are entailed by this position?
My job duties as the producer water project manager include serve as an in-house expert for producer water related to surface water protection, provide technical assistance and review of proposed treatment technologies, demonstration projects, and related water quality research, analysis, and reports, prepare written testimony, and serve as an expert witness for producer water permit, and raw hearings using technology and applicable rules, regulations, work with NMED attorneys to prepare and participate in hearings before the NMED Secretary or WQCC by providing oral testimony and sitting for cross-examination by other parties. Serve as agency representative and interact with several entities outside of NMED, including universities, water research institutes, non-government organizations, stakeholders, landowners, industry, and different state and federal agencies regarding producer water and related treatment technologies. Participate in the New Mexico Producer Water Research Consortium and contribute to working group products, and assist with stakeholder outreach related to proposed water reuse regulatory revisions and or new initiatives.
All right. Please summarize your post-high school education.
I have a Bachelor of Science degree in Environmental Engineering from China University of Mining and Technology, a Master of Science degree in Environmental Science from the same university, and a Doctor of Philosophy degree in Environmental Engineering from New Mexico State University.
Do you hold any certifications or have you received any additional professional training relevant to the proceeding before the commission today?
Yes, I attended and received certifications from EPA's Water Quality Standards Academy and the EPA NPDES Permit Writers course.
Can you tell us about your work experience relevant to the proceeding before the commission today?
Before my current position, I served as a postdoctoral researcher at the Georgia Institute of Technology for 8 months, and as a graduate research assistant at New Mexico State University for 4 years. I received my PhD in environmental engineering from New Mexico State University in 2021, focusing my dissertation research on producer water treatment and toxicity assessment. I have served in various capacities over my 7 years career, with work related to producer water treatment, environmental toxicology, resource recovery, environmental chemistry, desalination, project management, and regulatory development. The details of my job duties can be found in my CV, which has been submitted as NMED Exhibit 10.
Okay. Have you authored or co-authored any articles related to your professional training?
Yes, I have 13 publications, some of which related to my testimony, including co-authoring an opinion paper on safe reuse of treated produced water outside oil and gas fields, a review of current practice, challenges, opportunities, and a risk-based pathway for produced water treatment and fit-for-purpose reuse. A research paper on toxicological characterization of produced water from the Permian Basin. A technical report on characterization of produced water in the Permian Basin for potential beneficial use. A research paper on biomineralization of hypersaline produced water using microbially induced acid precipitation. A research paper on treatment of produced water in the Permian Basin for hydraulic fraction, comparison of different calculation processes, and innovative filter media, and a research paper on simultaneous recovery of ammonium, potassium, and magnesium from produced water by situ wet precipitation.
Thank you. Have you reviewed the direct technical testimony as filed by the parties in this matter?
Yes.
And did you submit technical testimony in this matter?
Yes. My direct technical testimony was submitted as NMED Exhibit 5. My rebuttal testimony was submitted as NMED Exhibit 179.
Okay. Do you have any changes or corrections to your written testimony?
No.
Okay. Do you adopt that pre-filed written testimony as your testimony here today?
Yes, I do.
Okay. What is the nature of your testimony today?
My direct written testimony focuses on the produced water characteristics and the treatment technologies, all supported by credible scientific data. I'm testifying on 11 referential definitions that have already been defined in State's Water Quality Act, NMSA 1978, Section 74-6-1. The state's ground and surface water protection regulations 20.6.2 NMAC, and the state's standards for interstate and intrastate surface waters 20.6.4 NMAC. Additionally, my testimony will discuss the current findings of primary scientific research concerning produced water characteristics and treatment technologies.
I would like to shift towards the specifics of the rule as provided in your direct and rebuttal testimony. You mentioned testifying on the 11 referential definitions that have already been defined in other state regulations. Why did the department include certain referential definitions in the proposed rule?
The purpose of including these referential definitions in the proposed rule is to aid in implementation and maintain consistency with other state or federal regulations. This reference, being part of a supplemental rule, serves to clarify that a term is defined in an alternative location with a specified with a specified mean. Given that the industry and or other concerned parties may not be familiar with 20.6.2 nMic and 20.6.4 nMic, these definitions were added as references to enhance clarity and conciseness in the language used.
Let's transition to primary scientific research on the characteristics and treatment technologies of produced water. Dr. Hu, can you provide an overview of the characteristics of produced water based on primary scientific research?
Yes, as provided in my direct written testimony, the constituents found in produced water are diverse and variable, including elements such as oil, grease, suspended solids, dissolved solids, heavy metals, naturally occurring radioactive materials, dissolved gases, microorganisms, and a wide range of other known or unknown compounds. Based on a comprehensive literature review conducted by researchers from the Environmental Defense Fund, a total of 1,198 chemicals have been identified in produced water from onshore oil and gas production sites in Canada, Mexico, or the United States. These include toxic organic and inorganic compounds. The physical and chemical characteristics of produced water from both conventional and unconventional well exhibit significant variability influenced by factors such as geographic location, geological history, the type of hydrocarbon product being produced, and the well age.
Can you briefly differentiate between conventional and unconventional wells?
Conventional wells extract oil and gas from permeable rock formations using natural reservoir pressure, while unconventional wells utilize advanced techniques like hydraulic fracturing to assess resources trapped in low permeability formations such as shear and tight sandstone.
Can you provide an overview of the current research status regarding the characteristics of produced water in the United States with a focus on primary scientific studies?
Yes, to date, the predominant focus of studies pertaining to produced water characterization in the United States has been centered on the Appalachian Basin in Pennsylvania. According to the data from U.S. Energy Information Administration, the Permian Basin, located in southeastern New Mexico and western Texas, stands out as the largest oil producing basin in the United States, contributing to about 43% of U.S. crude oil production and 17% of U.S. natural gas production in June 2022. However, research on produced water characterization in the Permian Basin remains limited, particularly concerning produced water from unconventional wells. The majority of produced water samples from the Permian Basin, as documented in U.S. Geological Survey, National Produced Waters Geochemical Database version 2.3, was conducted before 2002. Specifically, out of 114,943 datasets in the USGS database, only around 3,800 are associated with the Permian Basin. These samples mostly come from conventional wells. However, out of the 3,800 database, only 39 samples collected in 2016 are included in USGS database, providing exceptionally limited information on inorganic water quality measures and metals.
Okay. What are the typical characteristics of produced water in the Permian Basin?
As stated in my direct written testimony, it's clear that produced water is not uniform even within the same basin. Produced water contains a wide range of compositions from simple to highly complex. Therefore, making conclusions about its characteristics based on one of a few studies is insufficient due to its variability.
Could you share a recent study regarding the produced water characteristics in the Permian Basin?
Yes, a research team from New Mexico State University conducted a comprehensive analysis targeting 309 constituents within produced water samples from 5 distinct locations within the Permian Basin. Their findings revealed that the detection of 91 analytes, while 218 analytes remained undetected. Although informative, as discussed in great details in Kathleen Murphy's direct written technical testimony, this sample design limits what can be said about produced water characterizations in the Permian Basin. According to their findings, produced water samples from unconventional wells in the Permian Basin exhibited total dissolved solids concentrations ranging from 100,800 to 201,500 milligrams per liter. A wide range of constituents including mineralized salts, metals, oil and grease, volatile and semi-volatile organic compounds, naturally occurring radioactive materials, ammonia, hydraulic fraction additives, and PFAS were identified at varying concentrations.
Has the produced water been fully characterized?
No, produced water is not fully characterized at present. As discussed in my direct written testimony, in addition to its naturally occurring constituents, produced water may contain chemical additives introduced during drilling operations to address operational challenges and improve oil-water separation. Those additives contains a wide range of substances, including corrosion inhibitors, scale inhibitors, and more. Moreover, hydraulic fraction operations involve the use of chemical additives, some of which are not fully disclosed due to trade secrets. Therefore, it's very important to conduct a non-targeted analysis to discern these unknown chemicals present in produced water.
Have any published scientific studies focused on so-called non-target analysis of produced water?
As of now, only one preliminary study by New Mexico State University and the EPA has been published on non-targeted analysis of produced water. This research focuses on developing the methodology for non-targeted analysis and provides results for a single pre-treated produced water sample from the Permian Basin, New Mexico. However, the findings of this study lack representativeness for regulatory development. It's also underscored the need for non-targeted chemical screening, as the majority of the compounds identified in our study are not found in existing produced water database.
See. Why is it important to fully characterize produced water?
Defining the range and the concentrations of constituents within produced water is critical in determining appropriate and effective treatment technologies for produced water management. Given the varied composition and the concentrations of contaminants in produced water, a wide range of treatment technologies, including multiple unit processes, is necessary to effectively remove contaminants that may not be sufficiently addressed by a single method. The treatment processes selected will depend on the water chemistry of produced water.
And what is the current typical treatment process for produced water?
The typical produced water treatment process for reusing the treated water for fracking includes 3 stages: primary treatment, secondary treatment, and the tertiary treatment.
Okay, what is the primary treatment stage?
The primary treatment stage is related to the removal of oil droplets and suspended solid particles range from 5 to 15 micrometers in size. This stage relies on the principles of gravity or density difference, typically employing large purpose-built tanks. Through this process, denser suspended solids and disposed oil set out or separated out of the water.
Okay, and what is the secondary treatment stage?
The secondary treatment phase is aimed to further reducing particles, dissolved hydrocarbons, scale-forming metabolites, and gases using various gas flotation processes, chemical coagulation, and electron coagulation.
What is the purpose of the tertiary treatment stage?
Tertiary treatment is used to further reduce turbidity and the concentrations of also small droplets of oil and other impurities left from secondary and primary treatment.
Are there advanced treatment and post-treatment technologies available for produced water?
Yes. Advanced treatment refers to desalination processes that significantly reduce the total dissolved solids or produced water. The 2 major categories of advanced treatment are membrane-based and thermal-based technicals. Post-treatment technicals such as ion exchange and advanced oxidation processes are employed after advanced treatment to remove trace constituents like BTEX and ammonia depending on the target water quality requirements of the end users.
Are any waste streams generated during the treatment of produced water?
Yes, liquid and solid waste streams generated during produced water treatment require proper disposal. After desalination processes, the fouling and scaling forming constituents in produced water are further concentrated, and the brine needs appropriate treatment to avoid the clogging of saltwater disposal wells. In the Permian and the San Juan Basin, produced water contains elevated concentrations of naturally occurring radioactive materials. It's important to conduct studies and measurements to assess the radioactive levels of soil waste from chemical precipitates and solids generated from crystallizer. This is essential for the development of a comprehensive solid waste management plan.
In Hightower's direct testimony submitted in this matter, there is an assertion that produced water can be effectively and consistently treated to, quote, a safe level. Does the department concur with this assertion?
No. First, the department would question how Mr. Hightower would define safe. This term should need to be quantified in the regulations to provide clear guidance. Second, as stated in Hightower's, Bart's, Lewis, and my direct written testimony, the technologies to treat produced water are still being researched due to significant variability in characteristics across different regions. According to a detailed produced water treatment report from the New Mexico State University Civil Engineering Department, several mature technologies could be carefully selected to develop a treatment train for produced water, depending on the initial water chemistry of produced water and the required quality of the end product. However, several technical challenges arise due to its high salinity and other concerns in produced water. Treating highly saline produced water, such as the produced water in the Permian Basin, is energy intensive and comes with a high cost. The report concludes that while emergency technologies like ultra high pressure reverse osmosis, membrane distillation, supercritical water desalination, or forward osmosis have the potential to significantly reduce costs. They are still in the development phase and are not yet ready for full-scale implementation. Lastly, there is still a lack of robust data concerning the full and complete characterization of untreated and treated produced water, treatment methodologies, effluent quality, and the management of treatment waste streams. Therefore, before conclusively asserting that produced water can be consistently treated to a safe level, it's important to conduct a more detailed region-specific studies.
Thank you. Are there any additional concerns regarding the assertion that produced water can be treated effectively and consistently to reach a safe level?
Yes, a significant concern highlighted in my direct testimony is the presence of unknown chemicals in produced water. As I mentioned, hydraulic fracturing operations involve the use of chemical additives, and some additives are not fully disclosed due to the trade secrets. The toxicity of these unidentified chemicals cannot currently be determined.
The New Mexico, the Produced Water Consortium's technical data and information report highlights that even after treatment, some constituents in produced water can remain problematic at low concentrations for specific reuse applications. Does the department concur with this statement?
Yes, the department concur with this statement. As discussed in my direct written testimony, while current treatment technologies may reduce the presence of the constituents in the produced water, they are unable to remove all constituents. Currently, there is a significant lack of robust data regarding the characterization of untreated and treated produced water, treatment methodologies, effluent quality, and the measurement of treatment waste streams, including a lack of defensive and reliable data of underpin the development of a mature treatment chain to attain a consistent and protective water quality for discharge of produced water in New Mexico. Certain elements, such as heavy metals, naturally occurring radioactive materials, remain a toxicity even at low concentrations. This statement is in direct contradiction with Mr. McHattle's testimony, which states that the studies show treated produced water is safe, and supports the department proposal to specifically prohibit discharge of treated or untreated produced water, and requiring submittal of an NOI, so the department can determine that no discharge will occur before a project can proceed.
Numerous studies highlight the importance of total dissolved solids, or TDS, in the treatment and reuse of produced water. Is TDS the sole concern in produced water?
No. It's important to note that TDS is just one concern of the complex composition of produced water. As discussed in my direct written testimony, produced water can contain thousands of constituents, some of which can remain toxic even at low concentrations. For example, trace amounts of heavy metals are detectable in produced water from the Permian Basin. Heavy metals are a group of metals and metalloids that have relatively high density and are toxic even at concentrations in the parts per billion or microgram per liter. Unlike organic pollutants, heavy metals are non-biodegradable and bioaccumulate in living organisms through direct exposure as well as through the food chain.
Apart from salts and metals, are there any other concerns that should be taken into consideration?
Yes. In addition to salts and metals, produced water also serves as a reservoir for very high concentrations of naturally occurring radioactive materials, which is one of the major environmental concerns with the recovery of oil and gas from unconventional wells. For instance, investigations conducted by the New Mexico State University indicate that produced water samples from the Permian Basin have mean total radium concentrations of 469.3 picocuries per liter. This is almost 100 times the domestic water supply criterion. In the state standards for interstate and intrastate surface waters 20.6.4 nmic, and over 15 times the livestock watering criterion for total radium. Radium poses significant environmental and health risks, underscoring the importance of appropriate producer water management to prevent adverse impacts. Moreover, other constituents of concern in producer water include BTEX, PES, and PFAS, further complicating its compositions and potential risks. Therefore, further studies are necessary to fully understand its compositions and potential impacts, supporting the intent of the proposed rule.
Is it presently feasible to utilize treated or untreated produced water as a new water source to alleviate the freshwater shortage in New Mexico?
No, as discussed before, producer water is not fully characterized, and using either treated or untreated producer water as a freshwater source jeopardizes the protection of ground and the surface water, as well as human health. Additionally, technologies for treating producer water are still in research phase. In light of this, the department has determined that allowing the discharge of treated or untreated producer water into the environment is premature and cannot currently be done in a way that complies with the Water Quality Act.
Does the proposed rule conflict with Governor Lujan Grisham's 50-year water action plan, specifically regarding the Action B, new water supply, which illustrates that New Mexico must develop new sources of water?
No, the primary objective of this proposed rule is to conserve and protect New Mexico's very limited freshwater resources, as mandated under the Water Quality Act and the governor's 50-year water action plan.
Are there any reuse applications specified in the state's standards for interstate and intrastate surface waters?
No, there are no reuse applications specified in 20.6.4 900 nmic. When discussing the numerical and narrative criteria for applications in 20.6.4 nmic, it's necessary for the department to clarify that these are not applications, but rather designated use. The surface water quality standards in 20.6.4 nmic include designated uses for surface waters of the state, criteria to protect those uses, including general criteria in 20.6.4.13 nmic, and an anti-degradation policy to maintain and protect water quality. Water quality in surface water must meet the most stringent criteria for pollutant in order to protect its designated use.
Why does the proposed rule prohibit the discharge of treated or untreated produced water into the environment as supported by primary scientific research?
As I stated before, there is a significant lack of robust data regarding the characterization of untreated and treated producer water, treatment methodologies, effluent quality, and the management of treatment waste streams. Given the variability and the unknowns, the department has determined that allowing the discharge of treated or untreated produced water into the environment is premature. That cannot currently be done in a way that complies with the Water Quality Act.
Would the authorized produced water demonstration or industrial projects under this proposed rule pose a risk to water quality?
No, as outlined in the proposed rule, authorized produced water demonstration and industry projects will not discharge in a manner that may directly or indirectly affect ground or surface water, thereby posing no risk to water quality. Demonstration and industry projects will only be authorized after showing that there is no potential discharge.
What impact will the proposed rule have on primary scientific research after it becomes effective?
As discussed in my direct written testimony, there is a significant lack of defensive and reliable data to underpin the development of a mature treatment chain to attain a consistent and protective water quality for discharged or produced water in New Mexico. Therefore, the implementation of the department's proposed regulations is essential to support produced water demonstration projects in the state and drive produced water treatment research, which will inform the development and the adoption of standards specific to treated produced water. This rule aims to establish necessary restrictions, promote research efforts, and equip regulatory bodies with essential resources to make sure that no discharge compromise the quality of New Mexico's ground and surface water.
All right, thank you, Dr. Hu, for your testimony. Madam Hearing Officer, we would request a comfort break before our next witness.
Yes, excellent idea. Thank you, Dr. Hu.
Okay.
Let's come back at, let's see, 3:30.
And
12 minutes.
this will be our last witness after this.
Yes. All right, let's come back from the break, please. Mr. Knight.
Madam Hearing Officer, Chair, and members of the Commission, I would like to call my final witness, Susan Antonia Lucas Camat.
Okay.
If she could be sworn.
Yes. Ms. Kamat, do you swear or affirm to tell the truth?
I do.
And if you would spell your name for the transcript.
Susan Antonia Lucas Camat, SUSAN ANTONIA, and my last name is Lucas Camat, 2 words with a space, LUCAS space KAMAT.
And what is your current position?
I am the Point Source Regulation Section Manager with the New Mexico Environment Department Surface Water Quality Bureau.
And how long have you held this position?
I have been the Point Source Manager for 3 years.
And what duties are entailed by this position?
As stated in my resume is NMED Exhibit 11. As the Point Source Program Manager, I manage 4 teams that implement the permit and certification and compliance and enforcement processes for discharges to surface waters in New Mexico. I directly supervise 4 staff and indirectly supervise 6 staff, oversee and review certifications of over 90 National Pollutant Discharge Elimination System, or NPDES, individual permits, and 6 NPDES general permits, and I oversee compliance inspections for NPDES permits and unpermitted discharges. I develop policy, guidelines, templates, and regulations related to point source regulation and compliance.
Please summarize your post-high school education.
I have a Bachelor of Science degree in Earth, Atmospheric, and Planetary Sciences, Geophysics option from the Massachusetts Institute of Technology. I also completed graduate classwork in hydrology, water resources, geochemistry, and statistics at the University of New Mexico Earth and Planetary Sciences Department.
Do you hold any certifications or have you received any additional professional training relevant to the proceeding before the commission today?
Yes, I have received training and obtained various certifications applicable to my position. Specific to the proceeding, I have completed training from the EPA on quality assurance management and MPDS permit writing. I also have certification as a geographic information systems analyst, a project coordinator, and project management information systems specialist from the University of New Mexico. A full list of my training and certifications can be found in my resume, filed as NMED Exhibit 11.
Can you tell us about your work experience relevant to the proceeding today?
My first job in New Mexico was at MIAX Corporation, a capital equipment manufacturer of on-site mixed oxidant generators for a variety of potable and industrial water treatment applications. At MIAX, I performed design review for municipal and industrial projects and prepared project plans and specifications, bid documents, design packages, and submittals for U.S. and international projects. I've been employed with the state of New Mexico since May 2005 and have held my current position with the Surface Water Quality Bureau since April 2021. During my 19 years with the state of New Mexico, I've been employed by both NMED and MNERD. I began my state career as a mining geological specialist in the Mining and Minerals Division, working for 6 years on mine registration, mining reclamation and remediation in uranium, potash, hard rock, and sand and aggregate mines, and managing the Legacy Uranium Mine Inventory Project. I spent 9 years with the NMED Department of Energy Oversight Bureau as an environmental scientist, staff manager, and bureau chief. At DOE Oversight, I performed and oversaw multimedia environmental surveillance monitoring of inorganic, organic, and radionuclide pollutants for groundwater, surface and stormwater, wastewater, soil and sediment, and vegetative media. I was the NMED Risk Management Bureau Chief for 4 months, where I was responsible for the department-wide health and safety program, job hazards analysis, and loss control prevention. I was employed for 1 year by the OCD Environmental Bureau, where I permitted produced water recycling facilities and containments, surface waste management facilities, and pit below-grade tanks. Since November 2021, I've been in the NMED Surface Water Quality Bureau Point Source Regulation section as both the municipal team supervisor and then the program manager. I have over 6 years of direct experience implementing ground and surface water protection regulations as found in 20.6.2 NMAC, and over 4 years of direct experience implementing standards for interstate and intrastate surface water regulations as found in 20.6.4 NMAC. My other work experience can be found in my resume, filed as NMED Exhibit 11.
Have you authored or co-authored any articles relating to your professional training?
Yes, I have 6 publications, which include co-authoring Uranium Resources in the Grants Uranium District, New Mexico, an update published in the New Mexico Geological Society's 64th Field Conference Guidebook, co-authoring Landmines, GIS monitors potentially hazardous abandoned sites, published in GeoWorld, and authoring Mining Review New Mexico, published in Mining Engineering. A full list of my publications can be found in my resume.
Have you reviewed the direct technical testimony as filed by the other parties in this matter?
Yes.
And did you submit technical testimony in this matter?
Yes, my direct technical testimony was filed as NMED Exhibit 6. My rebuttal testimony was filed as NMED Exhibit 180.
Do you have any changes or corrections to that technical testimony?
Yes, there was a typographical error in my rebuttal testimony, NMED Exhibit 180. On page 13, Line 19, the citation 20.6.2, 201 NMAC should be 20.6.2, 2001 NMAC.
And then do you adopt your pre-filed written testimony here today as corrected?
I do.
What is the nature of your testimony today?
My testimony will summarize the reasoning and supporting evidence the department used to draft the proposed regulations, the implications of not adopting the regulations, and how the department envisions the implementation of the proposed regulations.
Can you briefly describe the sections of the proposed rule that you are testifying to today?
Yes, today I will be testifying regarding 4 topics for the proposed regulations as detailed in my written technical testimony, NMED Exhibit 6, and my written rebuttal testimony, NMED Exhibit 180. First, my direct testimony covers the general authority given to constituent agencies of the Water Quality Control Commission that can propose regulations to the Commission. Second, my testimony focuses on multiple definitions that are used in the proposed regulation. Third, I will testify regarding the implementation of the proposed regulation. Lastly, I will testify regarding the potential consequences for not adopting the proposed regulations.
And can you briefly describe the reasoning for these sections?
Yes, my testimony will discuss the authorities granted to the Commission and constituent agencies by the Water Quality Act and the Produced Water Act, and will provide the legislative and regulatory context under which the department drafted the proposed regulations. The definition section as proposed will provide the department with the necessary clarity and support to implement standardized reuse permitting, as well as the proposed regulations specific to surface water discharges. The proposed regulations explicitly prohibit the discharge of treated or untreated produced water outside the oil and gas industry.
The first topic you mentioned is the authority of the department, the authority that we are relying on for the proposed regulations. Can you provide a brief summary of this portion of your direct testimony?
Yes, as previously testified by Mr. Jason Herman, the Water Quality Act was amended by the Produced Water Act in 2019. The Produced Water Act specifically directed the Water Quality Control Commission to adopt regulations to be administered by the Environment Department for many aspects of treated produced water, including the use of treated produced water outside the oil and gas industry. The Water Quality Act already contained the requirements necessary to promulgate regulations for surface and groundwaters, with directions on what the Commission should give weight to and what circumstances are relevant to the rulemaking process.
Did any party object to this section?
Yes, as Mr. Herman testified, Wild Earth Guardians, New Energy Economy, and New Mexico Oil and Gas Association objected to the proposed regulations. The New Mexico Mr. Hightower also objected to the regulations.
And what is the basis of these objections?
As Mr. Herman testified, objections regarding the authority and underlying directives stem from a common misunderstanding of the interactions of other regulations, the proposed regulations, and the existing ground and surface water protection regulations.
What is the department's response to these objections?
Mr. Herman testified to the department's response to these objections by Wild Earth Guardians, New Energy Economy, and the New Mexico Oil and Gas Association. The Commission has promulgated surface water protections under both 20.6.2 NMAC and 20.6.4 NMAC. As I testified in my written rebuttal in NMED Exhibit 180, the authority of the Water Quality Act, Produced Water Act, and Commission is to protect New Mexico's surface waters. States have the authority under their constitutions, supported by federal acts, to promulgate regulations that serve their needs at states. I hope that the state of New Mexico will not voluntarily surrender their sovereign rights to protect their surface waters to any other state, including Texas. The proposed regulations will support the NMED Section 401 certification process for federal NPDES permits as detailed in 20.6.2 NMAC and ensure that New Mexico surface water quality standards, including both narrative and numeric criteria of designated uses of receiving streams, are met for New Mexico's designated uses. As discussed in Ms. Fulham's rebuttal testimony, while the alignment of standards for the reuse of produced water across state boundaries may be efficient for industry, it may not be practical or legally enforceable. The mechanism in the proposed rule are crucial to the protection of human health and the environment under the state's Water Quality Act and 20.6.4 NMAC.
The second topic you identified is the definitions used in the proposed regulation. What definitions does your direct testimony address, and can you provide a brief summary of your testimony?
My direct testimony identifies NPDES related definitions, which include definitions for 1, the National Pollution Discharge Elimination System, NPDES permit, and pretreatment. The department proposes to include these definitions by reference to their controlling federal regulation under the Federal Clean Water Act. These definitions will assist the department in the interpretation of the proposed regulations and maintain consistency with other state or federal regulations. And then 2, new definitions included specifically for implementation of the proposed regulation include NTUs, which is nephelometric turbidity units. This definition will assist the department in the implementation of the proposed regulations.
Right, and just to be clear, that was nephelometric turbidity units.
Yes.
Word of the day. Did any party object to this section?
Yes, multiple parties objected to the inclusion of these definitions, including Amigos Bravos and Sierra Club and New Energy Economy.
And what was the basis of those objections?
The major objection is that the definitions are not used in the proposed regulations and they're unnecessary and should be deleted.
And the department's response to those objections?
Ms. Fulham responded to these objections in her rebuttal testimony. The inclusion of definitions for terms not found elsewhere or found within another definition does not set precedents, as there are several other regulations adopted by the Commission that contain definitions not found elsewhere or found within another definition. Mr. Herman testified in his rebuttal testimony that the inclusion of definitions for the purpose of implementation of the regulations is a consideration that deserves attention. The purpose of a rule is assist in the implementation of a statute. Part of the implementation is being able to explain how a regulation works, and definitions like these proposed definitions assist in that explanation. Definitions also assist with implementation of compliance and enforcement processes. The definitions included for NPDES help explain what an NPDES permit is to the public and regulated community, and that an NPDES permit is not a groundwater discharge permit.
Yeah. Is a discharge permit interchangeable with an NPDES permit?
No, until you have worked in permitting and certification, you don't understand how often the public and the regulated community think that discharge permit, DPs, and NPDES permits are interchangeable permits. The effluent limit criteria and pollutant lists are different for groundwater, 20.6.2 NMAC, and surface water, 20.6.4 NMAC. And the reporting requirements are different between a DP and an NPDES permit. Permits are not interchangeable.
Families are less than 90,000.
Are there facilities that have both a groundwater DP and an NPDES permit?
Yes, several municipalities in the state have an MPDS permit for their treated wastewater treatment plant effluent discharge to a river or a stream, and also have a groundwater discharge permit for reuse of the same treated wastewater treatment plant effluent for uses like irrigation.
So how would someone know what an NPDES permit is?
If there is a definition of MPDS and MPDS permit, the public and regulated community can refer to the definition to learn what an MPDS permit is. The public reading 20.6.8 MMAC will not know what an MPDS permit is if the definition is removed.
The third topic you identified is the implementation of the proposed regulations. Can you provide a brief summary of your written testimony on that subject?
Yes, the department plans on implementing the regulations upon adoption of the regulations by the commission. Implementation will not include any changes to the manner in which the department has already been applying the requirements of the Water Quality Act and Produced Water Quality Act for the Section 401 certifications. Implementation will include the ability to cite 20.6.8A 401 1 and 2 in MAC to prohibit produced water discharges to surface waters.
Did any party object to these amendments?
Yes, New Energy Economy, the New Mexico Oil and Gas Association, and Mr. Hightower objected to the proposed regulations.
And again, from your understanding, what is the basis of these objections?
Much of the testimony filed by New Energy Economy, the New Mexico Oil and Gas Association, and Mr. Hightower made assertions on reuse water quality. The parties presented little evidence or valid examples to support their objections.
And what is the department's response to these objections?
The objective of the proposed rule is to supplement the procedures for certifying federal permits found in 20.6.2, 2001 to 2003 INMAC. All discharges to surface waters in New Mexico must meet surface water quality standards found in both 20.6.2 and 20.6.4 INMAC. As testified by Dr. Hu, treated produced water has unknown effluent water quality. Due to the unknown produced water effluent quality, the department will deny State of New Mexico Clean Water Act 401 certifications for proposed MPDS permits of treated produced water discharges to surface waters to protect the designated uses of the receiving surface waters. The prohibition in this regulation of produced water discharges to surface waters is needed to support the Section 401 certification denial and prevent contaminants from entering New Mexico's surface waters.
What are so-called designated uses?
So designated uses are the goals and expectations for how each water body is used. Designated uses are outlined in 20.6.4 INMAC as domestic water supply, irrigation and irrigation storage, livestock watering, wildlife habitat, primary and secondary contact recreation, aquatic life, which is cold water, cool water, and warm water, fish culture, public water supply, and industrial water supply.
And what are water quality criteria?
As defined in 20.6.4.7 INMAC, water quality criteria are elements of state water quality standards expressed as pollutant or constituent concentrations. Levels are narrative statements, and they represent a quality of water that supports a use. When criteria are met, water quality will protect the designated uses.
How do you select criteria for surface water?
Water quality criteria are not pick and choose, nor are they either or. There has been considerable reference implying that treated produced water discharges should be allowed because water quality meets irrigation standards, which is only one of the designated uses in a surface water. And the department would argue that we do not know if produced water even meets the water quality criteria for irrigation, because as testified by Dr. Hu, treated produced water has unknown water quality. A discharge must meet all criteria for each of the designated uses in the receiving water and must not degrade existing uses.
What is anti-degradation?
Anti-degradation is a regulatory policy and implementation procedure adopted by NMED to protect existing uses of surface waters. All new and expanded discharges in New Mexico must have a completed anti-degradation analysis, taking into account the discharge of toxic pollutants. The results of the anti-degradation analysis may be used to set effluent limit conditions in a Section 401 certification.
Okay, and what is a Section 401 certification?
New Mexico does not have delegation for the federal NPDES program under Section 402 of the Clean Water Act. Therefore, all NPDES permits in New Mexico are issued by EPA. Under Section 401 of the Clean Water Act, EPA may not issue an NPDES permit that may result in a discharge of pollutants into waters of the United States unless a state water quality certification is issued or waived. The department has 4 options when making a Section 401 certification decision for a draft NPDES permit. 1, grant the certification. 2, grant the certification with conditions. 3, deny the certification. Or 4, waive the certification directly or waive by failing or refusing to act within the established reasonable period of time.
What are toxic pollutants?
Toxic pollutants, as defined in 20.6.4.7 T2, means those pollutants or combination of pollutants, including disease-causing agents, that after discharge and upon exposure, ingestion, inhalation, or assimilation into any organism, either directly from the environment or indirectly by ingestion through food chains, will cause death, shorten lifespans, disease, adverse behavioral changes, reproductive or physiological impairment, or physical deformations in such organisms or their offspring.
How do you test for the presence of toxic pollutants?
Whole effluent testing, which I'll call WET from here on out, can be performed to determine if toxic pollutants are discharged in toxic amounts for acute, i.e. mortality, versus chronic, i.e. reproductive exposures. WET tests measure wastewater's effects on a specific organism's ability to survive, grow, and reproduce. A WET test can identify that a discharge is toxic, but does not identify the specific pollutant or combination of pollutants that is toxic. WET testing results are specific to species. Species used in WET tests are marine or freshwater, and many species are sensitive to specific toxics. WET testing is not a one-time test. It can be part of an anti-degradation analysis required for Section 401 certification of a discharge, and a Section 401 certification may condition for continued WET testing at set frequencies. WET testing is used with, not in lieu of, targeted analysis.
Can a person discharge produced water for beneficial use west of the 98th meridian?
Federal regulations at 40 CFR 435, which is NMED Exhibit 202, provide for direct discharge of produced water west of the 98th meridian if there is a beneficial use for agricultural or wildlife propagation in the immediate receiving waters. And if the produced water is actually put to the agricultural or wildlife propagation beneficial use at the point of discharge and time of discharge. Applicants cannot simply state there is a beneficial use. You must use the EPA published beneficial use tool for agriculture and wildlife watering for discharges west of the 98th meridian, which was NMED Exhibit 208. Additionally, Section 404 applies to all discharges west of the 98th meridian.
Now, is that section 401?
Yes, I'm sorry, Section 401.
Okay. What about discharges from a centralized waste treatment plant?
A centralized waste treatment plant is a standalone waste treatment plant and recovery facility that receives materials from off-site. Oil treatment and recovery is one of the 4 centralized waste treatment subcategories. Discharges from centralized waste treatment plants are still subject to Section 401 certification. As detailed in NMED Exhibit 170, the discharge cannot supersede other applicable state, like 20.6.2 and 20.6.4 INMAC, and federal regulations. The EPA report titled EPA Report, Detailed Study of the Centralized Waste Treatment Point Source Category for Facilities Managing Oil and Gas Extraction Waste, details that approved analytical methods do not exist for many constituents found in oil and gas extraction waste. In addition, some constituents, such as total dissolved solids, found in oil and gas extraction waste, can interfere with EPA-approved analytical methods and significantly affect the ability to detect and quantify the level of some analytes. The current effluent limit guidelines at 40 CFR Part 437 do not contain many limitations for many of the pollutants commonly found in oil and gas extraction wastes. Many of these pollutants are not included on the current list of priority pollutants. Documented and potential impacts to both aquatic life and human health related to discharges from centralized waste treatment facilities treating oil and gas extraction wastewater exist due to the prevalence of some pollutants. Levels of pollutants downstream from centralized waste treatment facility discharges have been reported to exceed applicable thresholds, such as primary and secondary drinking water standards and acute and chronic water quality criteria for the protection of aquatic life.
So discharges west of the 98th meridian and from centralized waste treatment facilities are required to have a Section 401 certification?
Yes, discharges west of the 98th meridian and discharges from a centralized waste treatment facility are subject to 401 certification and must meet water quality standards, including all designated uses in the receiving water, numeric and narrative criteria, narrative toxic pollutant criteria, and anti-degradation requirements.
Right. And finally, the 4th topic you identified is the potential consequences of not adopting the proposed regulations as drafted. Can you provide a brief summary of your testimony on that subject?
Yes, the regulations that are in place now do not have the protections and mechanisms necessary to adequately protect ground and surface waters from discharges of treated produced water. The permitting regulations in 20.6.2 and 20.6.4 INMAC do not explicitly prohibit treated produced water discharges to surface or groundwaters, nor do they prevent pollutants from contaminating our water resources. The proposed regulation prohibits the discharge of produced water through the general requirements section of the proposed regulations, found at 20.6.8 400A. The proposed regulations also close an existing loophole in the procedures for 401 certifications of MPDS permits as required in 20.6.2 2001 NMAC, which do not authorize the department to deny a Section 401 certification of a federal NPDES permit on the basis of the source or type of water being discharged. Failure to promulgate the regulations as proposed and with explicit prohibitions was cause surface waters of the state to be at greater risk of contamination.
Thank you very much. That completes our presentation of our oral testimony, and the witnesses would like to come up and sit as a panel for questions from the board, from the
Thank you,
commission.
Mr. Knight.
Sorry.
Yes, thank you. So pursuant to the pre-hearing order, the commissioners will ask their questions first, and then we will turn to the parties in reverse order of presentation. So I'll mix it up, but I'll start with Commissioner Vigil once we have the witnesses arrayed at the witness table. And you can always change your mind.
Did we decide?
Mr. Knight, were you going to offer your exhibits as well? Okay.
Yeah, if there's, we would request at this time, if there's no objection, that our NMED exhibits 1 through 208 be admitted into the record now that the witnesses have testified.
All right, I'm going to pause for an objection rather than calling on all 9 parties. I don't hear an objection. So exhibits 1 through 108 are admitted.
Sorry, that's 1 through 208.
Excuse me, 208. All right. So just to remind folks, that's Ms. Murphy there on the end, Dr. Hu, Ms. Fulham, Mr. Herman, and Ms. Lucas Kamat. Commissioner Vigil, do you have questions of the department panel at this time? All right. Again, you can change your mind. Commissioner Brankard.
Thank you. Just a few. Yeah, I'll start with the reuse issues. So does the definition of reuse water include gray water?
Only in the effect that it doesn't conflict with the way the Water Quality Act excludes gray water under 250 gallons per day from residential uses.
But that exception is not in the definition of reuse water.
Correct. I think we, sorry, I should be doing this more formally. Thank you for your question, Commissioner, Chair, Hearing Officer. Yes, that definition is not included verbatim in the reuse water definition. It is, I want to say implied, would be probably the worst word I could think of to use. That's a good one to get out of the gate with.
Yeah. Okay, so I heard testimony that we have a number of discharge permits, 95 or so, that currently involve reuse water. And now we're talking about applications for the reuse water. Do the current discharge permits have applications in them?
Madam Hearing Officer, Mr. Chair, Commissioner Brankard. The existing discharge permits that we have do identify where they apply the treated wastewater. However, as we use the terms, they can be all over the place. So we have some that have applications like irrigation, but then we have some that just say surface reuse area. And so these definitions would allow us to incorporate actual terminology and with the restrictions based on where they would be discharging. So it's hit or miss right now, and we're needing to get that tied in.
Okay, so then a couple questions to follow on that. If the proposed rules just simply says reuse can't be direct or indirect potable applications, correct?
Could you rephrase that, or?
And you can't use you can't have an application of direct or indirect potable applications for reuse water. Is that what the proposed rule says?
Yeah, I believe what you're asking is if we can use wastewater for direct and indirect potable reuse applications.
Well, I'm not talking about I'm talking about the rule.
Right.
Okay, there's a prohibition against using it for potable applications in the proposed rule, reuse water.
There is a prohibition for produced water to be used in any application. However, as Mr. Herman spoke to, the indirect and direct potable applications are limited to just domestic wastewater, and they would be only for feasibility studies.
Commissioner Brankert, if I could possibly usurp your question with the subsection A of 201 is what you're referring to. That says the department shall not approve a discharge permit or a discharge permit modification that includes discharges of reuse water for direct or indirect potable applications, except for those authorized applications identified in subsection B of 201.
Right. So
that's the basis of your
that's
question.
what I'm talking about. That's it. Okay. So why not do the opposite also and say that every new discharge permit for reuse water must include the applications of the reuse water?
Commissioner Brankert, that's exactly what we would be doing. We would
Okay, but you're not putting it in the rule. You're not saying that.
We have not expanded on the domestic reuse portion because we do have guidelines that talk a little bit to those types of applications, but we don't have them defined anywhere. And so until we do propose a reuse, the language for the domestic portion of the reuse rule, we will continue to lean on the guidelines, but use the applications that are defined in the rule.
Okay, so does this will this mean that as we go forward, each of these 95 existing discharge permits, say as they come up for renewal, that you will modify them to define specifically which applications are used as defined in this new rule?
Correct.
Okay, so everybody who has one of these permits can expect it to be modified.
Commissioner Brankert, the permits come up for renewal every 5 years unless they modify the location or the type of discharge. So if they propose to modify, we would then start using these new definitions for the application specifically, rather than just coming up with something. And then those that are new would use these new definitions for applications specifically.
Okay.
So everybody's on the same line.
So now for all those 95 discharge permits that have reuse, do any of them currently allow direct or indirect potable application?
No.
Thank you for the question, Commissioner Brankert. The current situation is the city of Rio Rancho does have a discharge permit that has proven a connection to a potable source, but we do not identify that as an indirect potable reuse permit in the discharge permit itself. They are an underground injection control discharge that discharges directly to groundwater, and we treat it as such under the UIC and the existing 3103 standards. So the answer is yes, but no.
Yeah, so that was a whole area that I don't understand, that I sort of get into, but I know the department is getting more into discharge permits for storage, right?
Thank you for the question, Commissioner Brankert. Yes, the current permit process allows us to do, through the UIC regulations, aquifer storage and recovery permitting, Bear Canyon infiltration project with the Water Utility Authority. Plus, there's a couple of other ones. I know multiple communities right now are exploring the idea of that. But in those instances, they are not treated domestic wastewater. They're treated surface water, or in some cases, untreated surface water that is used for the aquifer storage and recovery.
Okay, so this is not a wastewater.
So with Rio Rancho, it is. The Albuquerque, Bernalillo County Water Utility Authority projects are not.
All right. Okay, so I'll try to move on here. Produced water. It seems that you have a program in place to approve these projects, these study projects, but now you want to put that program into the rules.
Yes, thank you for the question, Mr. Brankert, Chair, Madam Hearing Officer. I'm told at some point I can stop doing that, but I'll just keep going. The current process, we have utilized our leverage with the New Mexico Produced Water Research Consortium in order to encourage proponents to submit to us an NOI. I want to try to back up a little bit. You use the word approve, and in this context, we generally try to avoid the word approved in saying that we review the notice of intent to determine whether or not we'd have regulatory oversight or authority over that project, and then issue them a discharge permit required letter, could be a bad thing, or a no discharge permit required letter, which is the goal. Sure. Come on.
Okay, so there are currently approved demonstration projects. Are there any currently approved industrial projects?
There are, let me clarify, please, for produced water.
Produced water.
There are currently at least 2 projects that have proposed an industrial type process in their notices of intent that we have sent them no discharge permit required letters for. They have not operated or begun those projects.
I'm confused in section 401A and B, which those rules, A and B, plus the definitions that you're using, industrial project, demonstration project, the 2 types of demonstration projects, none of them seem to use the words produced water. So does sections 400A and B apply to all reuse projects?
No, because they're in the produced water reuse section of the regulations as an umbrella, anything that falls under those subsections would be produced water specific.
Well, it would help if you use the words produced water to limit what those sections are for, I guess, would be my suggestion. But to get back to your what you just said a minute ago about how you're not really approving these projects, which seems to go against your own language. 400A4 says that these projects would be authorized to operate by the department. Okay, and 400C1C says ED must make a determination that the projects meet the requirements of these sections. But it seems like you're trying to create this category of what you call it, a non-permit. It looks like a permit, but you're not calling it a permit because you don't want to call it a permit, right?
I wouldn't characterize it specifically in that manner. I would say that there's considerable numbers of projects that submit to us a notice of intent for any other type of project, like emptying a potable water tank in Santa Fe in order to clean it out, that they would provide us with a notice of intent, and we would respond to them that they do not require a discharge permit for that activity. And this would follow that same process, just specific to produced water.
But not really, right? Because those you're just sort of saying don't need a permit. Here you're saying you need to follow all these requirements for this type of project. How you deal with your produced water. We might even acquire financial assurance. All these things you have to follow for transport, storage, disposal. That's looking to me more like permit requirements. Now here's the problem you face, okay? When you look at the Produced Water Act, of course I can't find it, Section 70-13-4, it reads, for uses regulated by the Water Quality Commission pursuant to the Water Quality Act, a person shall obtain a permit from the Department of Environment before using the produced water, the recycled or treated water or treated product or any byproduct of the produced water. Produced Water Act seems to be saying you need to give them permits, but yet you're avoiding calling these permits.
Madam Hearing Officer, Mr. Chair, Commissioner Brankard, you point out a very good difference between the different acts. The Produced Water Act does say that you shall obtain a permit. That does not circumvent the Water Quality Act, which says that we must protect ground and surface water. What this rule does is it makes it very clear that it would be outside of NMED's authority if we have this information in the notice of intent of whether or not it falls within the department's authority, because it would be a discharge. If it's not a discharge, we do not have the authority to oversee it, but we need these critical elements, which are additional to the ones that we find under our current NOI process in 20.6.2 NMAC. Because this is a different kind of water source, it has different types of water contaminants associated with it, and therefore different risks and threats to ground and surface water. So although the Act says it shall provide a permit, that does not supersede the Act, the Water Quality Act, that says that we must protect groundwater. So the way to protect groundwater at this point without substantial evidence of what would be protective is to not give a permit, so long as we have the information up front of what they're planning to do with it, and that means not discharging. Hope that clarifies that some. Apparently not.
Because 400 talks about your approval of authorized uses. The Produced Water Act says if you're going to approve uses of produced water, it's a permit.
However, Commissioner Brankard, rules can also have authorizations or the prohibitions. This particular rule that we're proposing is for the prohibitions because there are no authorized uses. None that could be protective of groundwater as far as the evidence that we've been
No,
providing.
no authorized discharges. But the uses,
Thank you, Commissioner Brankard.
the uses for these projects are being authorized. And these are uses of produced water for these projects. Demonstration, industrial, they
Commissioner
just don't discharge, okay? Correct?
You make a fair point. I think that the department does have the authority to determine the use. It doesn't have a discharge and outside of our authority. I guess that's how we attempted to word that. And that may not be capturing it completely by using the term uses. I think prior it used to say applications. Produced water. It said something at some point in the iterations, and we took that out because it absolutely is not for discharges.
And my understanding of your question is that there's a dance between the Produced Water Act and the Water Quality Act and the regulations where the Produced Water Act says if you want to use produced water, period, outside of oil and gas, you have to have a permit in order to do so. Therefore, if a researcher wants to take a gallon of produced water outside of the oil and gas industry and utilize it in the laboratory, that would require a permit from the Environment Department. And then our dance is to figure out how to make the Water Quality Act which says that our authority lies within the protection and the control of the discharge of contaminants. And so we have a conflict between the legislation that was passed, the existing legislation that we have been operating underneath for the last 60 years, 50 years, and then the implementation mechanism of our regulations, where we don't have a mechanism in our regulations to permit anything along the lines of produced water or that can accommodate that type of a discharge or a release of a contaminant. And so we're stuck in a untenable position, having to argue that I agree that the Produced Water Act absolutely says that anyone that uses produced water outside of the oil and gas industry must have a permit. And the Water Quality Act says you don't have the authority to require the permit until someone is releasing a contaminant that would be a threat to ground and surface water.
Well, but it's two different permits, right? I mean, if the Water Quality Act is authorizing one type of permit for discharges, and the Produced Water Act is authorizing a different type of permit here.
I respectfully do not agree with that analysis that they are one permit and that the Water Quality Act controls and the Produced Water Act modified the Water Quality Act to just as the dairy rule and the copper rule fell underneath the same Water Quality Act.
Well, but those were the same. Those are part of the Water Quality Act. This is a separate statute.
The Produced Water Act modified the Water Quality Act.
Commissioner Brankard, my understanding of the Produced Water Act, and I don't have it up, I can bring it up if you need to. It says that the Water Quality Control Commission under the Water Quality Act will permit. However, there is the amendment in the 2019 Water Quality Act, which states that the commission will adopt regulations for discharges of produced water. And that is where we're here today, but it's not protective of ground or surface water to the ability that we've been able to research and understand produced water in the state of New Mexico, treated or untreated. So essentially, we come before the commission today to adopt and promulgate those regulations pursuant to the Water Quality Act. That has to happen first before we can issue permits under the Produced Water Act that says we shall permit. We don't have we're coming to you today to tell you that the only thing that we could do is non-discharges would be protective of ground and surface water.
Well, I guess I disagree, because the language that was put into the Water Quality Act says not just adopt regulations for discharge. It says adopt regulations for discharge, handling, transport, storage, recycling, or treatment for the disposal of treated produced.
As it pertains to ground and surface water protection under the intent and objective of the act.
Right, but isn't that what you're doing with your approvals for these uses?
We are determining that it would be no discharge permit required.
I guess I'm wondering whether this is entirely a dance to avoid the other requirements in the Water Quality Act that pertain to permits. In other words, public notice, opportunity for hearing, appeals, etc.
Commissioner Brankert, thank you for your input. I think it's valuable. I think it's important. I do not believe that it would be appropriate for this department to issue a discharge permit should somebody apply for the discharge of treated produced water in a way that would be protective of ground and surface water. And that's ultimately the first line of defense for protection, is not writing a permit that would cause contamination. And that's why the notice of intent in 20.6.2 does exist. However, for these, they're non-discharging. Currently, a produced water demonstration project, if they self-determine that they did not want to submit a notice of intent, the way 26.2 reads is that they won't have to submit a notice of intent. This rule kind of closes that and requires all produced water demonstration projects submit a notice of intent for the department to determine that it's not discharging and therefore not a threat to ground or surface water. And so that's the other aspect of this role that we find critical specifically for produced water.
Okay, well, I guess my position is I think that the Produced Water Act gives both this commission and the Environment Department broader authority than exists in the Water Quality Act. Okay, and that you're not limited by the 60-year-old ideas in the Water Quality Act. That you're given broader authority and responsibility to deal with this, which you're trying to take on. But the question is how take that on.
Thank you.
I'm a little also disturbed when these definitions here, some of them seem to me really vague and broad. If the demonstration project means a bench scale or pilot project, a bench scale project means a project or study conducted in a laboratory. Would that be any study of we've had a whole bunch of discussions about studies of constituents that are in produced water, where people are studying the laboratories. Will those have to go through this whole notice of intent project? Anybody wanting to look at these constituents?
I believe so.
Okay, so all these folks at NMSU and everyone else, they're now going to have to come in through all these, to do all these approvals for a non-permit from the Environment Department.
I'm sorry, for the bench scale and the laboratory projects, no. The demonstration projects and industrial projects, yes.
Demonstration project means a bench scale project.
Sorry, yes. Yes.
All right, I just have quickly try to finish up here with something that's I find sort of troublesome here, which is totally unrelated to these two topics, and that was brought up early on in the testimony of the Environment Department, which is that the Environment Department discovered during this process that the notice that was to be put on the Commission's website did not occur until 48 days prior to this hearing. Am I correctly quoting the testimony?
Madam Hearing Officer, Mr. Chair, Commissioner Brinkert, you are correct.
And is that just not a basic violation of the Commission's procedural rules about notice in this hearing?
I consider that a legal question and beyond the scope of actual testimony.
Sure.
Mr. Brankard, my interpretation of the notice requirements require the notice to be on the department's website. It did appear on the department's website, not specifically on the WQCC page, is my understanding, but it did appear in several other places on the department's website. I think we've responded in some of the motion practice. We've responded to that argument.
Okay, well, the regulation is the definition to provide to public, which comes out of State Rules Act, which is modified in the Commission's procedural rules, says provided the public means, number one, posting it on the Commission's website. Say departments, Commission. So we may decide this is all pretty de minimis, whatever, but anyway, it seemed to be a pretty serious issue. The other one is it also says that the notice has to require a internet link to full access of the text of the rule. And I'm sitting here clicking on the department's, the commission's website. I'm opening up the notice and it says you can obtain a copy of the proposed regulations to be reviewed online at, and there's a link. There we go. Sorry, this page cannot be found.
Commissioner Brinker, I would like to point out that the department provided notice to the extent that the department has ability. We do not have authority for the WQCC's website. We do provide all our information to the Commission and the Office of Public Facilitation. However, to the extent in which the department has the ability to do noticing for all of these hearings, we do undertake that and provide notice. I actually am not in, I can't change, OPF.
And I will just add on to that, there is a known issue at this point in migrating our IT systems. I don't know the technical terms for it, but our resource space, which is where we upload all of our documents, has failed recently within the last 20 days. And we have received daily updates of further and further unhappiness from our IT department that they have not been able to fix it.
And I only discovered this last night, so it could have been fine for everything up to last night. I don't know. Just pointing this out.
I would guess it was within the last 20 days that in the last 7 days it became really bad, where files were being corrupted without us even knowing that a problem had occurred.
And I will like to add, I have worked with the Office of Public Facilitation. They have been exceptional in putting things back up when the entire website crashed. And it just said critical error instead of website. So there has been responsiveness when we've been made aware. But again, the department, as far as the Groundwater Quality Bureau and Surface Water Quality Bureau, do not have authority on the Office of Public Facilitation's website.
Thank you. I'm going to stop there.
Commissioner Patton, do you have questions at this time?
Not at this time, no.
Right, thank you. Chair Thompson, do you have questions at this time?
Let me turn it on. So I'd like to start by following up Commissioner Brankert's question about testing, pilot testing, and bench scale testing. So it seems to me pretty clear based on Mr. Herman's answer that if I took a gallon of produce water into my lab and did some testing on it, I would require a permit.
Thank you for the question, Chair. Not a permit, but submission of a notice of intent to us. And to which we would respond whether or not a discharge permit would be required for that activity. If it's in a laboratory, most of the time, it'd be a very easy no discharge permit required letter to write.
And how would I dispose, what would be the legal way of disposing of any residue or treated water or any products from the treatment process?
It would need to be, thank you for the question, Chair. The materials would need to be returned to the appropriate disposal location that they came from or had been intended for originally. We've had multiple projects that have occurred at Bergendorf at the Brackish Water Research Desal facility that have treated the produced water, combined it back together again, and then returned it to whence it came.
Okay, that was gonna follow up. The next scale up would be a field scale.
Mhm.
And I'm aware of field scale testing that has been done at the Brackish Groundwater National Desalination Research Facility,
Mhm.
BGNDRF, I think, Bergendorf. And in years past, they've simply disposed of the residue in their lined impoundments.
Thank you for the question, and I was prepared for this one, luckily. We have received notices of intent for those projects that were in 2015 and 2008 that occurred, and we did respond to them with no discharge permit required and allowed them to dispose of that water into their impoundments knowingly at that time. I wasn't employed at the department when that decision was made, and so they were fairly small quantity projects, and was determined that it happened long ago enough that we would not be able to detect any aspects of that activity at the facility today.
But if they did it today, the test I'm familiar with, they brought a couple 10,000 gallon tankers over and then tested it with the treatment technology. If they did it today, they would require an NOI. Would they also require a permit?
They would, this is a different situation. The facility has a discharge permit with us already because of their line impoundments as well as other aspects of their activities there. And therefore, at a permitted facility, unless it was fully contained, in and out, pack in, pack out, I think is the term for camping, but they would be combining back and returning it back to the oil and gas field. We would not modify the existing discharge permit for the brackish water research desalination facility in order to accommodate a produced water project.
Just sort of an editorial comment. I think that that facility is a good resource, and this is a perfect potential application to test the technologies. So anything that would, I understand and appreciate the need to provide security that we don't contaminate surface or groundwater, but if it impedes the safe testing at a very well-run facility, that would be a problem.
Commissioner Thompson?
Yes, ma'am.
I just want to reiterate there, and I've heard it from the public and I'm kind of hearing it from commission. The notice of intent process is not to inhibit, it's to be aware of the projects that are going on and that the individual who's doing those demonstration projects has a plan of where they plan to put that and that it would not be a discharge. So doing a project at Bergendorf is something that we like seeing. We've had a couple of projects there, but the idea that they would assume that they could discharge to those lined impoundments without having to manage that waste source, that's what the NOI process, particularly in this rule, outlines, because it is nuanced with different constituents than we would see in domestic wastewater. We just want to make sure that we know what's going on out in the world of produced water research, that it is not going to be a threat based on the department's determination, not the individual's determination, and that they have a plan for discharging of that wastewater in an appropriate manner that won't impact ground or surface water.
Thank you. And so if someone was going to do a pilot test at Bigendorf or at New Mexico State, they'd file an NOI. I'm trying to review the regs. I don't see that you would have to approve it. It's just simply a notice. Is that true?
It's a notice that we would respond to with either discharge permit required or no discharge permit required.
Okay. Okay. Let me change gears one last line of questioning. So, Dr. Hu, you worked with Dr. Zhu and she has done some terrific work. One was the analytical methods, and you report that there's something approaching 1,200 compounds that have been identified in produce water.
Madam Hearing Officer, Mr. Chair Thompson, Commissioner, that paper is not from Dr. Pei's group. It's from it's a literature review paper from the researcher from the Environmental Defense Fund. So it's not a research paper; it's a review paper.
I see. Yeah. I see. Well, okay. Thank you. I know that Pei has done a lot of work on characterization, and it's good work, very good work. My question is, I will accept that there are about 1,200 compounds in it. How many compounds would there be in municipal wastewater? In, let's say, in Albuquerque, a big municipality with industrial discharges, with hospital discharges, with domestic water, with illicit discharges of who knows what. how many compounds would you estimate might be in that type of wastewater?
Can we rephrase the question outside of the Albuquerque area?
No, I want to constrain it to a large municipality.
Las Cruces or Santa Fe?
Sure, large municipality. Yeah, I'm not asking for a specific number. I'm asking, I'll be frank, I'm asking for a comparison to the compound, to the number of compounds that we know about in produce water, to the number of compounds we know about in a large municipal wastewater, and then if it's possible to speculate on what might be the number of compounds we don't know about in municipal wastewater.
I don't have any numbers to quantify that. I know that for the discharges in a large municipality, you're looking at hundreds. And the NPDES permitting requires a full pollutant scan, which is everything that's in 20.6.4 and 900, plus anything that EPA may require because of pretreatment regulations, which are like effluent limit guidelines. I would say that for produced water, that goes back to lay. Like I say, there's a large number of unknowns. And as I talked about in my testimony, that's actually why you see a lot of wet testing, but also, as I said in my testimony, wet testing is not in lieu of, it's part of the entire permitting scheme.
It's a pretty crude test. I would agree with you.
And I would just add that our understanding of municipal wastewater and sewer sheds and the inputs into them is far greater and far more comprehensive than with produced water. I think that the actual answer to your question may be that produced water has less numbers of constituents. It's more of, do we have the methodologies to test for the constituents that we know we need to be concerned about? Do we know the toxicity data on the constituents that we know we need to be worried about? How about the ones that we don't know if we need to be worried about? And it's those levels of uncertainty that give the regulators nightmares at the end of the day.
Commissioner Thompson, I would just add, based on some of my background with toxicology, I'm not a toxicologist, but my background and research in it, dose makes the poison. So the number of constituents is not as concerning as the toxicity of those constituents and the unknown constituents. And so as Dr. Hu presented in his testimony, even in small quantities in produced water, that could mean a big difference in whether we would contaminate ground or surface waters. Just essentially that the dose makes the poison and the number of constituents is not as pertinent as the concentration of those constituents, and the ones that we know and don't know in produced water are of higher concern when it comes to protecting ground and surface waters.
And I would add for a large, Madam Hearing Officer, Chair Thompson and Commissioners, I would add that in a municipality, like a large municipality like Las Cruces, they have a pre-treatment program, which is essentially they're running their own mini MPDS, and they do sewer shed surveys, and they have, it's all based on categorical and significant industrial users where we know the chemicals they're using. We don't have this proprietary question of, well, we're not going to tell you what we're using, but, and so, you know what a hospital is discharging. It's predominantly disinfectants and laundry. Like, you know that hotels are what they're discharging. You know what scrap yards are discharging. You know what metal finishers are discharging, because you can go in and do a survey of their chemicals and look at all their processes. And so you know what they're putting into the system. Whereas in produced water, it could be from multiple sources, multiple formations. We don't know what all of the chemicals put in, or we don't know what the chemicals were coming out. So there's a lot more unknowns in produced water.
Challenge that. You know, a hospital doesn't just wash their clothes and things like that. They also treat patients with huge number of different pharmaceutical compounds. And those patients go to the bathroom in the hospital.
Commissioner Thompson, you do make a very good point. I will point out that under a permit, they sample quite a bit more often than we have for any of our produced water studies. So we have more data also on any of the permitted facilities.
Yeah.
Chair Thompson, is this a good place to break into your cross-exam?
This is a great place. I'm done. Thank you very much.
Okay. I imagine other commissioners have questions as well. My dilemma here is that we need to be out of the room in approximately 30 minutes. And I have approximately 10 people who would like to offer 3-minute public comments. So I'd like to, we can certainly stand up while the department is vacating the witness table, but we don't have time to take a proper break. Okay, Mr. Atencio, do you want to go to the witness table, please? Okay, you okay? All right. So we are going to begin public comment just a little bit early. No one will be prejudiced by this. We have plenty of commenters here, and we'll go until about 5:20. So, Mr. Atencio, if you would, do you swear or affirm to tell the truth?
Yes.
All right, and would you spell your name for the transcript?
MARIOATENCIO. MARIOATENCIO.
All right, and for everyone here, 3-minute maximum. If you have more to say than that, please put it in writing sometime before the end of the week. You can certainly submit comments in Spanish if you'd like. In writing, they will be translated for the commission's benefit. And I will only call on you once. So I'm going to start your 3 minutes, Mr. Atencio.
Thank you. Madam Hearing Officer, honorable members of the commission, I come before you as an individual Indian allotment stakeholder in my mother and father's lands in Northwest New Mexico. Very concerned about this ruling, hearing that science is not, there's no science behind some of the what is being presented, especially pilot projects. I'll be presenting written testimony. I'm also a party to the case. Let's come here, be very brief. In March of 2022, the Ojo Encino chapter of Navajo Nation government passed the resolution opposing the utilization of produced water for agricultural purposes within the Ojo Encino chapter boundaries. That's resolution OGOE 310-2022-02002. In there, in the findings, the Canales produced project that's part of the ruling, part of the rule today, is contra to that resolution. And looking through the attachments of that Canales pilot project, those lands are within the exterior boundaries of the Ojo Encino chapter, which is considered Eastern Naval Agency. I think, and if you look at the record, Naval Nation EPA supports the proposed rule, but I think they were not aware of this resolution of local tribal communities. My father and mother's land are both in the water, or in watersheds, especially my mother's land, which is downstream of where this pilot project is, within the main stem of the Torreon Wash, which is in the Arroyo Chico watershed. Looking at the documents, there are volatile organic compounds, organics in the quote unquote produced water. We've been deeply involved and incredibly concerned about what is happening out here. And so the framing of this rule, you're starting, commissioners, you are going to be impeding upon international indigenous human rights by taking action contra the indigenous peoples. We were not informed of what was going on as individual Indian allotment holders, because the underlying water, the value, when we have allotments that are directly main stem on ephemeral streams, that's deeply impactful. Not only that, but then in the region, water resources are the most important traditional cultural places as identified through federal policy making in the greater Chaco landscape. Springs, Eagle Springs is one of the most important, powerful, sacred water places in the Navajo Nation. I use that spring water to get married. Deeply central, core to just not me personally, but the peoples in the region. Commissioners, your actions today are starting to be viewed as textbook examples of institutional environmental racism. We were not notified of any of these pilot projects at the local level, and it's contra in Canalis's HPOC's documents that's in front of you. They don't cite the chapters have opposed these type of this project. So commissioners, there's deep. I'll provide more comprehensive issues raising, but here, commissioners, you do have to take a hard, long look at what's actually being presented in front of you. You are impeding upon cultural resources, and you don't even know it. No one is talking upon that level. You need to have free, prior informed consent of individual Indian allotment holders. We have to have a deep conversation about what's happening, and you need to really put the brakes on what you're trying to look at here. As much as it said, I heard it, science is not there. They're going to try to use indigenous Aboriginal land territory as a guinea pig, as test bench, and put the people as guinea pigs, just so they can prove this technology, which is something we are adamant against, and I find incredibly insulting. Commissioners, Chair, Hearing Officer, thank you.
Thank you very much, Mr. Atencio. Mr. Atencio got a few extra minutes because he entered an appearance. Let me go to Michael Swearingen. I believe he's on the platform, and he was here at the noon comment. Mr. Swearingen? Okay, I'll take him when he returns on the platform. Sky Johnson. Is Sky Johnson with us? No? Okay. Marty Carolyn. And by the way, if I am mispronouncing your name, please correct me. I want to do it correctly. Do you swear or affirm to tell the truth?
I do.
Thank you. And if you would spell both your names for the record.
Name is Marty Carvlin, Marty. Carvlin, Carvlin.
I'll start your 3 minutes now.
Good afternoon. I am a resident in Santa Fe since late teenhood. I'm a mom, I'm a grandma, and I'm a public school teacher. I'm not representing the district, but I'm speaking on behalf of the futures of all the people that I work with every day. I'm very concerned about this potential sort of euphemistic naming of water and its potential uses. It's scary for me, and for I'm really concerned for the future of the youngsters that I see every day. The majority of them being immigrant students. We tell our students, and I tell my kids, my grandkids, take care of yourselves, don't do drugs, don't abuse other people, yet the elders around them aren't always doing the best. And we really need the best for our students, for our kids, to have something to look forward to. I, as a person, have worked in a career as a teacher for a long time. It kind of built up to the point where I doing the best I can. I bought an electric vehicle. I've had solar panels for 10 years. Back in the day, I signed up for PNM's Blue Skies program, kind of idealistic. And I hope you will do that too and not settle for something halfway there and move forward with this ruling or definition of produced water the way it is now. I thank you very much for your time.
Thank you very much. Let's see, Ian Colburn. Is Ian Colburn perhaps on the platform?
I'm on Zoom. Can you hear me okay? Or
Oh, now I can hear you. Yes. Do you swear or affirm to tell the truth?
I do.
Thank you. And if you would spell your names for the transcript.
Certainly. Ian Colburn, IANCOLBURN.
All right, I'll start your 3 minutes now.
Thank you, Madam Commissioner. I am a organic vegetable farmer in Albuquerque, small business owner, and Burque born and raised. Although the oil fields are far away, at least it feels that way from Albuquerque. As I've been farming and working in the valley for the last decade or so, come to understand just how connected our waters are in the state. Seeing how far the water that flows through town comes from, and how the groundwater that we use to grow our organic vegetables is connected to the water that runs through the river. And so that said, that clean water is extremely important to me and my customers and our community here in Albuquerque, who count on us for healthy food for them and their families. And so I'm coming at this assuming that the produce water is not clean, and that moving this produce water off the oil field is not a wise decision and will be detrimental to the health of people in rural areas, obviously, but also here in Albuquerque. And what leads me to that conclusion is that there are no scientifically proven standards for effective treatment. There's no credible scientific data proving the safety or feasibility of treatment, especially at the scale that is being proposed in the rule. And of course, that conclusion is led to because these the chemicals in the reused water are proprietary. And how do we even know what to test for if we don't know what they're using and putting in the water? There are no minimal standards in the rule for the treatment and handling and disposal of the waste. Furthermore, the rule authorizes reuse in industrial projects and demonstration products for the oil field. So essentially, testing these projects before knowing that they're safe or that they are functional on people where there can be harmful impacts, which is just like, come on, we let corporations do this. We let Elon Musk get away with it, and we shouldn't. But the state, we should hold ourselves to higher standards, all right, and protect the people. It's the point of the state. So I really implore the commission to listen to the indigenous voices and the science and the people who have studied this, This is a rule that could benefit a corporate, an industry that is wildly profitable. The oil and gas industry has biggest profits than they've ever had. These are not companies that are hurting. We have to bend the rules for them. Let's keep the standards tight. Let's not give them an inch until we know this technology can work. And it's not even anywhere close to that. And our livelihoods and our family's health, my livelihood, and the families all over the city, state.
That's your time, Mr. Colburn.
Oh my gosh, thank you so much for holding for that. And yeah, thank you.
Thank you. Claire Sims. Claire Sims?
Hi, can you hear me?
Yes, thank you. Do you swear or affirm to tell the truth?
I do.
Would you spell your name for the transcript?
Yes. Clara, Clara, Sims, Sims.
Thank you. I'll start your 3 minutes.
Thank you so much for the opportunity to make public comment on the proposed produced water rule. My name is Reverend Clara Sims, and I serve as the Assistant Executive Director of New Mexico and El Paso Interfaith Power and Light, as well as the Associate Minister of First Congregational Church in Albuquerque. As a lifelong resident of New Mexico, I know in my bones, like everyone here, that there is nothing more precious or precarious than water in our beloved state. Drought has lived in my vocabulary for as long as I can remember speaking, and even though the best efforts of the regional water management plans underway, the reality is drought is the inheritance we have set in motion for our children and our children's children. And though this future will undoubtedly be challenging, it need not be bleak or without hope. But that hope must lie in the choices we make today, not to sell out to special interests, but to truly consider the common good of our communities, many of whom are already in deep water crisis and cannot afford the threat of ground or surface water contamination. And that is why today, as a faith leader, I ask you to support a clear, straightforward prohibition against the discharge of untreated and treated produced water to ground and surface water. I ask that any industry proposals now and in the future that seek to weaken the proposed prohibition be rejected. And though this rule needs to be stronger than it is, I believe it is a first step toward regulations where none have existed. And even so, we know that our rules are only as strong as their implementation. And I ask that if any authorization is indeed granted to industrial projects, that NMED takes swift actions of enforcement against any of those violations. In New Mexico, the declaration that we have been a sacrifice zone for industry is growing weary on our lips. We believe that what is precious should not be sacrificed for profit. We must make clear, strong, and stringent rules against anything which threatens the vitality, health, and longevity of the waters by which we live. Thank you for your time and for your leadership.
Thank you very much. Raquel Zamora. Raquel Zamora?
Hi, present.
Hello. Do you swear or affirm to tell the truth?
Yes.
Would you spell your name for the transcript, please?
Yes. First name is R-A-Q-U-E-L. Last name is Z-A-M-O-R-A.
Thank you. I'll start your 3 minutes.
Thank you. Anam Netebote, greetings. My name is Raquel Zamora. I'm an enrolled member of the Texas Band of Yaqui Indians. I'm here to respectfully address why I am defending New Mexico's water. As you know, Indigenous people have inhabited these lands since time immemorial, serving as the original stewards of Turtle Island, living in harmony with nature. However, as you may know, it was disrupted with the arrival of Europeans in 1492, since our struggle as Native people continues to this day in 2024. This story seems like a broken record to many, but as Indigenous people, it's distressing, overwhelming, and heartbreaking because since the arrival of Easterners, we have endured genocide, slavery, rape, murder, and exploitation to Mother Earth. Why am I bringing this up? Because we continue to struggle to live accordingly to our way of life, which is rooted in balance and harmony with nature. I'm here today due to the imposition of fracking water waste reuse. If Texas the state where I reside acted to suspend permits for injection wells, that tells me Texans were concerned about earthquakes. So sooner or later, I imagine New Mexicans will share the same issues. I want to remind you that when all Europeans arrived, some tribes extended a helping hand, teaching settlers how to survive off the land when they were starving and dying. We have contributed to the survival of your nation, and nowadays we're questioning your methods because they don't truly benefit the community. So let me get to my point. I'm here to urgently ask you you all to not support the governor's plan to use public funds to reuse produced water, aka strategic water supply plan. Support the plans that are safe for the community and land. The governor's plan will eventually affect everyone if it goes into motion. Alternative options have been presented. 2022 New Mexico Water Task Force offered 50 recommendations to better protect and conserve our water, and the state has not implemented or fully funded any of them. Allow me to kindly remind you this is native land and my concerns are not for selfish reasons. Have you read the effects this can cause on the community, especially if the water gets contaminated? The water is not something to risk. Water is life, and the evidence I saw demonstrates how dangerous the governor's plan is for the community. I urge you to consider alternative methods that don't involve poisoning the community. Chukoitesia, thank you.
Thank you very much. Has Michael Swearingen joined us? No? Or Sky Johnson?
Hello, everyone.
Oh, Ms. Johnson?
Yes.
Do you swear or affirm to tell the truth?
Yes, I do.
Would you please spell your name for the transcript?
SKYEJOHNSON.
All right, I'll start your 3 minutes.
Awesome. Thank you. Hello, Chair, members of the Commission, Hearing Officer. My name is Sky Johnson. I'm a leader of Rise Youth Collective and the Colegio Sin Fronteras, a capstone project by EarthCare. EarthCare is a community-based organization on the south side of Santa Fe, representing hundreds of youth and families. We're concerned about this rule because although it includes a discharge of untreated or treated produced water, it also includes provisions that allow for a widespread experimentation and application of produced water and reuse off of the oil field in demonstration and industrial projects throughout the state. Our communities are disproportionately impacted by environmental sacrifice, with pollution concentrated in our most low-income neighborhoods and neighborhoods of color. We know that the waste from these projects will be radioactive and toxic, and will be dumped in, it'll be disposed in dumps across the state. One of the issues we're tracking closely is the PFAS chemicals that are causing harm by getting into our water. I'm sure you're familiar with the contamination going on in the La Cienega area. Our members that are in the area are having to buy bottled water because it's unsafe for them to use groundwater. They can't eat eggs from their chickens who've been drinking the water because they're contaminated, or eat meat from their livestock because their water has been contaminated with these PFAS chemicals, which are also known as forever chemicals. They persist in the environment, accumulating in soil, in livestock, and even humans over time. Community members, along with pets, livestock, and produce, have all been affected by PFAS contamination. And our organization was part of a publication of a study by physicians on social responsibility that documented the prevalence of PFAS chemicals in oil and gas operations across the state. Given the environmental department's acknowledgement that produced water is dangerous and to human and environmental health and can contain chemicals like PFAS, why would the commission allow its widespread use without scientifically based standards for treatment? We need the commission to act on the evidence before you, which finds there is no treatment for that is capable of addressing the radiation of diverse contaminants in this water, including PFAS. We agree that a prohibition should be placed on the discharge of produced water on the ground and surface water, but the prohibition must be extended to all reuse off of oil field. So we're calling the commission to reject this rule and instead adopt a rule that protects all our communities from PFAS and harmful chemicals by including a ban on all of the produced water off of oil field. Thank
That's
you.
your time. Do you want to finish your sentence?
That was the end. Thank you for your time.
Thank you. Maria Olivas? Is Maria Olivas on the platform? Blanca Diaz?
Aquí María Oliva.
Oh, you were Maria Olivas? Okay, good. Do you swear or affirm to tell the truth? Can you hear me?
Yes, 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 voy.
Okay. Would you spell your name for the transcript, please?
Hola, buenas tardes, presidentes y comisionados.
No,
Mi
wait,
nombre es
Miss Olivas. We can't accept spoken Spanish statements. We'd like you to put it in writing so it can be translated because we don't have an interpreter. Can you put your comment in writing, please, in an email to Pam?
only Spanish.
Yeah, okay, that's fine. If you would put it in an email, you can put it in Spanish in an email to Pam Jones. Thank you very much.
Okay.
Blanca Diaz? Okay. Marbelli Colindres. Colindres. No? Okay. We have someone in the room. Ashley Kegley?
Spell my name.
Do you swear or affirm to tell the truth?
Yes.
Thank you. And if you would spell your name for the transcript.
Yeah, it's Ashley. Oh my gosh. Sorry. Excuse me. Ashley Kegley, Ashley. Last name Kegley, Kegley.
Thank you. I'll start your 3 minutes.
Chairman Thompson, members of the commission, and good afternoon. I come before you today not only as the government affairs officer at Infinity Water Solutions, but also as a concerned citizen, someone deeply invested in the future of water across our country. And I urge you to reconsider the current direction in which these regulations are headed, specifically as they relate to produced water. As an industry professional, I am acutely aware of the challenges we face when it comes to water scarcity. New Mexico's water resources are precious and finite, and it is imperative that we manage them responsibly for the benefit of both current and future generations. At Infinity, we are actively engaged in a number of studies. One in particular is within the agricultural sector. It presents a novel approach to using treated produced water on non-consumptive crops. And it is just one example of how research, data, and science can help drive today's conversation around reuse. By embracing a spirit of experimentation and learning, we are gaining valuable insights that we hope will not only inform our own practices, but also broader policy discussions like the ones we're having now. Swift action today, intentional or not, risks stifling innovation, and we believe will inadvertently disincentivize companies like ours, companies that are funding on their own dime pilot projects and research efforts that will benefit everyone, including NMED. Moreover, we are deeply concerned about the potential economic impacts of these regulations, particularly as it relates to the state's primary source of revenue. We are reaching a critical mass. Produced water volumes are at an all-time high. Injection of this water is not sustainable, but nor is the shuttering of an industry that makes up more than 50% of the state's annual budget. Revenue that supports education, healthcare, and public safety, We are at a pivotal moment. We have a unique opportunity to transform this water scarce state into one that is characterized by abundance and sustainability. But it will require cooperation from a variety of stakeholders, government agencies, industry, environmental organizations, and citizens alike. I implore you not to shut the doors on collaboration, but rather to embrace it wholeheartedly. Fear should not dictate our choices. It should steer our scientific endeavors. Understanding will emerge from exploring, not disregarding the unknown. Instead, let us work together to find solutions that protect our water resources, that support economic development, and pave the way for a brighter future.
Please wrap up.
Let us prioritize research and data collection over emotion. Thank you for your time and consideration, and I look forward to working with you all more.
Thank you, Ms. Kegley. Let me check one more time if Mr. Swearingen has come back on the platform. No, he's waiting patiently earlier today. If he's not there, let me just say to everyone, I've come to the end of the names of the folks who reached out to specifically sign up for this public comment period. We will have 8 more public comment periods at 1 p.m. and 5 p.m. every day. And the reason I can't take any more today is we are supposed to have vacated this room by 5:30. And it's going to take us a little bit to pack our stuff up and depart. So see you tomorrow morning at 9.